Yes, Malad.
With notice to I'm mentioning for inclusion.
What is this?
With notice to other side, I mentioned
Application or hearing or what?
application.
Yes.
This is a matter was listed on 5th August due to change
What
of
is this? What is
matrimonial appeal here.
Hearing? Yes, hand over.
Or may I have your lordship's leave to file this appeal without the certified copy? Intra-court appeal, server copy is there, my lord.
Section 82 of the ESI Act, hearing to 2013 is pending, my lord.
What is the matter?
But against an order under section 45A of the Act by the ESI Corporation.
Please hand over.
My lord, this is for correction, my lord.
With due, my lord, with due notice, I was mentioned.
Your lordship, may I?
Ma'am, wait. Yes.
We mentioned
Order 41, you don't have determination. It's code number 16 now. Changed. Yes.
Your lordship, may I permit it to mentioning for restoration?
Of whose order? This bench?
This bench.
Yes. Call of the list.
I am for the appellant, my lord.
What is the
The
correction?
correction, my lord, we are told by the department, the second page, my lord, in third line, instead of 7th bench, it should be
Oh,
6th bench.
Right, right.
And
Yes, yes.
my lord,
That,
there are two submissions, my lord. First
Yes.
is that, my lord, this was, my lord, SL before the Honorable Supreme Court by the respondent, my lord, on 3 occasions at admission stage heard and SLP dismissed. So it has been affirmed. And the second submission is, my lord, it's a mistake on our part, we should have, my lord, pointed out at the time of hearing. Prayer A has been allowed by your lordship eviction. Prayers B and C, my lord, are, my lord, consequential mean profit decree. So we have not pressed that, so we are taking out a short review application, my lord.
do that.
We are doing that.
Do that. But in the meantime, let us correct
My-
this first.
Before the decree is drawn up, it is affirmed up to Supreme Court.
Anyway, so এটা এটা শুধু এই পাতাটা দিয়েছে কেন? এটা পুরোটা বার করে দিন। লাস্ট দুটো পাতা এখানে রয়েছে, তলা থেকে পুরোটা বার করে দিন। এরকম ভাবে দেবেন না কখনো। পুরোটা বার করে দেবেন। হ্যাঁ, ঠিক একদম ঠিক দিয়েছেন। এরকম দেবেন। In the judgment dated July 1, 2025, in the ordering portion in paragraph 82, we had erroneously mentioned the single judge, the learned judge, seventh. We had erroneously mentioned the learned judge, 6th bench, City Civil Court at Calcutta, as within double inverted single judge, 7th bench, City Civil Court at Calcutta, double inverted close, full stop. Let the said error be deemed to stand corrected, and the above erroneous expression be read as within double inverted judge, 6th bench, City Civil Court at Calcutta, double inverted close, full stop. Let this portion, let this correction be deemed to stand incorporated in the judgment and decree dated July 1, 2025.
decree তো ওটাই যাবে সেজন্য। Lord, page 2, my lord,
Yes.
first para 1, third line, it is also 7th bench, so it
Yes.
should also, wherever it is taken as 7th bench.
There also.
Yes, my lord.
last page.
আচ্ছা,
Third line.
আর হ্যাঁ, আরেকটা লাইন অ্যাড করি।
না, একটু তো দর্শক
In-
বলে দিয়েছেন।
The expression double inverted judge, 7th bench, double inverted close, wherever it is appearing in the said judgment, be read as judge, 6th bench, double inverted close.
Develop.
Even if you miss out some other part, it will apply universally. And your review application independently will be.
We shall file. Immediately file.
Oh, my lord, I am appearing for the appellant. My lord, this mediation was already directed by the earlier division bench. My lord, it failed. Thereafter, my lord, the matter was heard, order was passed. Lastly, your lordship passed an order to continue with the maintenance. They have not paid, my lord. I have taken out an application, can 4. Let it be listed, my lord, so that it can be heard. On my other side is present, my lord.
My lord,
Because I have paid for attached.
Mr. Rai, these have been identified for mediation, even on the question of maintenance.
No, mediation, already there was a direction. Possibly, my lord, it has missed, my lord, the department has
Oh.
missed it.
Mediation failed.
Yes, there was a direction by the
There is-
division bench. Yes, yes. We went to the mediation failed. Thereafter, the honorable division bench heard the matter. Everything is over.
You also agree with that?
yes.
It is on record.
Learned
That is
counsel.
At present now, he is admitted to hospital, ICCU. I want some.
So the alimony
By
application was
opposition.
finally decided.
Yes, yes, that was decided.
So if he does
And
not
well,
pay, you can file an application.
I have taken out an application.
Fine.
I
have
to
filed
file
it.
the
It is-
opposition
It is
with
appearing
regard-
also.
It is possibly not appearing, my lord. I was,
Mention that application any day will take up. We are taking up.
my lord can direct it for.
No, it is not appearing in today's list. We
No,
can
you're,
cross-
since my lord,
The application is not appearing in today's list. We
it is
cannot.
not, no, I'm not praying for hearing the application. My lord, let it appear as per your lordship's convenience, my lord, so that, because it is already filed,
Learned
but I have served
counsel-
copy.
Take instruction in this regard. I
Learned
am-
counsel for the parties submit that the matter was previously referred to mediation. Full stop. However, comma, the exercise of mediation has failed. Full stop. Accordingly, the parties want to proceed with the hearing of the main matter.
Lord,
Full stop. In view of such express unwillingness of the parties to repeat the exercise of mediation, comma, uh, it is not possible for the it would not be appropriate for the court to force the parties to futile exercise of further mediation. Full stop. Accordingly, let the matter go out of the list with liberty to the parties to mention
my lord,
any pending application for inclusion in the list.
my lord, the can 4, my lord, has already been
This is
filed.
can 4 is that application.
Yes, can 4.
So then it is appearing in the list.
Yes, yes, but that is what, my lord.
Can 4 is the
Can
one.
4 is the
Can 4 is not the alimony application. It is your new application.
new application.
আচ্ছা তাহলে লাস্ট লাইন যেটা বললাম উইথ লিবার্টি যেটা ওটা কেটে দাও লেট দ্য ম্যাটার গো আউট অফ দ্য লিস্ট না করে ওইখান থেকে কেটে দাও তার বদলে করো ক্যান 4 of 2025 be listed under the appropriate heading tomorrow.
Grateful, my lord. Deeply obliged.
ক্যান 4টা কালকে লিস্টে দিন নরমাল অ্যাপ্লিকেশন
My lord, I am praying some time because he is admitted to hospital.
You are not admitted in hospital, you are the advocate. Client need not appear personally. Yes.
This is my matter, my lord. It may be sent, my lord, for mediation, my lord. may be
Let
sent
us
for
send it to mediation. You are for the appellant.
My lord.
Who is appearing for the respondent? Do you have an
For-
idea?
I have served, my lord. My lord, actually, my lord, I have not been able to contact with my client also. Yesterday, my lord, I have tried, my lord, repeatedly. I failed.
This is arising out of a matrimonial appeal.
Yes, yes, yes.
What
It
is the nature of you are the wife?
Why?
You have challenged a decree of divorce obtained by the
Yes,
husband.
yes.
There is a child of the marriage.
No.
No child. None appears for the respondent at the time of call. Full stop. Learned counsel for the appellant apprises the court that the appeal arises out of a decree of divorce obtained by the respondent husband. Full stop. In view of the dispute being matrimonial in nature, comma, the court is of the opinion that there is a fair chance of resolution of the dispute by way of mediation. Full stop. Accordingly, let the matter be sent to the Calcutta High Court Mediation Committee to explore the options of mediation upon notice to both sides.
My
We have incorporated upon notice to both sides.
My lord, I am for the appellant. My lord, this is also for
Similar.
similar, my lord. For
You are the
me.
husband, wife obtained the decree of divorce.
No, my lord. Husband's suit for divorce dismissed.
Any child of the marriage? Mr.
Yes, my lord. Yes.
What is the approximate age? I mean,
My lord, they are, my lord, I think they have attained majority.
acha. So we are referring it to mediation, as we have been. These have been earmarked.
My lord, upon notice to the
Upon notice to both sides, because it has to. The appellant is represented by learned senior counsel for the appellant. Full stop. However, comma, none appears for the respondent at the time of call. Full stop. Next para. This is the second occasion when the respondent remains absent. Full stop. Since the appeal arises out of the dismissal of the appellant's suit for divorce, comma, the matter pertains to a matrimonial dispute and otherwise fit for mediation. Full stop. Accordingly, let the file be sent to the Calcutta High Court Mediation Committee for exploring the options of resolution of the dispute between the parties by mediation upon prior notice to both sides.
Lordship, I was appearing for the appellant. I have long before given the no objection to the
Oh,
petitioner.
acha. You are Ms. Roy.
Yes, Monita
Paul Roy.
Roy. Yes, Lordship.
Acha. At the time of call, comma, Ms. Monideepa Paul, Paulter within bracket, Roy, comma, learned advocate, appearing for the appellant submits that she has given a no objection to the appellant and as such has no connection with her client. Full stop, none appears for the respondent even today. Full stop, next para. Since the matter arises out of a divorce decree, comma, we are of the opinion that the matter may be resolved by way of mediation. Full stop, accordingly, the file be sent to the Calcutta High Court Mediation Committee for exploring the options of mediation upon notice to both sides. Upon notice to both sides, so you are absolved of.
Grateful.
But you are still on record because they have not filed written objection. I have no objection. Give your appearance, we'll record your name, but you need not appear there. 8.
My lord, I am for the appellant.
Appellant, what is the matter about divorce suit?
My lord,
You are the wife. You are the
wife, my lord.
wife. So he obtained a divorce decree, or your divorce suit was
Me,
husband obtained a divorce.
wife obtained.
Your suit was dismissed.
My
You are
lord,
the wife.
my lord,
Appellant.
my lord, actually, 23rd June, 2025, your lordship passed an order to prepare paper book. But yesterday, court informed us that
No, these are appearing for the purpose of sending to
Mediation.
mediation.
my lord,
So
the
we'll
wife,
send it. Let us see
my lord, wife didn't want to mediate.
why. Mediation can always be a one of the modes of resolution.
My lord,
You never know because see, two things. One is here the husband obtained a decree of divorce, which you have challenged.
yes,
Husband obtained a divorce decree.
my lord,
You are the wife, you have challenged that.
my lord,
So mediation does not necessarily mean that you will have to concede to that divorce. It may go the other way also. You may be maybe a resolution will come out by which you will live together. The divorce decree is set aside. That can also be. So why not explore the option of mediation? Let us send it to mediation.
My lord.
Give a chance to mediation. If it fails, it will come back to.
my lord,
Initially, comma, learned counsel for the appellant wife submits that the appellant is not agreeable to mediation. Full stop. Next para. However, comma, upon a discourse between the court and learned counsel, comma, it transpires that the wife is not altogether averse to mediation. Full stop. In any event, comma, since the dispute pertains to a matrimonial issue, comma, it would only be appropriate if the parties are given a chance to mediate. Full stop. In any event, comma, the outcome of the mediation may go either way, comma, by the divorce decree being sustained or the parties choosing to reconcile and live together. Full stop. Next para. Moreover, comma, in the event mediation fails, comma, the parties always have the option to revert back to court and mention the matter for being included in the list for hearing. Full
my
stop.
lord, my lord, the husband already married.
Therefore, why you carry it on? Mediation, in mediation, you ask for some alimony or something like that.
My lord,
Next part, accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of exploring the avenue of mediation upon giving notice to both sides. Thank you.
grateful, my lord.
If he has remarried, then it's all the better that you go to mediation and agree on a sum of permanent alimony.
My lord,
We think that's better.
grateful.
Next. কালকের একটা অর্ডার হয়েছিল সেটা কোথায় গেল? কাল অর্ডার হয়েছিল এটা। কালকের অর্ডারটা নেই কেন? অর্ডারটা আলাদা হলো কি করে? এটা মারো ম্যাটারে আছে নাকি? কিভাবে কোর্ট চলছে? parties yesterday when it was called on for hearing, full stop, even today none appears for either of the parties. Full stop, the appeal arises out of judgment dismissing the appellant's suit for declaration that the marriage between the parties is a nullity. Full stop, next para. Since the dispute pertains to matrimonial issues, comma, we are of the opinion that this is a fit case for mediation. Full stop, accordingly, the file be sent to the Calcutta High Court Mediation Committee for exploring the options of mediation upon notice to both sides. Next.
I am for the appellant, my lord.
You're for the appellant. What is the appeal about?
Lord, restitution of conjugal rights.
You sought restitution, failed.
Yes.
Your
Failed, dismissed.
Your suit was dismissed. So let us try the option of mediation. The appellant is represented by counsel, although the respondent is not. Full stop. The appeal arises out of the dismissal of the appellant husband's suit for restitution of conjugal rights. Full stop. In view of the nature of the dispute, comma, the appeal is deemed fit for being sent for mediation. Full stop. Accordingly, the file be sent to the Calcutta High Court Mediation Committee for the purpose of exploring the avenue of mediation upon notice to both sides.
My lord, item number 11, I beg to appear for the petitioner. My lord.
Yes.
This is in, my lord, for
Notice they have received?
Yes.
Received?
Yes, my lord.
Great.
My lord, expedite hearing of the matter pending before the learned tribunal, my lord, land tribunal.
What is the nature of the matter? What have you challenged there?
My lord, challenge the order passed by the appellate authority challenging a 7AA proceeding that was initiated after 20 years, but not giving me an opportunity to file my return, just giving me 5 days, just. My lord, we could not file because the big Rayat was ill at that point of time. We prayed for time; it was not considered. Against that, we preferred an appeal before the appellate authority. Appellate authority confirmed the order, and against that, we have come up before the learned tribunal.
Ways of 2012.
Yes, ma'am.
Why is it pending? You are sure you did not take time?
My lord, previously, my lord, there was my lord, shortage of members at certain point of time. Between 2014 to 17, my lord, and subsequently, my lord, but the last 3 dates, my lord, the matter was not heard at length.
Is there any pending application?
No, my lord, no pending application.
So OA 456 of 2012 can be directed to be
just the application.
Very well. Affidavit of service filed today be kept on record. Full stop. Despite service, none appears for the respondent. Despite service, none appears to Kedin. Full stop. Next para. The prayer in the present writ application is innocuous. Full stop. An original application, comma, bearing OA number 456 of 2012, filed by the present petitioners, is pending before the West Bengal Land Reforms and Tenancy Tribunal since the last 13 years. Full stop. Next para. It is evident that the parties are unnecessarily suffering for such long pendency of the matter. Full stop. Accordingly, WP LRT 121 of 2025 is disposed of by directing the West Bengal Land Reforms and Tenancy Tribunal to dispose of OA 456 of 2012 within bracket LRTT pending before it as expeditiously as possible, comma, preferably by the end of December 2025. No arrest to cost.
Yes, sir.
Thank you.
My lord, item number 12, my lord, similar, but this is a contempt application that is pending since 2010.
Oh, gradually the time is increasing.
Last date was 5th August. What happened on that?
My lord, on that date also nothing happened. My lord, the next date has been fixed on, my lord, 15/9/2025.
What is the number of the this MA is that content? What is the number
Yes,
of
my lord, MA 975 of 2011.
OA is of 2010, MA
Yes,
is of 2011.
Yes, my lord, my lord.
So you want a disposal of MA 975 of 2011 and also the OA, obviously.
OA is itself connected.
First you want to send them to jail and then we'll direct both, but
yes, but there was a direction before for the government representative to file the reply against our exception since 2014. Since 2014, they have not filed
If
the.
they choose not to, then the tribunal will proceed.
My lord,
without-
then has to proceed.
The
with
Galik
the-
was not even on the state panel then, so he cannot be blamed. Very well. Affidavit of service filed today be kept on record. Upon hearing learned counsel for the parties, it transpires that the prayer made in the present writ petition is innocuous, full stop. A contempt application bearing MA 975 of 2011 filed by the present petitioners in connection with OA 1985 of 2010 within bracket LRTT is pending pending for an inordinately long period before the tribunal, full stop. Accordingly, WP LRT 122 of 2025 is disposed of by directing the West Bengal Land Reforms and Tenancy Tribunal, fourth bench, to dispose of MA 975 of 2011 as expeditiously as possible, positively within 2 months from the date of communication of this order to the said tribunal. So it is expected that thereafter, the tribunal shall make endeavor to dispose of the OA bearing OA 985 of 2010 itself as expeditiously as possible, preferably by the end of December 2025.
My lord, the next date has been fixed on 15/9/2025.
15 and very well. So this is the timeline. Need not be preponed for that.
Careful.
But I beg to appear on behalf of the petition.
Yes, Mr. Ondal, what is the matter?
Lord, I've served up.
What have been served?
Yes, but my lord, whether my lord,
Any private respondent is there?
Yes. Ajit?
No, if you have served, that's all. No, it's
Yes,
not,
yes.
not yet been completed service. This is only receipt.
It has been served, my lord.
You have sent
last week.
only receipt. So
But, my lord,
what
matter
about the
is
track report? You have to file the track report.
Matter is extremely urgent, my lord. Track report,
Achha,
my lord, I did not
What is the
get.
nature of the urgency, Mr.
My
Mondal?
lord, the private respondent herein made an application, my lord, for recording of their name. My lord, though my lord, land is different. My lord, the land was originally belonged to our my lord, in the CS and my lord, RS record, LR record, my lord, it is in our favor. My lord, they filed an application for recording of their name.
CSRS in your name.
CS, RS, LR.
LR also?
LR also.
In your predecessor's name or your name?
My lord, my father's name.
Achha, then?
My lord, my father filed a title suit. Since my lord, the private respondent were disturbing their possession. My lord, interim order, my lord, of injunction was, my lord, granted. Even then, my lord, they started, my lord, disturbances. Police protection was granted in our favor.
Then?
All on a sudden, without making us a party for recording their name, my lord, they made an application before the learned tribunal. Learned tribunal.
Before the tribunal? Directly?
Land tribunal.
For recording their name before the tribe, not before the BLLRO, not a correction of the records of
For
right.
correction before the BLRO, thereafter they went before the tribunal.
Correction was refused by the BLLRO.
Correction, my lord, that was not refused, that was pending. That is why, my lord, they go in there. Before
Tribunal
the
directed that to be done quickly.
Directed
Representation to
tribunal,
be considered.
tribunal directed, my lord, the BLR to file a report. That report, my lord, whatever is there, my lord, we have no knowledge with that report.
Yes.
My lord, without, my lord, giving any chance to us, my lord, to show that report, my lord, BLRO, my lord, is asking us, my lord, to attend at the hearing. After getting this notice, my lord, we are appearing before the BLRO.
Yes.
BLRO is on that the land is vested to the state.
No, it will be premature to adjudicate on that. BLRO has to pass an order on you on their application for correction of the record of right. If you are aggrieved with that, you can challenge before the application.
But my lord, before that, when the report was called for,
no,
by the learned tribunal,
the BLRO has to give you a copy of the report, definitely.
My lord, that report, my lord,
but we don't know whether it will be given to provide it to you.
Yes, but my lord, they are not providing.
Hearing has not been concluded before the BLLRO.
My lord, that
what is
hearing,
the wrong in the order of the tribunal, Mr.
My lord, the wrong in the tribunal is that tribunal should judge whether at all the report filed by the BLR.
What is the order of the tribunal? Let us see
My lord,
The last annexure, Lord.
last
You
annexure,
are for the
Lord.
private respondent.
Lord, I am for the private.
So we can dispose it of.
Yes, because
upon
and
hearing all of you. Yes.
kindly see the last 2 pages of the writ petition.
Right.
There is
The last page, my lord, that is
there is
there.
one can because he was not a party in the way. That's why he preferred one special leave. This can.
Oh, acha.
Yes.
Can we are allowing?
And Lord has to be. My lord, but I find, my lord, kindly sees the fourth paragraph.
My lord, what I am on, lordship kindly consider.
Let us allow can first.
Yes.
Unless you have leave, you cannot.
Yes.
Since you are affected, your
Yes.
name is there.
My
So we
lord,
are allowing the can first.
my lord.
Can 1 of 2025 is an application for leave to prefer the writ petition before this court in view of the writ petitioners not being parties in the original application pending before the West Bengal Land Reforms and Tenancy Tribunal. House of Learned Counsel for the petitioners submits that the petitioner's predecessor's name was recorded in the CS records of rights, the RS records of rights, as well as the LR records of rights. However, the private respondents are seeking to disturb the same by applying before the concerned BL and LRO for a rectification of the records. Next para, it is further submitted that a civil suit is pending at the behest of the petitioners against the private respondents where an injunction order has been passed. Next para, upon hearing learned counsel, we are of the view that since the rights of the petitioners shall be directly affected in the event the adjudication in the event an adjudication is made by the tribunal, we are of the opinion, the petitioners are necessary parties to the proceeding and have a right to challenge the order of the tribunal. Accordingly, can 1 of 2025 is granted, thereby granting, can 1 of 2025 is allowed, thereby granting leave to the petitioners to prefer the present writ petition. Let us come to the
Now kindly comes to lordship.
Yes. Let Mr. Mundal place it, Mr.
My lord,
Malik.
lordship kindly consider page 70.
Order dated 8th of October.
My lord, 14th
14th March.
14th March. Very
14th
well.
March
Yes.
2022.
Yes.
My
Yes.
lord, lordship kindly consider third para. Accordingly, after hearing, my lord, both parties, we direct that the BLRO Kultoli Block District, my lord, South to Vishwargana, 2, my lord.
Panchanan Mundal is your predecessor.
Yes, my father. My lord, Panchan Mundal died long ago.
Anyway, yes.
Now, my lord, lordship kindly, if your lordship kindly consider, my lord, the application filed by them, that is with regard to different Khotiyan. Lordship kindly consider they have relied that learned tribunal relied upon the report, my lord, of the BLR. But my lord, learned tribunal before that would have considered the fact that the petitioners, my lord, file in the application. Well, that application, my lord, I have annexed. Lordship kindly consider the application, my lord, paragraph 2. My lord, this is, my lord, at page, my lord, 76. My lord, Khotiyan is different. My lord, Khotiyan number 498. They himself disclose.
Yes.
Now, my lord, BLRO served the notice. My lord, upon the Khotiyan belong to us. My lord, that was
What is
not
your
due to
Khotiyan
the
number?
land tribunal. My Khotiyan number is, my lord, 524.
5 to 4. How do you know it was a different Khotiyan? You
Lord,
have not got a
lordship
copy
kindly-
of the report, you said.
Lordship kindly consider, my lord, 6th fact of the case, para 2, II. Para II, lordship kindly consider Khotiyan number.
Para 2 we
498.
don't have. Para 2 আছে.
That is at page, my lord, 76.
It's para 3.
Yeah,
Para II.
That is para 3.
Para 3.
Para, my lord, in my petition.
Para 2 you are placing.
Yes.
There is no para 2.
My lord, that the application states that the subject matter of the instant application is the
That is
plot
my
of
application.
land. Is the plot of land described.
This
in
is
the
6 Roman 2. 6
Yes.
Roman 2.
Yes. And my lord, lordship kindly now consider, my lord, in my petition, my lord, the Khotiyan belong
You have
to us.
also applied for recording of your names.
No, my name appeared, my predecessor name appeared in the CS.
Predecessor's name is still there. He is deceased.
Lord, he is deceased. My father's name was there in the
Father's name is still there.
My lord, suit is pending. That is why, my lord, we have not applied for correction of our name. My lord, all of a sudden, the private respondent, my lord, they obtained patta from the, my lord, big riot.
Maybe.
The land was vested from the big riot, of the Khotiyan of the big riot. Now, my lord, what the authority.
That is in
BLRO
respect of Khotiyan number 498, which is a different plot.
Yes. But, my lord, BLRO, my lord.
But you
is
can
ha-
take all these points before the
Lord,
BLRO.
My lord, what
And only
happened?
direct that the copy of the
My
report
lord,
of the
what
BLRO.
happened? My lord, we are going before the BLRO. The local MLA, the local Sobapoti.
Mr. Mundal, you did not let us
all are
complete.
waiting there.
You did not let us complete. will direct the BLLRO the hearing to be held by furnishing all reports, all copies of all documents relied on by the BLLRO to all the parties, and then only giving both of you hearing, then decide.
But no MLA, BLRO, local Swapati Panchayat member, they will not be present. Yes,
can we pass such an order in an electricity?
But
no MLA.
But Lordship kindly consider.
No,
if your Lordship
whatever.
if your Lordship
If an
kindly,
MLA wants to be present, can we restrain him in this proceeding?
How they can present Lordship?
Okay, why should they not be present? Tell us.
Lordship just now, Lordship.
Anybody can be present in a hearing. Here also, if an MLA comes and looks at the proceedings, can we restrain him
then
or her?
What will be the fate of the BLRO? The BLRO is acting.
Shiver and pass an order against you, challenge that. Before a higher forum, you lose there, go up before the tribunal, lose there, come here, will not shiver.
Lordship kindly consider.
Mr. Mondal, we cannot apprehend anything. An MLA will be present. Can we direct in an order that no MLA? What categories shall we?
Friday was the date.
What categories shall we restrain? Tell us. MLA, MP, President of India, Chief Minister, Prime Minister. Then can we do that in this sort of a
even I will not be allowed to present in the office.
Mr. Mondal, we cannot presume that the BLLRO will be influenced.
But so far, Lordship kindly
we cannot. That will be prejudging the integrity of the BLLRO. But why should you do that?
Lordship kindly consider the Khotian is different. My Khotian is different.
Mr. Mondal, a notice has been given to you by the BLLRO. Tribunal has only directed the BLLRO to give you hearing and conclude the matter.
What report submitted by the BLRO, that should be considered first. Let my landed friend submit that report first before my lord.
We are doing it, we are directing precisely that. Before the BLLRO, copy of that report has to be given to you and to the other side, and both of you will be entitled to argue on that. You will get an opportunity of hearing on whatever report the BLLRO. That has to be there.
But Lordship
will make it clear in our order. Will not interfere with this order.
But Lordship kindly consider they have challenged Khotian number of their Khotian.
You will take all points, Mr. Mundal. If it's a different Khotian, how are you aggrieved? We shouldn't have granted this leave also.
Lordship kindly make it clear.
What shall I make clear?
Lordship kindly consider the report.
We'll record your submission, Mr. Mundal.
The report which was submitted before the BLRO, by the BLRO before the landed tribunal, that shall be considered first.
Aren't we repeating ourselves? Aren't we saying the same thing?
No.
Aren't we saying the same thing, you and I? We are repeatedly saying that report of the BLRO will be given to both sides. You will be given a hearing on the report. You are repeating that only.
But Khotian, our Khotian.
We have to start with a but.
The CSRS LR.
I ask you your name, Mr. Mondal, you will say, but.
Lordship kindly pass necessary order.
Precisely what you are asking, we are giving. But you have to argue. We are passing that order. The BLLRO will consider, give all copies of all documents will be circulated to both of you.
Before hearing took place.
No, after hearing they will give the copy. What sort of this arguments you are making? Obviously, it will be before hearing, Mr. Mondal.
At the hearing, we went there. We asked that.
We will direct.
Lordship kindly do this.
We will direct the BLLRO to give all copies to you prior to hearing. Are we not making ourselves clear in clear English, Mr. Mondal? Isn't it a wastage of court's time?
No. I am not wasting the.
You are totally wasting court's time.
But Lordship kindly consider the predicament of the petitioner. What? Where he will go? The landed tribunal.
You better go to the washroom first. Clear yourselves. You're full of.
Lordship kindly pass the order.
Excreta. The grievance of the petitioner is that a report of the BLLRO was taken on record by the tribunal before directing the BLLRO to decide an application for rectification of the records of right made by the private respondents. Full Learned Counsel for the petitioners argues that the BLLRO has formed a prior opinion by submitting a report, and as such, the petitioners apprehend that the BLLRO shall be influenced in passing its final order on the application of the private respondents without giving adequate opportunity of hearing to both the parties. Full Learned Counsel for the petitioners further alleges that despite having approached the BLLRO, no copy of the report has been given to the petitioners. Full stop. Heard learned counsel for the petitioners, the private respondents, as well as the state. Full stop. Upon a perusal of the impugned order, comma, we do not find any illegality or irregularity having been committed by the tribunal, which merely directed the BL and LRO to dispose of the representation given by the private respondents for rectification of the records of rights in their name with regard to a particular plot. Full stop. In fact, comma, the tribunal clearly recorded that before such disposal, comma, all necessary parties, including Panchanan Mondol, shall be given a hearing. Full stop. The petition, since the petitioners say that the Panchanan Mondol, comma, the predecessor in interest of the petitioners is no longer living, comma, it is made clear that the present petitioners, comma, who claim to be the heirs of Panchanan Mondol shall be given a hearing. Full stop. Next para. Thus, comma, we do not find any infirmity in the impugned order. Full stop. Accordingly, WPLRT 125 of 2025 is disposed of without interfering with the impugned order, but making it clear that the BL and LRO, comma, Kultoli block, comma, district South 24 Parganas, comma, shall dispose of the representation given by the private respondents regarding effecting corrections to the records of rights upon giving adequate opportunity of hearing to all the necessary and interested parties, including the present petitioners. Full stop. Before such hearing, comma, the BLLRO shall furnish copies of all documents, comma, including its report which was filed before the tribunal, comma, to all the concerned parties, including the petitioners and the private respondents. Full stop. In the event the BLLRO seeks to rely upon other documents or the parties seek to rely upon other documents, comma, the BLLRO and the parties shall circulate advance copies of all such documents among all the parties beforehand. Full stop. Such circulation shall be effected at least 1 week prior to the date of hearing before the BLLRO. Full stop. It is expected that the BLLRO, comma, upon giving such opportunity of hearing and circulating all documents, comma, shall dispose of the representation of the private respondents as expeditiously as possible, comma, preferably within 2 months from the date of communication of this order to the concerned BLLRO. Full stop. It is made abundantly clear that this court has not gone into the merits of the contentions of either of the parties, and all points will be kept open for being decided by the BLLRO in accordance with law. No orders to question.
With regard to Khotian, my lord will not.
All points are kept open, whatever points you take. Next. Alimony. Other side.
The area, my lord.
You are the husband for the husband.
For the husband.
Areas have not been paid.
If your lordship can come to page 16 of her petition, my lord, application.
Can 6 is for what?
For area. Come to page
Lordship,
16.
the modification application was filed before.
There was a can.
Achha, let them move it first. There. Yes.
Lordship, there
You take your
was-
seat, Miss. Yes.
Modification. there was
Use the microphone.
alimony was granted, lordship. Thereafter, the matter came up before your lordship. Then they filed an modification application before Honorable Justice Shaw mentioned for the modification of that order. Then,
Modified order was modified.
No, that was dismissed. Now I have came.
So that order remains, whatever order was.
Yes, lordship.
Yes.
I came before your lordship to pay the area. At present, they are paying the current months at the rate of 7,000. But initially, the
What is the quantum of area
30,
according to your calculation?
30.
Both of you agree on that?
Lordship, actually, today,
Why are you looking at her?
Lordship, today the brief is not with me, so she's.
You please go through their quantum and check up with your client whether that is correct or not. If you agree on the quantum, we'll.
They have not disputed the quantum. That is whatever they are paying, lordship. It is in.
What is the quantum? We calculate. What is the period of?
I have mentioned it, lordship.
We won't sit here and calculate. And in any event,
It
if you
is, it is
if you
mentioned,
calculate, you are at risk.
Lordship, it is mentioned in paragraph 12, Lordship, page 5. It's 3,38,000.
আমরা তো অলরেডি ফাইনাল অর্ডার দিয়ে দিচ্ছি অ্যালুমিনিয়াম, শুধু এরিয়াটা দিচ্ছি না বলে এসেছি। ওটা রিওপেন করা যাবে। ওরা মডিফিকেশন চেয়েছিল, সুমনদা থেকে সুমনদা রিকোয়েস্ট করেছে। From when was the alimony directed to be paid? You say she doesn't have the brief.
If your lordship can come to page 16, my lord, there was
16, as you said,
there
yes.
was 2 can. One can is filed by me, can 5, which is for modification, and that was dismissed.
Right.
So the amount is 10,000 back to 10,000.
We directed 10,000.
No, my lord directed 7,000 for the time being, until the
Modification.
application was heard out by the learned judge.
So what is the total arrear according to you? It should be paid from which date?
And if your lordship can come to the bottom of that page, there was a can filed by them for arrear, my lord. And
No,
here
just
is-
give us the period when we since when do you have to pay? What the arrear since when? What was the direction?
liberty is given to the petitioner to pay before the trial court by filing an appropriate execution proceeding, realizing the arrear, my lord. Arrear
From
is-
when does the arrears accrue? You are directed to pay from when? Which month? From the date of the application. What is the date of the application? You are asking the month from when it is to be paid.
17th May 2022, right, sir?
The application date, the original alimony application date. Where is the first order of alimony? Shows the first order of alimony.
Yeah, next question.
15th of March.
17th of May.
2022, Lordship. Page number 9, Lordship.
Yes, Justice Sen and Justice Mukherjee.
Yes, Lordship.
Alimony pay per month till disposal of the appeal. Arrears were not directed.
But from that day, they were not paying, Lordship.
No, this is the only order of alimony, 17th of May. You check up, that is the order of alimony. It does not say anything about arrears.
But from 22, that time they were not paying, Lordship.
Acha. Shall continue to pay alimony at 2,000, 10,000 till disposal. Means from May 2020, they have to pay. They have started paying from when?
Finally, they are giving, Lordship, paying, Lordship. After that modification application, they are
What is the period for which they did not pay? Your application is for payment of arrears. You have a copy of their can 6?
Yes, my lord.
This is can 6.
This is my copy.
You also tell her what to argue.
Lordship,
Give her the application, tell her what to argue, and you argue.
Lordship, I'm paying for short.
No, not now. No, not.
Lordship, just
We'll just calculate arrears. Calculate from, you have your copy of your application. Do it right now.
area I have calculated. It is
What is the period during which they did not pay?
from the date of order, Lordship.
From May till when? When did they start paying? সময় নষ্ট করে বলুন তো কোর্টের একটা অ্যালিমনি অ্যাপ্লিকেশন কোন মাস থেকে কোন মাস দেয়নি সেটা বলতে পারছে না, মক্কেলের কাছ থেকে ফি নিচ্ছে। From when did they start paying? It's your application. Look into your application and tell us. Why should he find out everything for you?
No, Lordship, this is my fault, Lordship. That was
Nobody's fault. Please look at your application and tell us. You did not draft your application.
that was marked.
Look into the application. It's before you, ma'am. The application is before you. You are looking at us and asking for time for your copy to come. কি অ্যালিগেশন দিয়েছে, ক্যান 6 এ কি বলেছে, কবে থেকে দিচ্ছেন? there was violation of the. কবে দিয়ে দিচ্ছি সেটাই বলেনি সুচ 3,38,000 as on the date of filing of that application. What is the basis of the calculation?
Lordship, 10,000 per month. It was
10,000 per month from which month? May 22.
22. Then that order was modified later. Your Lordship directed to pay 7,000. From there, 7,000 they are paying, Lordship. That order was passed.
Please give the breakup. You have a breakup. What is the arrear according to you?
I don't have the breakup. Because
Do you have what are the arrears according to you?
periods are really hard to calculate, my lord, because 7,000, 5,000 he is as
From when did you start paying? You can't mathematically calculate.
start paying from the very beginning, from the trial court itself.
But
Neither of the parties' counsel are able to assist us as to the breakup of the arrears of alimony claimed by the appellant wife. Footstep learned counsel are requested to come prepared in the matter and elucidate as to what is the exact breakup of the arrears of alimony payable by the respondent husband. Footstep, the parties shall give their respective file their respective breakups upon exchange of copies between themselves on the returnable date. Footstep, the application shall next be listed on August 11, 2025. Next. August 18. Next. None appears to move the application. Footstep, as a last chance to the appellant to move the application, the matter is adjourned for the day. Footstep, it is made clear that in the event none appears to move the application tomorrow, when the matter is next called on for hearing, the matter may be disposed of ex parte. Next.
This matter I'm appearing on the response.
And for the petitioner, my lord, there is 119 days delay. It's a matrimonial matter.
Matrimonial means your suit was dismissed or their suit was decreed?
My suit was dismissed.
Divorce suit?
Yes, my lord. Suit for divorce. Now, my lord, what happened is this only ground which has been possibly shown by the court is that why I filed Section 9 application earlier. And it is on the same cause.
But Section 5, you have to cross this hurdle first.
I have, my lord. I have said that Section 9 application, whatever I had said, my lord, it is not in consonance with.
No, what is the reason for the delay?
Reason for the delay, my lord. Reason for the delay, I have said that, my lord. I asked my advocate to.
Literally jaundice. Jaundice is your ground.
Well, jaundice is my brother's jaundice.
Brother's jaundice.
And I was the only person to look after my brother. But the other ground
fraternal feeling.
My other ground is, my lord, can you look at
such brotherly love is not found nowadays.
Ordinarily, but
so your brother is unable to look after himself.
Totally.
Why?
Totally became unable because he was in the hospital.
Because of jaundice.
Hospital also.
You were the only person to look after.
Yes, my lord. I was only person. 8/2/2025 to 14/4/2025. She was in the suffering from jaundice. My lord, page is, my lord, at page 31.
For 2 months.
For 2 months, my lord, and earlier, my lord, while I allowed my advocate to draw the petition, my lord, she could not. My lord, I have communicated to the advocate.
What is the period of delay?
The period of delay is 119 days, my lord.
119 days.
Yes, my lord. Can you look at page 27 once, my lord? I communicated and recorded the matter in the WhatsApp to my advocate.
Without giving the money?
No, that's not possible, my lord. Advocates, I don't want to say anything about. But my lord, can you look at that particular? No answer from the advocate.
Would you answer if they did not pay and sent you a WhatsApp message saying that draft my petition? I wouldn't. When I was an advocate, I wouldn't. If somebody sends me a WhatsApp telling me file my application without
it's not a
caring to meet me or whatever.
It is a question when he returned the brief, my lord, I said that it is for your reason, my lord, I could not file that proceeding in time.
If if there are allegations against the advocate, then you have to give a notice to the advocate.
Lord, I can give the notice, Lord,
Give a
possibly, Lord, well, can you look at once? I said, Lord, possibly we have to file.
That's the standard practice in our court. If you blame an advocate,
I'm not
you have-
really blaming, Lord. Can you look at page
you have to
27?
give a notice to. We want to hear that advocate.
Very well, Lord. I
You're
will
taking a risk. Your application may be dismissed if they come and say that they did not do this thing.
Possibly, Lord. Can you
Take
look
the
at
bar at face value.
well,
first.
can you look at page 27 once and thereafter your lordship decide? Well, I have never blamed
Deprecate
him.
this practice of.
Well, I have never blamed the advocate. I said that it is for your reason, my lord, that it could not be done, my lord. I will be only saying that I will be filing my
At the
application.
27, please read it.
Well, read it, my lord. আমার ডিভোর্স কেসের ম্যাট্রিমোনিয়াল স্যুট নাম্বার এটসেট্রা জাজমেন্টের বিরুদ্ধে মহামান্য হাইকোর্টে অ্যাপিল ফাইল করতে সমস্ত ডকুমেন্টস আপনাকে দেওয়া হয়েছিল, কিন্তু সেখানে অনেকটা দেরি হয় আপনার তরফ থেকে, হয়তো আপনার ব্যস্ততা এর একটা অন্যতম কারণ। যাই হোক, বর্তমান মামলাটি মহামান্য হাইকোর্টে ফাইল করা হচ্ছে, কিন্তু অনেকটাই দেরি হয়ে যাওয়ার জন্য লিমিটেশন একটা বাধা হয়ে দাঁড়িয়েছে। ফলস্বরূপ একটা লিমিটেশনের একটা পিটিশন মহামান্য হাইকোর্টে
This is post facto. This is just to create a ground.
he has created ground. But will kindly look at then, my lord, my brother's own illness. That is also one of the factor within the time, my lord.
Brother's own illness has to be own brother's illness, maybe.
My lord, will kindly look at, my lord, page number 31 to 33, my lord. Kindly, my lord.
Medical.
Official document, my lord. My lord, will kindly look at
What is
that.
official about?
My lord, will kindly look at the particular portions. It is said that it's suffering
Yes,
from.
what should you do?
Melody, I will draw your lordship attention. Just page 4, para 5. Lord, what they have submitted, that learned advocate did not take any steps. Your lordship will find on 16th April 2025, the learned advocate handed over the brief. Handed over the brief to them. Thereafter, your lordship will find. Next para, a photocopy of the relevant communication, WhatsApp communication dated 24/28/4/25. My lord, when they have received the copy, what is the necessity of this WhatsApp? When they have received the copy, they are taking plea against the lawyer. But lawyer has, let me finish. Lawyer has handed over the brief. Thereafter, your lordship will find. Just I will draw your lordship attention on page 6, paragraph 8. Page 6, the appellant hand immediately after getting the paper from advocate Soman Shamanto on 16th, as stated herein, contacted another lawyer on 15th April, my lord. 16th April, he got the paper.
It should have been on 16th April. It should have been a printing mistake, my lord.
16th April, he received the paper from the lawyer and he sent the WhatsApp subsequent to that. And thereafter, on 15th, he handed over the paper
It is
to the
not a
lawyer.
15th, my lord. It should be 16th, my lord.
And apart from that, your lordship will find, so far medical ground is concerned, each and every day he attended before the trial court in maintenance case.
Earlier,
If your
earlier
lordship
time,
call for the record,
earlier.
if your lordship call for the record during this period, he each and every day contacted matrimonial case, maintenance case, and maintenance case has been disposed of at the.
But I have not yet shown, my lord, my brother's eye
And
operation.
he has not.
Eye operation also at page.
How could you attend the maintenance case?
Yes.
There is no maintenance case.
Yes, there is maintenance case.
That maintenance case.
File an opposition.
I am
You
paying-
file an opposition. We'll grant you.
Yes, my lord, I will file
My
complaint.
lord, I am paying the
My
maintenance.
lord, I will file opposition.
Maintenance to the
The premise of the present application for condonation of delay is twofold. -1, the alleged jaundice of the brother
and eye
of the
operation. my lord.
petitioner as well as his eye operation, for which the petitioner apparently had to attend his brother. And secondly, the delay committed by the first learned advocate who was entrusted by the petitioner to prefer the appeal. Full stop. Next para, learned counsel appearing for the respondent points out certain discrepancies in the dates on which the brief was received back from the erstwhile advocate and handed over to the new advocate. Full stop. It is further submitted by learned counsel for the respondent that throughout the period during which the brother of the petitioner was allegedly ailing, the petitioner had attended a maintenance proceeding, thereby belying the grounds taken in the application for condonation of delay. Full stop. Next para, since several factual contentions have been raised by the parties, the respondent is directed to file an affidavit in opposition to the application under Section 5 of the Limitation Act within within 1 week?
Yes, my
Within a week from date?
Yes,
Full stop. Reply if any within 3 days. Thereafter.
Also 1 week.
Acha. Reply if any shall be filed within 1 week thereafter.
My lord.
The application shall be listed for hearing on September 8, 2025. When an 8, 2025. Full stop. Next para. Since allegations have been leveled against the learned advocate who was allegedly entrusted with a copy of the brief first, comma, a copy of the application shall also be served on the said learned advocate, comma, along with a server copy of this order indicating the next returnable date. Full stop. An affidavit of service to that effect shall be filed on the returnable date. Full stop. The learned advocate on whom such copy is to be served will be at liberty to be present or be represented to place before this court his stroke her version of the matter.
Well, grateful, my lord. Well, only, my lord, so far the earlier affidavit of service was concerned, my lord.
We'll
Service
consider.
track report is there. If necessary, I can file it because service has to be shown to be complete.
No, keep it with you.
I've
Yes,
already
yes.
appeared. I'm good.
What is the appeal about?
The appeal challenging the judgment and order dated 3rd May 2024 passed by the additional district judge Kagdim, my lord.
Judgment decree dated.
Dated, my lord.
You are the this is a matrimonial appeal.
Matrimonial appeal, my lord. Can one is for
your suit was dismissed or their suit was
my lord, their suit she has succeeded in her suit, my lord.
Divorce suit.
Divorce suit, my lord. Challenging the
what is the nature of this application?
Application, my lord, for paying for stay, my lord.
Achha, let us see the defect first.
My lord.
Some of the defects have been removed by you.
My lord. My defect has already been removed, my lord.
Removed, yes. Well, so you are sure she has not married yet?
My lord, she has not married yet, my lord.
Not married yet.
My lord.
Will not grant stay, will mold the relief and grant an injunction so that she cannot remarry.
She cannot remarry.
We'll pass that injunction for a limited period and because stay of a judgment in rem we do not generally pass. There are other ramifications also, because otherwise you will be claiming certain rights as her husband. We don't want that, but she will be restrained from remarrying.
Deeply obliged. Okay.
The present appeal arises out of a decree of divorce obtained by the respondent wife. Full stop. Next para. Since questions of both facts and law are involved in the appeal, comma, the same is required to be heard on merits. Which is the next para. Although the present application has been filed for stay of operation of the impugned judgment and decree, comma, since the said judgment is in the nature of a judgment in rem, comma, we are loath to pass a blanket stay of operation. Full stop. However, comma, in order to save the appeal from being rendered infructuous, comma, we restrain the respondent wife from contracting any remarriage, comma, if not already done, comma, during pendency of the present application. Full stop. The appellant shall serve a copy of the application on the respondent indicating that the application shall be listed for hearing next on September 15, 2025. Full stop. Affidavit in opposition, if any, shall be filed within a fortnight from date. Reply, if any, shall be filed within a week thereafter. Thank you.
I beg to appear for the appellant, my lord.
I beg to appear on behalf of the read petitioner respondent.
All have been served.
Yes, my lord, you are appearing, my lord.
You are for the state.
I was the read petitioner respondent.
I was the private respondent, my lord. I have come up in the appeal, my lord. They are the read petitioner, my lord.
What is the order under challenge?
The order, my lord, has been passed on 10th of February 2025.
Yes.
That we, the private respondent in the read petition, my lord, had raised, my lord, issue of maintainability of the read petition.
You had raised.
We had raised, my lord.
Why not maintainable? What is the nature of the writ?
Yes, my lord. My lord, on 4 grounds, my lord, we had raised the point of maintainability, my lord. First was the locus of the petitioner. But second was the conduct of the petitioner. Third was, my lord, choosing of correct forum. And fourth was my lord, delay and latches. But why my lord,
delay?
delay and latches? But why have we raised my lord? I shall place before your lordship. But only one thing, my lord, I should be candid before your lordship. But in this matter, we are being led by Mr. Abhatosh Majumdar. Your lordship may hear us today, but if your lordship kindly, my lord, gives him some day, my lord, some time to my lord, address your lordship on this.
The appeal will be over before we hear him. If these are the 4 points, it will be over before we hear him. It may be over even before we hear you completely. So,
may I place my subject to your lordship's kind consideration?
Yes, absolutely. You are encouraged to do that.
Very good. Your lordship, my lord, find my lord.
You cannot assure a success. I mean,
I will try my best.
You are competent enough, you can do it. I mean, you argue your matter. Why not? Whatever is the merit will happen before in your hands or in Mr. Majumdar's hands. Doesn't make a difference. Yes.
Your lordship would find the impugn order appended to my stay application at page 195.
What was the relief sought in the writ petition?
Yes, my lord. Your lordship kindly comes to the prayers in the writ petition, which your lordship would find, my lord, at page 37 of the stay application. But may I just indicate this backstory, my lord, of this writ petition? But the private respondent of the appellant before your lordship is a successful MR distributor. Now, my lord, the vacancy for this distributorship, my lord, was, my lord, published in the year 2007. But petitioner was also, my lord, one of the applicants. He was not successful. I was the successful, my lord, candidate. My lord, in 2012, I had filed a writ petition, my lord, seeking a direction upon the respondent authorities, my lord, to act on the recommendation that was made, my lord, indicating that I was the most suitable candidate. Now, that writ petition in 2012 was finally disposed of in 2015. Now, my lord, your lordship would kindly, my lord, indicate or mark the date 2015. Why, my lord, I say so?
Your writ petition.
My writ petition.
Yes, 2015.
Because when the vacancy was, my lord, published, the vacancy was published in terms of 2003 control order. And in the inter-exam in 2013, a fresh control order, my lord, came into force, my lord. So when, my lord, in 2015, my writ petition of 2012 was disposed of, a specific submission was made on behalf of the state respondents that my application is pending before the respondent authorities for taking further steps, beginning thereby, my lord, for grant of issuance of the license. There was a specific direction upon the respondents to grant me a license if I am, my lord, eligible in accordance with law.
But your representation was on the basis of the 2003 control.
2010, my lord, my recommendation was there. 2000.
So that was on the basis of the 2003 control order.
Lordship.
Very good.
Now, my lord, after the passing of that order, my lord, the respondents took a stand that because in the inter-exam there has been a change of the control order, so my lord, in repeal and savings, my lord, all the, my lord, the vacancies, my lord, gets, my lord, eliminated. I again, my lord, challenge that vacancy notification as well as my cancellation. In 2022, my lord, this honorable court, my lord, passes a direction directing, my lord, the respondents, my lord, to, my lord, issue a license in my favor. But I'll take your lordship to that judgment, my lord. Now, my lord, challenging that order, a leave to appeal was preferred by one candidate who was the unsuccessful candidate.
Directly without preferring an appeal.
My lord, sir.
Directly SLP.
No, leave to appeal before the intercourt appeal, my lord. That appeal got
leave to appeal because he was not a party.
He was not a party, but he was not required to be made a party. Now his appeal got dismissed. He then, my lord, went to the Supreme Court. His SLP has been dismissed. Your lordship would be amazed to see that both the averments in this writ petition and that petition are identical.
So you mean to say he is set up by the
lordship?
Maybe, yes. May have identical advocates and identical interests.
Well, I will not say more, my lord.
May have. I mean, there is no conflict of interest between them.
But, my lord, the conduct of the petitioner.
So, res judicata, we cannot say.
Will not be applicable in this case, my lord. But if your lordship kindly comes to my lord,
that will be destructive res judicata, not constructive. Yes.
If your lordship kindly comes to my lord, stay application. If your lordship kindly takes up, my lord, from page 18 of my stay application.
Paragraph 10 corresponds to paragraph 8 of the
So these people file a fresh writ petition seeking that relief that your MR dealership should be granted. In the meantime, license had been given to you.
License has been given to me, and today I am operating.
What is the ground for their writ petition? Different grounds maybe.
Same grounds, my lord.
You will say different ground. We get your point, and we'll hear. Yes.
ঠিক আছে, ঠিক আছে. If your lordship kindly comes to my
What is the ground basically? What is their
but
ground?
today the grounds before the your also in the writ petition
Writ
is
petition?
my lord,
Yes.
that first is my lord, they seek for a cancellation of my approval, my lord.
On what ground? Why should it be cancelled?
Yes, my lord, on two grounds, my lord, mainly. One is, my lord, the godown that I have constructed or godown that I have offered is, my lord, is not sanctioned by the appropriate authority, my lord. And second is, my lord, the land that I have offered, my lord, is not, my lord, is a basjar. And, my lord, in terms of the, my lord, rules prevalent today, my lord, as in a basjar, a godown.
Basjar as in bamboo grove?
Yes. No, my lord, no godown should have been, my lord. My application could not have been entertained, my lord.
Appropriately basjar.
Now, my lord, these issues.
So you have offered a bamboo grove for this MR dealership land?
No.
The bamboos, you have removed the bamboos.
Ma'am,
Send
we
it
have,
to them all.
we have applied for conversion, my lord. It has been converted, my lord. Today it is a commercial godown place, my lord. We have the documents to satisfy your lordship. And that is the reason, my lord, yesterday.
So what happened to their representation? That was rejected.
Yes.
That was challenged in the writ petition. How did the learned single judge proceed?
Yes.
Let us see that.
And before, my lord,
Your point of res judicata remains.
No, because when
Cannot be a
persons
res
are different,
judicata.
my lord.
Different.
Persons are different.
So we may be prejudiced on that, but we cannot do anything in your favor. So we have to see the
averments, my lord.
No, the merits of the order.
But before coming to the merits of the order, but may I take your lordship to the averments made in the writ petition, my lord, because these are important, my lord. And kindly comes to page 18, my lord.
18, yes.
Paragraph 9. Your
Yeah,
petitioner states that as per instruction of the district controller Murshidabad, subdivisional controller Jongipur, White memorated such and such, instructed your petitioner to remain present on his proposed office come go down along with relevant papers and documents on 20th of October 2008. Next paragraph. Your petitioner states that as per instruction of the district controller, Murshidabad subdivisional controller, Jongipur conducted inquiry and submitted report before the district controller Murshidabad in respect of 12 candidates out of 16 candidates who were found suitable, including your petitioner. Well, no document has been appended to this petition showing that he was the most suitable candidate. That document belongs to my clients.
All this happened before your direction was passed. The direction directing you to get the license.
Yes.
All this happened before the direction. All right.
In this regard, it is pertinent to mention hearing that during the course of hearing, subdivisional controller Jongipur, considering the antecedent of your petitioner, not only publicly opined that amongst all the candidates, your petitioner is the suitable candidate, but also forwarded the entire file to the district controller Murshidabad, recommending the name of your petitioner for grant of MR distributorship, license at Choki Moja and such and such. If your lordship kindly comes back to the vacancy notification, my lord, it starts at page 45.
Yes.
Well, the lordship has got the notification, my lord. This is the notification against which I have got the license today. Now, if your lordship kindly comes to my lord, page 53.
This is dated 2007.
Yes, the vacancy was published in 2007, my lord. The first notification was passed in 2006. It was cancelled and then republished in 2007.
You gave 2000. Oh, those were the control orders.
Control orders, my lord.
That's very good. 45 then?
Then your lordship may come to page 53, my lord.
Yes, 53.
Now, this is a very elaborate judgment. I will not trouble your lordship to the entirety of the judgment, my lord. If your lordship kindly comes to, my lord, page 64 or page 63, paragraph 15, my lord.
This was your writ petition?
My writ petition, my lord.
64.
63, my lord, kindly come.
63, sorry. Yes.
Paragraph 15, my lord.
15.
No reasons have been assigned by the respondent authorities as to why the issue regarding the grant of license in MR distributorship in respect of the vacancy declared by the memo dated 23rd March 2007 was kept pending even after the passing of the order dated April 7, 2011 in WP 2394W of 2011. Furthermore, when WP number 1606, this was my first writ petition, 16066 of 2012, was taken up for hearing on January 8, 2015, the specific stand of the learned additional government period on instruction was that the matter is pending before the respondent number 2 for taking further steps in the matter. Though the petitioner approached the court for grant of MR distributorship license on the basis of the process of selection initiated by notification dated March 23, 2007, when the 2003 control order was in operation, the petitioner cannot be blamed for the long pendency of the matter and could not also be made to suffer the consequences of the long pendency of the writ petition before this court. But paragraph 16, these are the observations of the Honorable Court directing the respondent to grant a license before me. Now your Lordship kindly takes up the impugn order. Why we are prejudiced by the order? Wherein the point of maintainability, as per us, has not been properly considered.
Yes.
It starts at page 195, my lord.
We are looking at the
Memo,
memo, so you can refer to the internal page.
Very well.
Yes.
Private respondent number 6 challenged the maintainability of the writ petition on twofold grounds. We are challenged on 4 grounds, my lord. So, 2 grounds, have not been properly, with all due respect to the learned single judge. Firstly, the writ petition is not maintainable due to the affidavit sworn by the special power of attorney on behalf of the petitioner is defective, on the basis of which this court cannot entertain the writ petition. Now, if your Lordship takes up the writ petition filed by my learned friend, my lord, the affidavit has been affirmed by a person who is not the petitioner. Now, if your Lordship sees the age of the person who has sworn the affidavit, his age is 24 on the date of while affirming the affidavit. Your Lordship would kindly recollect that the notification was published in 2007, So
maybe true to the records.
No, he says true to his knowledge. And there is not a single averment as to why the petitioner has not come and filed this petition or filed the affidavit.
Technical, very technical.
Secondly, on earlier round of litigation, one applicant had challenged the appointment of the respondent number 6, which was decided in favor of the private respondent up to the Honorable Supreme Court. The present petitioner again tries to agitate the same issues before this court. Thus, the present petitioner, being the fence sitter, cannot be allowed to challenge the appointment of the respondent number 6 as a distributor in respect of the impugned vacancy notification. Learned Senior Counsel submits that it is a well-settled proposition of law that any person approaches this court in its exercise of high prerogative writ jurisdiction ought not to make material statements which in fact untrue and or misleading, suppression and making misleading statements would culminate in dismissal of the said petition. Mr. Majumdar further submits that this writ petition was affirmed by one Muhammad Najmi Alam on 26 October 2023, claiming himself to be the constituted attorney of the petitioner. He further submits that on perusal of the said affidavit in the writ petition, it would be revealed that the age of the said power of attorney holder is declared to be 27 years. Mr. Majumdar argues that by swearing affidavit before the commissioner of this court, the said special power of attorney said that he was well acquainted with the facts and circumstances of this case. Mr. Majumdar submits that this instant vacancy notification was published on 8th of December 2006, but it will be 23rd of March 2007. It's typographical error, my lord. The first notification has been mentioned. The second notification is the actual one. Considering the present age of the constituted attorney, he was a minor at the date of issuance of such vacancy notification. The minor's knowledge regarding the fact of the writ petition cannot be considered and not determined the same to be true. The constituted attorney has stated before the commissioner that paragraph 1 to 30 of the writ petitions are true to his knowledge. The same statement cannot be true. Mr. Majumdar argued that the writ petition is defective due to ineffective affidavit. Thus, the writ petition is required to be dismissed in limine. We had cited a reference, my lord, of a judgment which was passed by the Honorable Allahabad High Court. I have the judgment with me, I'll place.
The relevant portions have been quoted here.
Yes, my lord. And paragraph 7, if your Lordship kindly sees, my lord.
Yes.
The Allahabad High Court rules contain in chapter 22 provisions for the directions, order or writs under article 226 and article 227 of the Constitution other than a writ in the nature of habeas corpus. Under rule 1 subsection 1 of chapter 22, an application for a direction, order or writ under article 226 and article 227 of the Constitution other than a writ in the nature of habeas corpus is required to be made to the division bench appointed to receive applications. Rule 1 sub rule 2 stipulates that the application shall set out concisely in the numbered paragraph the facts upon which the applicant relies and the grounds on which the court is asked to issue direction, order or writ, and has to conclude with a prayer setting out the exact nature of the relief sought. The rule further stipulates that the application shall be accompanied by an affidavit or affidavits verifying the facts stated therein by reference to the numbers of the paragraph of the application containing the facts. Such affidavit shall be restricted to the facts
which are within the deponent's own knowledge and shall further state whether the applicant has filed in any capacity whatsoever, any previous application on the same facts, and if so, the orders passed. Chapter 4 of the Allahabad High Court rules provides for affidavits and oath commissioners. Rule 9(2) stipulates that an affidavit filed on, I am not reading the entirety of the order, my lord. The lordship kindly comes to internal page 5. And only one internal page 4. The paragraph, the second last paragraph, which starts from quotation 9. And except in interlocutory proceedings, affidavit shall strictly to be confined to such facts as the declarant is able of his own knowledge to prove. Well, he says that true to his knowledge that the petitioner was first, there was a recommendation in his favor, there was no recommendation, my lord.
He was a minor when that notification came out.
Yes.
Notification is public record. It will be on the record even after that.
And notification, as well as when the application was also made and considered, he was then also a minor.
Application by
the
them.
petitioner, yes.
ওখানে বলেছে যে he is a suitable candidate.
আমি দেখাচ্ছি But then, my lord, we had cited the number of judgments, my lord, which says, my lord, that statements, my lord, material to the judgment or for statements which are judgment for adjudication of the writ petition, but has to be made, my lord. There should not be many untrue statements, my lord. Petitioner should be approaching this court, my lord, with clear hands, my lord. Internal page 6, my lord, Mr. Shahral and senior counsel appearing on behalf of the petitioner submits that a writ petition was filed by the petitioner through his constituted attorney. The special power of attorney was annexed with the writ petition by such said special power of attorney. One Muhammad Najmi Alam has sworn the affidavit before the commissioner of this court at the time of execution of power of attorney. He was major. Thus, the affidavit sworn before the commissioner cannot be said illegal. Heard the learned advocate peruse the affidavit sworn by the power of attorney holder. In para 2 of the affidavit, power of attorney holder stated that the statement made in para 1 to 30 of the writ petition is true to my knowledge. The fact of the impugned vacancy notification was of year 2006. Admittedly, considering the present age of the power of attorney holder, at the time of alleged vacancy notification, he was a minor. In Wasif Hussain Rizvi, the honorable, it will not be the honorable apex court following the Allahabad High Court, it will be honorable Allahabad High Court, not the apex court. Following the Allahabad High Court rules, has held that the application shall be accompanied by an affidavit or affidavits verifying the fact by reference to the number of paragraph of the application containing the facts. Such affidavit shall be restricted the facts which are within the deponent's own knowledge and shall further state whether the application has filed in any capacity.
By the impugned order, the main matter has been fixed.
Yes.
How is it a judgment within the contemplation of an intercourt appeal?
Lordship, if Lordship kindly comes to page 8, my lord, internal page 8.
Yes. One ground has been decided, but the other grounds have been left open.
And my lord, that one ground, although my lord, the honorable single judge has, my lord, indicated that there may have some legal flaws. Your lordship may come to, my lord,
legal flaws, yes, you have seen that. There may have been some legal flaws.
Yes, but it shall not affect the entire merit of the writ petition. And why we say so, my lord? If your lordship kindly comes to the writ petition once again, my lord.
The other questions have been left open to be argued, the other objections.
But my lord, these are material issues, my lord, for the purpose of adjudication of the writ petition, the locus point. I don't know why I say so. But petitioner says he was an applicant in the 2007 vacancy. If your lordship sees, my lord, the averments, my lord, there is.
Where is that?
Now, if your lordship kindly comes to, my lord, it starts from page. I'm sorry.
Petitioner is not the person who affirmed.
Yes.
Petitioner, it's in the first person. The petitioner is the actual petitioner.
Lordship may take, my lord, paragraph 10 and read it with page 116. And 118 is the type
of this conducted inquiry and all these things.
Yes.
He could not have had knowledge.
Yes. And second thing, my lord, kindly take, my lord, paragraph 8 or paragraph, my lord, 10 of the writ petition and read with paragraph 100, page 118, my lord. Why I say so?
Similar to the previous one.
No.
But please come to page 118, my lord. Kindly, my lord. Is the type copy of 116.
Yes, 118.
That second paragraph.
Hmm.
Considering the merits and demerits of the candidates on the basis of the
118.
118, my lord.
Second paragraph.
Yes, a vacancy.
Middle of that. Middle of
Yes,
that.
my lord.
Yes.
I'm sorry, my lord.
Considering merits and demerits. Yes.
The candidates on the basis of the inquiry reports of the subdivisional controller food and supplies Jongipur has recommended National Consumer Cooperative Store Limited as the most suitable candidate for filling up the said vacancy. So, my lord, there was a recommendation in my favor.
Tell us this.
Yes.
If I have knowledge of something when I was a minor, this is not a contract that he entered into at that point of time. Can't a minor have knowledge of something? Is it invalid?
But he's
per se is a minor's knowledge invalid? Can't a minor be a witness in a suit or in a proceeding?
May I, my lord, answer?
Yes.
And as far as
Minority does not affect the acquisition of knowledge.
But as far as the notification is concerned, the minor may have had knowledge.
Yes.
But regarding the fact that when the petitioner says that he was recommended as the most suitable candidate, or there was an
Even then he was a minor.
Even he was a minor.
He was in this world.
He was in this world.
As a minor, he might have had knowledge. You don't know that per se. We cannot say that he did not have knowledge.
But when these statements are untrue, my lord. These are false statements.
You say so, but how can we know that? At the inception threshold, how can we know that? It may be very true. He might have had knowledge. He has stated on oath. Per se, how can we say that he did not have knowledge of those? He might have known that this person was. He might have been a 14-year-old boy, and he might have known.
But may I place my two documents? Well, kindly have a look.
What are these?
Yes.
What are these?
These are, my lords, the stay application which was filed by one more disgruntled applicant whose application got dismissed. If your
These are not part of your writ petition.
Yes, yes. But in the opposition, I have taken these points. These are part of the affidavit of opposition filed by me, my lord. I have given a chart. I'm just producing a copy of the, my lord.
Now, what do you want to prove from this?
Para 8 corresponds to para 10.
This is in another writ petition.
Leave to appeal, my lord.
Leave to appeal filed by them?
Leave to appeal filed by
the previous
one more,
person.
Yes.
Yes. So you want to say that these are identical?
Identical. Absolutely identical.
How does it vitiate this person's application?
Because all the persons are coming and they say that they were all recommended as the suitable candidates. They have an approval in their favor.
This power of attorney holder says in the first person of the petitioner that the petitioner did this, that, and says that is within my knowledge. Suppose he was a minor at that point of time. How does that invalidate his knowledge? A minor can have knowledge also.
But a
minor, for having knowledge of something, a minor need not be a major. Otherwise, there wouldn't be any child witness.
The minor may have had knowledge, but
it's equivalent to witness evidence. Affidavit is equivalent to evidence.
But
so minor may have had knowledge. We don't know. How do you say per se just because you say so? Your minority, his minority does not affect his knowledge.
Your lordship kindly takes up the internal page 5 of that application.
Maybe exactly identical. He might have copy pasted from the previous application. They might have known each other. So what does that prove? How does that invalidate his writ petition?
Because in that case,
you say he's a fence sitter.
He's a fence sitter.
Fence sitter is another point you have taken, which the court has kept open for being decided in the final hearing.
And that is where we are.
Affidavit point has been decided.
Yes.
This is not a judgment. Let us put it under the unless it's a judgment deciding some rights of parties. It's not amenable to intra-court appeal. Not amenable to intra-court appeal. This is not something which has decided any right of any party. One point, maintainability, but we are against you on that and we'll give our reasons. We have given you already the reasons actually. So no.
But may I just indicate 2 more points?
Yes.
If your lordship allows me.
Absolutely. Why shouldn't we? Since we are against you, we are all the more allowing you. And since Mr. Shahara has come, we'll allow you more. Yes. Yes.
Now, man, kindly takes up in this writ petition, what are the grounds that they have taken, my lord?
See, whatever grounds they have taken, it will be premature to go into those because the learned single judge has kept all these questions open, and the premise of this order is that yes, I decide the first issue because it hits the root, that affidavit question. But the other points, court says that factual considerations are also necessary and has fixed the writ petition itself for hearing. And also, See, otherwise, ready for hearing at this juncture, this court rather intends to hear out the entire writ petition than to dispose of the writ petition on the point of maintainability. Accordingly, arguments on the second point of maintainability set at rest for the time being. We can add one line that this expression itself shows that other grounds of maintainability are kept open. Mr. Shah won't be disputing that. We'll say that. But on this issue, we are against you. We'll clarify why we are against you. And we have expressed to you. Other grounds all are kept open. We'll make that very clear, and the judge has made it clear. The present challenge has been preferred against.
My lord, only one thing, my lord.
Yes.
This point was also taken by us. That, my lord, if your lordship kindly comes to, my lord, page.
Other points are kept open. All points are kept open. Nothing has been decided.
No, no, that is not the issue. I'm sorry, my lord. The thing is that, my lord, the points, the grounds that they have taken, these issues have already been agitated before the Honorable Apex Court. The Apex Court, after hearing those points,
that also has to be gone into upon looking into the Apex Court order, looking into
before
not
the
only.
Honorable Single Judge.
See, learned single judge was deciding only on the point of maintainability.
Regarding the filing of
When
the
he
affidavit.
said that no, after this affidavit point, he said it requires a consideration of the materials and here everything on merits. And there, because for deciding that, learned single judge had to look into the Supreme Court's order, not only an order in isolation, the matter, the pleadings from which that order arises. Obviously, if I have to say res judicata, I have to see the plaint pleadings, the plaint relief, and in context of that, I have to see the judgment, previous judgment. Same principle applies here also. One order of the Supreme Court says XYZ. XYZ arises from what pleadings? I have to see that to consider res judicata, isn't it? And res judicata is not applicable as per your arguments also.
Yes, because of the different persons are
At
coming.
best set up. Somebody has been
Yes,
set up.
Yes.
So that can at best, we won't furnish you with further grounds, but at best clean hands.
We have raised those points.
Those will be decided, have not been decided as yet.
Only one thing, like your lordship has given us enough time. If any day, my lord, if your lordship kindly hears Mr. Mujumdar for only 5 minutes, my lord.
Yes?
Mr. Mujumdar for 5.
No, no. We have constructively heard him. If he is in court premises.
No, he's not in court. He's in some personal difficulty today.
No, then don't give his name.
I will not give his name, my lord. So I was only playing because he has requested me to request your lordship, my lord.
This is nothing has been decided.
না জজ সাহেব সেটা বলছেন না জজ সাহেব অন্য কথা বলছে
The present challenge has been preferred. Yes, Vishal. The present challenge has been preferred against an order dated February 10, 2025, passed in WPA 25813 of 2023. Full stop, next para. The moot question involved in the writ petition, comma, in connection with which the impugned order was passed, comma, is a challenge thrown by the writ petitioner stroke private respondents herein against the allotment of MR dealership license.
Distributorship.
Sorry, MR distributorship. Thank you. Distributorship license in favor of the present appellant. Full stop, next para. There is a checkered history to the matter which is submitted before us by learned counsel for the appellant. Full stop. However, comma, upon hearing learned counsel for the parties, comma, we find that by the impugned order, comma, the writ petition itself has not been disposed of. Full stop. The present appellant, comma, who is the private respondent number 6 in the writ petition, comma, took a 4-fold challenge as to maintainability of the writ petition, comma, the first of which was that the writ petition was not maintainable in view of the affidavit having been sworn on the basis of a special power of attorney by a person who, comma, by his own admission, comma, was 27 years old at the time of filing of the writ petition in the year 2023, whereas the relevant events pleaded in the writ petition took place during a period when the person who swore the affidavit was a minor. Full stop, next para. The learned single judge decided such point against the application against the present appellant. Full stop. However, comma, the learned single judge was of the opinion that insofar as the other grounds of maintainability and the merits of the writ petition was concerned, comma, it would only be appropriate if the learned single judge decided the writ petition itself. Full stop, next para. As such, comma, we do not find that the impugned order qualifies as a, within double inverted judgment, double inverted clause, which is amenable to an intra-court appeal, comma, since no substantial rights or liabilities of the parties has been decided as such. Full stop. However, comma, the appellant has a point in arguing that one of the prongs of the attack to maintainability being decided, comma, the rights of the appellant in that limited regard has been affected. Full stop. Accordingly, comma, we take up the appeal on such limited issue. Full stop. Next para, the learned counsel for the appellant, comma, as before the learned single judge, comma, relies upon certain judgments as well as the provisions of the Code of Civil Procedure in support of the contention that if there is infirmity or misrepresentation or erroneous disclosure in an affidavit, comma, the same merits a dismissal of the connected application under Article 226/227 of the Constitution of India. Full stop. Next para, by placing reliance on Syed Wasif Hussain Rizvi versus Hassan Raja Khan and others, reported at 2016 SCC Online, Allahabad 179, comma, it is contended that the court held in the said case that an affidavit shall be confined to such facts as the deponent is able of his own knowledge to prove. Full stop. On an interlocutory application where a particular fact is not within the deponent's own knowledge but is based on his belief or information received from others, comma, which he believes to be true, comma, the deponent is required to use the expression that he is informed and verily believes such information to be true, or words to that effect. Full stop. The court, comma, in the said judgment, comma, also quoted the provisions of Order 19 of the Code of Civil Procedure, comma, as amended in Allahabad. Full stop. Next para. Learned counsel also cites Padmavati Dasi versus Rasik Lal Dhar, comma, a 1910 decision where it was held by this court that the provisions of Order 19, Rule 3 of the Code of Civil Procedure must be strictly observed, and every affidavit must expressly state how much is the statement of the deponent's knowledge and how much is the statement of his belief, and the grounds of belief must also be stated with sufficient particularity. So next para, next relying on Dalip Singh versus State of UP, reported at 2010 to SCC 114, comma, it is stated that if inaccurate, untrue, or misleading statements are made in an application, comma, in dealing with such applications for special leave, comma, the court naturally takes statement of facts and grounds of fact on their face value, and it would be unfair to betray the confidence of the court by making such untrue and misleading statements. Full stop. Next para. On a careful perusal of the rationale read down in the said judgments, comma, we are, comma, however, comma, of the opinion that the said propositions are not directly germane to the present case. Full stop. Insofar as Syed Wasif Hussain Rizvi's case is concerned, comma, the Allahabad High Court was dealing specifically with the Allahabad High Court rules, comma, and the amendments to the Code of Civil Procedure effected in the state of Uttar Pradesh, comma, which are not applicable in the present case, comma, which pertains to Calcutta jurisdiction. Full stop. Next para. That apart, comma, the provisions of Order 19 in general indicate that in an affidavit, comma, it has to be clearly disclosed as to which portions of the averments are true to the knowledge of the deponent and which portions are true to their statement of belief or submissions, comma, which proposition was reiterated in Dalip Singh's case. Full stop. Next para. Even going by such standard, comma, the premise of the arguments of the appellant here is that the deponent of the affidavit supporting the writ petition from which the present appeal arises was 27 years old in the year 2023 and, comma, as such, comma, was a minor when the relevant germane incidents which were averred in the writ petition, comma, happened. Full stop. Next para. However, comma, per se, we do not find any reason to hold that the mere minority of a person at the relevant juncture in any manner vitiates his knowledge of such facts. Full stop. Next para, under the Contract Act, comma, to enter into a valid contract or to give consent, comma, a person has to be a major. Full stop. However, comma, such provisions do not debar a person from validly having knowledge of some fact which occurred during the period when he was minor and and does not prevent such person, comma, whence he acquires majority, comma, from standing by such knowledge and information by reiterating the same. Full stop. The acquisition of information or knowledge in any form by a person who is sufficient to acquire intelligent preference, comma, although a minor, comma, does not fall within the category of such minor giving consent or entering into a contract. Full stop. Next para. Thus, comma, per se, the minority of the deponent of the writ petition at the time of the relevant happenings averred in the writ petition does not take away anything from his having knowledge of the facts. Full stop. Since such knowledge has been stated to have been acquired on oath by affirming in the jurat portion of the affidavit that the relevant paragraphs are true to the knowledge of the deponent, comma, it is for the present appellant stroke respondent number 6 to rebut such fact of knowledge of the deponent by way of cogent evidence in the writ petition itself, comma, if necessary by filing affidavit in opposition or otherwise. Full stop. However, comma, on the face of it, comma, it cannot be said that the minority of the deponent hits at the maintainability of the writ petition itself merely because he stated that the events which happened during his minority are true to his knowledge. Full stop. Thus, comma, we are in complete agreement with the findings of the learned trial judge that the writ petition could not be held not maintainable at the threshold merely on such ground alone. Full stop. Next para. Insofar as the other grounds and objections taken by the appellant are concerned, comma, those have in any event, comma, been kept open by the learned single judge for being decided at the final hearing of the writ petition. Full stop. In fact, comma, the learned single judge observes that the second point of maintainability is set at rest, তারপর double inverted মধ্যে for the time being, double inverted clause, thereby indicating that it will be dealt with at the time of hearing of the writ petition. Full stop. In respect of the other objections to maintainability taken by the appellant before the writ court, comma, those have not been dealt with at all, and it is evident that those shall also be decided finally at the time of final hearing of the writ petition by the learned single judge. Full stop. Next para. Thus, comma, there is no scope of interference in the light of the above observations, comma, with the impugned order. Accordingly, accordingly, MAT 281 of 2025 and consequentially Can 1 of 2025 are dismissed on contest. Full stop. It is, comma, however, made clear that this court has not entered into the merits of the respective contentions of the parties in connection with the main writ petition, as well as the other issues of maintainability raised by the appellant before the learned single judge, and those will be kept open for being decided by the learned single judge at the final hearing of the writ petition along with the merits of the same. No address to cost. I hope cover your apprehensions.
I'm grateful, man.
We'll take a
Chin-up system.
Yes. কালকে নোটস গুলো কোথায় নোটস দিচ্ছিলাম কয়েকটা সেগুলো কোথায় গেল আচ্ছা yes please
It was my application for
Mr. Bosu, you can take your seat. No, Mr. Bose for you. So, yes.
application for substitution. The case was that there's a ticket tenancy which belonged to the partnership firm known as Khanna and Sons. Khanna and Sons. That Khanna and Sons claimed before ticket tenancy controller that this tenancy is a ticket tenancy and not TP Act. That application upon contest was dismissed, rejected by the ticket tenancy controller, holding that two grounds, that the land with structure was let out not to Khanna and Sons, but MB Khanna and Brothers. MB Khanna and Brothers. But land with structure, therefore, could not be. MB Khanna was not a ticket tenant. Second ground, in any event, MB Khanna's rights and Khanna and Sons are not related, had no connection. Therefore, whatever right may be, on these two grounds, rejected. Appeal was preferred before election. In the appeal, appellant are number one, Khanna and Sons. Number two, Arun Chandra Khanna. As a partner, Constitution says, as a partner. As a partner. Arun Chandra Khanna died.
Yes.
His heirs and legal representatives applied for substitution. In the petition for substitution, there is no averment that Arun Khanna had a personal right to sue. It's a partnership asset. There is not even averred the right to sue was of, if any, of Arun Chandra Khanna that was transmitted to his heirs or survived in favor of the heirs. No such allegation. Without considering that aspect of the matter, main criteria for substitution is condition that there must be a right to sue and that will survive the death. Some right to sue are personal and do not survive the death, defamation, etc. There is no finding that the right to sue was held by Arun Chandra Khanna in respect of this alleged ticket tenancy because it was claim of the partnership firm. Secondly, that it is not. Learned tribunal, it appears from the judgment, thought that this tenancy right is heritable and therefore substitution can be granted. But whose tenancy right? Partnership firm's tenancy right cannot be inherited by the partner or his partner's sons. Lordship last time wanted to see the deed of partnership, which I shown to your Lordship, and there is no averment or even holding of the tribunal that upon death of Arun Chandra Khanna, his heirs were admitted into partnership. And the clause 5 Lordship saw last time, it depends on the option of the surviving partner. This was the ground I challenged, may I hand over a list of dates? নিশ্চয়ই আমি জজকে দিয়ে তোমায় দেবো না আগে আগে জজকে দিয়ে তোমায় দেবো না আগে তোমায় দিয়ে জজকে দেবো এই সাহস আমার হবে এটা আরেকটা মাইন্ডার দুটো আরেকটা কপি লাগবে তো আরেকটা কপি দাও দিচ্ছি রে দিচ্ছি oh sorry my lord these are meant for judges copy have a thick paper and one is meant for my learned friend.
You can give him one of the thick papers and give us one of the thick papers.
He was raising
He's
kollol.
more eager than us to.
Yes. He was raising a kollol for not getting disturbed.
He's an era, Mr. Mitra. Don't forget that. Kolol is an era. Kolol Juk.
Is it so?
Yes.
Mr. I've given the page number also.
Yes, right.
Miscellaneous case number was initiated by Tika Control to decide the claim of recurrency of measures Khanna and Sons, that is unregistered firm, then comprising of Moonchand Khanna, names of both partners are given. Respective instance number 108, Dr. Lalmohan Bhattacharya wrote. Moonchand Khanna and Turunchand Khanna filed affidavit before the Tika Controller. Two of the partners filed, stating that Khanna and Sons was not a Tika tenant in the said premises. Then, Tika Controller by his order dismissed on the ground that said premises was not a Tika land. Said premises comprising of land with structures and factory had been let out to Messrs. M.C. Khanna and Brothers, not Khanna and Sons, by the then owner of the state property, namely Acharyas, Snehanshu Acharya's family. Manmohan Singh family.
Acha.
Manmohan Singh family. Raja Shishikant Acharya, from whom it had purchased the property, etc. Mrs. Khanna and Sons had no relation with M.C. Khanna. These are two findings of the learned appeal. Big OA number was filed against said order, was filed with a partnership, filed partnership of Mrs. Khanna and Sons, appellant number 1, and Urunchand Khanna, partner of said firm, as per appellant 2. The page 60 have given me, Lord.
Yes, you have
Remember,
given
appeal to get description.
This will be very helpful.
Khanna, not his personal capacity, as a partner.
Yes.
Moonchand Khanna, one of the partners of Khanna and Son, died. Urunchand Khanna, another partner of Khanna and Son, died, leaving Urunchand Khanna as a sole partner of Khanna and Sons. Then, fourth of waiting time, legal heirs of Urunchand Khanna, namely names are given, 3 sons, filed an application, MA number 983, for substitution of their names in place of Urunchand Khanna, which contains no averment, this is not that Urunchand Khanna was a Tika tenant or had any personal right to sue, or any right to sue was transmitted by him to his heirs. Page 137, the petition is at page 137, volume 1. At page 2 of the order, which is not the most objection part, there is a wrong recording that Premchand Khanna was inducted as a tenant on the bare land, which was nobody's case. And what that this has gone to the wrong place. But this comes to this last paragraph is of the order of the impugned order, not here. It should go under the impugned order.
Oh.
At page 2 of the order. Last page.
No, you have stated that. Page 2 of the order. You have stated that.
Can you see turn the page?
Yes.
Upon completion of affidavits, the substitution application being MA number was allowed, and the West Bengal Land Reform Tribunal directed, that is the land, that said heirs Urunchand Khanna to be substituted, to be substituted. There is no finding in the order that Urunchand Khanna had any personal right to sue, or that the partners of Urunchand Khanna and not the firm of Urunchand Khanna were the individually taken. Partners were not individually taken, that's the problem. Or that upon death of Urunchand Khanna, his heirs became the partners of Urunchand Khanna and Sons, and imputed a patience. I mean, then this last paragraph should come, because that unnecessary observation which affect the merits of the case. This is that the judge recorded that there is a wrong recording that Premchand Khanna was inducted. It's not a fact.
While hearing a substitution application.
This is merit. And second, dangerous thing, next thing, on a bare land, tenant on a bare land, Premchand Khanna, and which was nobody's case. And further, the temporary structure was constructed with alleged consent of the landlord, which was contributed. There is no fine. This should have been there at all. This is the position, my lord. And that this is the question that Order 22 Rule 3, that the There's so many judgments, but may I cite one judgment?
Order 22 Rule 3 does not apply here in the sense that the partnership firm is a juristic entity.
Yes.
So you have three
Application
grounds.
made under Order 22 Rule 3. Made under. For
Because
substitution.
let us say there is no provision actually. At best, it could have been Order 22 Rule 10 somehow.
Rule 10 don't
I
apply
mean,
in
because
case of
juristic
death.
person Order 22 Rule 3 does not apply at all. Because it's not a personal right to sue in any
That's
event.
it. Therefore, could not have been.
Not applicable. Plus, you say that the partnership firm itself came to an end because only Torun survived. So it could not have been a partnership firm at all then. And Orun was in the capacity of a partner. He had applied in the capacity of a partner.
Yes. And in his petition before ticketed controller, he claimed the firm was a tenant, ticket tenant.
Yes.
Not he personally.
And therefore, if that is so, then his heirs' personal capacity cannot come in.
Cannot come. This is the point.
Right. And there is no averment that in the partnership deed there was any provision for induction.
Automatic
Induction. And that option was given, but no averment in the substitution application that option was exercised and they were inducted. So therefore, they do not come in from any perspective.
That was my humble submission. The judgment not if there is settlement in court that a partner has no right, specific right, respect to a partnership firm. The right is 1960 Supreme Court 1300. The right is to, upon dissolution of the firm, get all the assets sold.
Money.
That is then surplus. That is why, my lord, even immovable property of partnership firm is treated as movable. That is the
right.
His judgment, if I had once I brought it, I had one.
Please.
You to copy the paragraph number 2. Paragraph number 2. And you may not come to page 4. It's SCC online, reported in 19 AR 96 Supreme Court, page 1300. But it came. Maybe. Okay, একটা কপি দাও কল্লোলকে দাও দেওয়া দরকার নেই স্যার দাও রে না কল্লোল তুলেছো তো সবসময় কল্লোল তুলে যাচ্ছে
Mr. Basu, you should use your device to look into it. Why are you taking a copy?
I have. Kollol is, but I don't think it's raising Kollol. Raising Kollol. He's proved to be a Sarthok Nama by being Kollol.
This what should we not do, Mr. Bose? You were saying something?
8
Won't elaborate on that.
দিয়েছে কার got extra কোনটা এই না নে Look, can you turn to my page? I have marked that copy. Thank you. Paragraph 4 is long paragraph. Can you turn the page? Come to the continuation of paragraph 4. Section 48 is set up.
Yes, section 48.
That partnership act set up. Then paragraph. From the perusal of these provisions, it would be abundantly clear that whatever may be the character of the property which is brought in by the partners when the partnership firm is formed, or which may be acquired in the course of the business of the partnership firm, the property of the firm and what a partner is entitled to is his share of profits, if any, accruing to the partnership firm from the realization of the property, and upon dissolution of the partnership, to a share in the money representing the value of the property. No doubt, since a firm has no legal existence, the partnership property will vest in all the partners, and in that sense, every partner has an interest in the property of the partnership. During the subsistence of the partnership, however, no partner can deal with any portion of the property as his own, nor can he assign his interest in a specific item of the partnership property. His right is to obtain such profits, if any, as fall to his share from time to time, and upon the dissolution of the firm, to a share of the asset of the firm, which remain satisfying, etc. Is quoted from Lindley and Partnership. What is meant by the share of a partner is his proportion of his partnership assets after they have been They have been all money. They have
All
been
should be all.
realized and converted into money. And all the property partnership dates or liabilities have been paid and discharged. This it is, and this only which on the death of a partner passes to his representative or to a legatee of his shares, and which on the bankruptcy passes to his trustees. Then the statement given and goes on. Please also come to paragraph 7, Milord.
Yes.
Again, Supreme Court ratio, it seems to us that looking at to the scheme of the Indian Act, no other view can really be taken. The whole concept of partnership is to embark upon a joint venture, and for that purpose to bring in as capital money or even property, including immutable property. Once that is done, whatever is brought in would cease to be the trading asset of the person who brought it in. It would be the trading asset of the partnership, in which partners would have interest in proportion to the shares in the joint venture of the business or partnership. The person who brought in would therefore not be able to claim or exercise any exclusive right over any property, which he has brought in, much less over any other partnership property. He would then would not be able to exercise his right, even to the extent of his share in the business of the partnership. As already stated, his right during the subsistence of the partnership is to get the share of profit from time to time, as may be agreed upon among the partners, and after dissolution of the partnership, with the retirement from the partnership of the value of the share in the net partnership assets as on the date of dissolution or retirement of the reduction of liabilities and property liabilities. This was healthy beginning, my lord. Supreme Court, in this case, without considering this judgment, say Indian law is different. We are becoming independent. 1963, is the Indian law. Lindley is not fully accepted.
No, we are seeing that. And that view was also changed in the subsequent editions of Lindley itself, apparently.
Our Partnership Act is there.
That is comprehensive.
In fact, those days acts were drafted better, and the Indian Contract Act was better than English contract law. Must everybody admits that. Drafted by Mr. Pollock, Indian Contract Act. Those acts, Transfer Property Act, Civil Procedure Code.
Wherever the subsequent amendments have come in, there are some chinks.
One or two amendments after 50 years or so, 120 amendment. So Rajbihari goes drafted CPC. This is when those draftings are better. Arbitration Act 1940 was drafted by NN Sarkar. But here the English.
The new act is absolutely almost a copy paste of the ancestral model law.
Yes.
Almost a copy paste minus some provisions.
They had the advantage of English law, that the copy paste more or less. But this Arbitration Act, they should have waited for another 6 months. English Arbitration Act came after 6 months. If they waited for 6 months, copy paste thing would have better.
Right. Absolutely. That's why the amendments, Mr.
So many amendments. No. But Securities Act is not transferable or sellable.
No.
Apart from that, the section itself. Section 5. Section 81 section clearly says.
And this dispute regarding ticker tenancy absolutely pertains to the immovable property. And for which you have cited this judgment also. It does not translate into right of immovable property. That is all. Yes.
My learned senior friend Millard started Millard.
Was requesting me to make this.
Yes, Millard. I because I could not hear Millard on the last day because of the network issue. That is why
I requested him to repeat.
Yes. Millard, my learned senior friend Millard, in his list of dates Millard started Millard the journey of this legal battle on and from Millard 2013. Millard, may I Millard
Journey of this legal battle.
Yes,
Right.
not the Korean combat. I mean, 2013, he started from this. But 46-47 is a year when my predecessor in interest, my grandfather, that is the respondent, my lord, they were inducted as a tenant, my lord, in respect of a bare land, by I'm telling 46-47. 47-48.
Predecessor means?
My grandfather, the respondent herein.
Yes, that one correction. I started from number 13 because he had a concern with the question of substitution in an appeal court.
No, because this journey is required, my lord, why I tell you, lord.
Make the journey short.
No, only, my lord, only five or six.
Again,
years.
grandfather.
No, grandfather inducted as a in the bare land because my learned senior friend said that
Is that to be decided in the main matter?
No, kindly see. The 46-47, my lord.
Your grandfather means whose grandfather?
That is the applicant before the tribunal, my lord. My father was a partner.
That is the father of Arun Chandra.
Yes, my lord, I am the. But my grandfather was a MC Khanna and sons, brothers. That was the first tenant, proprietorship concern.
How could the farm be your grandfather?
No, proprietorship farm Khanna. Premchandra Khanna was my grandfather. Premchandra Khanna, my lord, had 3 sons. Although, my lord, it was described as MC Khanna and brothers, no brother of MC Khanna, Premchandra Khanna, that is my grandfather, my lord, was, my lord, there was no partnership farm. MC Khanna and brothers was a proprietorship concern. MC Khanna was inducted in respect of a vacant land, my lord, in the year 47-48. Am I clear, my lord? MC
No,
Khanna.
because Premchandra Khanna, how did he become MC?
No, that is why, my lord, the name, my lord, it creates confusion. MC Khanna is his elder brother. MC Khanna and brothers were the name of the, my lord, proprietorship concern. MC Khanna had no connection in any manner.
MC Khanna and brothers was a proprietorship?
Proprietorship.
Who was the proprietor?
My lord, Premchandra Khanna, that is my grandfather.
He was the only sole proprietor?
Only sole proprietor.
Of MC Khanna and brothers?
Yes, that is the name, my lord.
Very good.
But
Yes.
that is there when I cannot travel beyond the records.
No,
my lord. 47-48 in respect of bare land. My lord, in 64, my lord, my learned senior friend's client's predecessor in interest, my lord, had filed a suit for eviction against my client, describing the land, my lord, as a bare land. My lord, why I am putting emphasis on this, my lord, that this admission with regard to the nature and character of the land, my lord, as a bare land, my lord, because I am armed with a decision which I can.
Are these German at the substitution
German, my lord,
stage?
because I tell you, your lordship, because
we are not here deciding the final.
No, 74.
This is not a final adjudication.
The firm was constituted, my lord, from proprietorship to partnership in 74. My lord, we have filed a suit, my lord, in 87, and the suit was decreed expiry, declaring me as a Thika tenant. Kindly, my lord, takes.
You filed the suit in
87. 87.
Filed what? This application?
Filed a suit for declaring me as a Thika tenant, my lord, and I was declared as a Thika tenant.
By the civil court.
At that point of time, my lord, the civil court had jurisdiction, my lord, to declare. Now, my lord, from 1st November.
When were you declared? When was the decree passed?
88. Suit filed. 8/7/1987. Ex-party decree. State of West Bengal was one of the respondents. My lord, 8/7/87, the decree was passed.
Declaring whom to be the Thika tenant?
That is the Premchand Khanna. And
Premchand Khanna or MC Khanna?
And sons. MC Khanna and sons were the lawful Thika tenant. Premchandra Khanna and Messrs Khanna. Premchandra Khanna and Messrs Khanna were declared as Thika tenant under, my lord, the state of West Bengal.
Both Premchandra Khanna and Messrs Khanna?
Yes, that was the.
And MC Khanna?
Yes, my lord, the suit namely.
Messrs Khanna or MC Khanna?
Declaring that the plaintiff.
Sir, both, please go one by one. You said MC Khanna. MC or Messrs?
This is no. In MC Khanna was a brother. MC Khanna and brothers.
You formed a partnership in 1974.
87 filed a suit. The suit was filed, beloved.
Who filed the suit?
Premchandra Khanna and Messrs Khanna and Sons. Messrs Khanna and Sons was the new partnership firm, which was, beloved, converted from proprietorship to partnership.
Messrs Khanna and Sons.
Yes, beloved, they were declared as Thika tenant.
How could both be Thika tenants?
That is the I cannot. That is the decree. I have not 80. 20.
Decree was set aside.
I am coming. I have not completed my journey, Millard.
Your journey you have not completed, but your journey will go on for.
No, Millard. 2014, Millard.
Is it an international journey or a national journey or local? Make it within the state.
2014, Millard, the decree was recalled. Millard, we filed Order 9, Rule 13 was allowed. Millard, kindly, Millard, have the charity to consider that 1/11/2010,
It's not a charity. We beg to differ.
Section
No,
5.
first we have to clarify this point.
Section 5.
But it's a question of charity by a constitutional authority.
No, consider, my lord, I said. Charity to
Where does the question of charity come? We have serious objection to this. First, to clarify your.
My lord, I borrowed this term from my lord of the bench Justice Krishna. We have
Justice Krishna.
This is not an original expression, my lord. And
we wanted to elicit the
attributable.
We wanted to elicit the source.
Yes.
That's why. Anyway,
only one thing. Look, section 5, subsection 1.
That ordinance rule 13 allowed your degree was recalled. So nothing remains in that.
1/11/10 to 2010. On that date. 1/11/2010. Section 5, subsection 1. The amendment brought about and the jurisdiction of the civil court. That was taken away. The Thika controller had. So the Order 9 Rule 13 that was filed way back in 2014, March after 2010, the Civil Code entertained Order 9 Rule 13.
2024 or 2014?
2014. Order 9 Rule 13 was filed by them. Because they suffered a...
Wasn't there a saving clause, I mean, in the amendment?
The saving clause in the amendment, obviously, all actions. That
yes.
There.
Pending suit was saved.
Yes. Saving clause in the Thika Tenancy Act. That
right.
Yes. All actions, that is.
So therefore, 2014, that application.
No, I am saying, that they filed. Question is,
you took a chance.
No,
failed.
Today,
take some other.
Now, thereafter, what happened? 2013, they filed the writ petition, questioning the mutation that was granted in favor of the.
1 second, what happened to that suit after Order Rule 13 being allowed? That is still open. Still pending.
No. That we filed an appeal which is not mentionable before the district Alipur, because Order 9 Rule 13 was
after the expiry degree was set aside, the suit is pending.
No, yes,
suit is pending. After
that is my instruction. Now,
that may not be correct also. What do you mean by that is your instruction?
Yes,
you take responsibility for what you.
That is the suit. We filed an appeal which is not a correct provision of law. We should have filed revision.
Forget that. The suit is pending. Yes.
Yes. Now, 2013, they filed a writ petition questioning the mutation that was granted in favor of my clients. It is their interest. High Court set aside the order and directed them. They initiated a proceeding under Section 5(3) of the Thika Tenancy Act before the Thika controller. Now, my respectful submission, your lordship kindly takes note that Thika tenancy, even if there is no claim, the land can be vested, yes, the land can be vested, even if there is no claim. Because, if it is proved under Section 4 of the Thika Tenancy Act that the bare land was, taken on rent and I am the structure of the owner, then, the vesting is German, because my learned, my learned senior friend says that after the farm that stood dissolved, and we have no right, right to sue survives, according to me. Why? Mr. Mitra, my learned senior friend says partnership is not a juristic person, even if it is a registered partnership firm and or unregistered. That is the law.
He doesn't say exactly that. He says the reverse. He says that it's not a personal right of Arun which survives.
The personal right of the
because Arun sued in the capacity of one of the partners.
Even if
on his demise, what happens? What will be the effect? How does his personal heirs come in?
Now, because the Thika tenancy, the claim which is German and alive, that Thika tenancy is a heritable right. Number one. Thika tenancy partnership.
Heritable that the partnership firm was the
partner cannot. Partner is not a partnership firm is not a juristic person, and the property of the partnership firm, that is my right. Kindly see my learned senior friends' reliance upon the judgment 66 SSC online, page 6, the paragraph 4 and subclause 22. This is my humble attempt, subject to what my lord will say. 5 subsection 5.
You say partnership. Let us be clear on your subject.
Partnership firm is not a juristic person. Number one. Thika tenancy is a heritable right under Section 5, subsection 3.
So it is heritable by the heirs, individual heirs of the individual partners.
Individual partners. Number 2. Number 3, the 1966 SCC, page 6, clause paragraph 5. Kindly see paragraph 5.
Yes.
And Sir I may read for my lord. Sir W. Grant, so decided in such and such case, we have quoted extensively from this decision because of the argument that the decision in such and such would have been otherwise but for Section 220 of the English Act. Adverting to this, Lindley has said, I am skipping over 22 next. where land or any heritable interest therein has become partnership property, it shall, unless the contrary intention appears, be treated as between the partners, including the representative of the deceased partners, and also as between the heirs of a deceased partner and his executors, administrators as personal or movable and not real heritable estate. So, my lord, I said if the partnership firm is not a juristic person as laid down, my lord, by the High Court, and my lord, I will also show, my lord, other judgments.
Let's go slow. Please read this again. I could not follow. Where land
or any heritable interest. I said Thika tenancy is a heritable interest.
Okay.
Therein has become the partnership property. If partnership is a tenant, then the property belongs to partners. Unless the contrary intention appears, be treated as between the partners, including including the representative of a deceased partner and also as between the heirs of a deceased partner and his executors, administrators as personal or movable and not real or heritable estate. I say that a non-juristic person.
No, Thika tenancy is heritable but
Absolutely.
not transferable.
Not transferable but portable.
Therefore,
Yes.
this is heritable. So
Is
you say-
heritable.
All
If
right.
it is heritable, a non-juristic person, my lord, that is absolutely.
So you say this is a heritable interest.
Heritable interest. That interest.
Even if of the partnership firm, then by legal fiction, they are the heirs of the
Yes.
partners.
Otherwise, my right has already been crystallized, my lord. Otherwise, my lord, it takes us nowhere. And law, my lord, creates uncertainty, which is not permissible, desirable. So, my lord, that is my understanding of the situation. Number one. Number two, that I am not required to make any averment, my lord, about my right. The facts are essential because law cannot be pleaded. My lord, when the court comes to a conclusion that right to sue survives, it is a question finding on law, not on fact. Law, my lord, fits into the fact. So, my lord, my right, it's a claim. The duty to consider of the court, I raise the dispute. I place the facts. The duty of the court is to decide all dispute raised before it. Now, my lord, the court had decided from the facts. So it is not required that my right to sue survives. The moment I say my right to sue survives, it's a legal claim. It's a legal claim, and I claim jural relationship.
You mean to say just because you file an application for substitution?
I say, my lord, my
court has to
substitution,
substitute you.
my substitution, if I say, because my heirship of my lord Prem Khanna, MC Khanna, my lord, that are not disputed. I said, my lord, the land, I am not separated from the land. So it is immaterial for the court to, my lord, look into the pleading whether I have made a specific pleading that my right to sue survives. I said I am the heirs and I can take part in this judicial proceeding.
So the concept which you are projecting, Mr. Bose, if you understood you correctly, is that the Thika tenancy is a heritable interest of the partnership firm, and by legal fiction, as per this paragraph 22, it devolves on by inheritance on the heirs of the partners also.
Yes.
So by virtue of that, you claim to be
Otherwise, my lord, whether I am justified in placing this submission before your lordship, a non-juristic person cannot be tenant under the eye of law. If that is so, my lord, then what is the consequence or ramification of my existence in the partnership business as well as in the land?
That is a different proposition.
I
a
said
juristic person and a biological person.
Yes, I'm a biological person.
Both can become Thika tenants.
I said I put.
Suppose it was a company. If it was a company, it's a juristic
then
person.
the question will be different. But if it is a partnership firm, even if
Concept is different.
Concept is different. The partnership firm, it cannot be a juristic person under any circumstances. Yes. So, my lord, today my claim about Thika tenancy, my lord, kindly, my lord, consider these aspects. I am claiming this right from a statute, not a common law right. If it is statutory right, then, my lord, the enforcement of such right in this curial combat, my lord, is not a teasing illusion.
This curial combat.
Court curial.
Combat as in battle. Yes.
Oh, my lord, I will forget everything. My lord, if your lordship does. My lord, I am the humble adversary, my lord, against the leading light of the bar, my lord. I have to withstand the storm, my lord. I am feeling nervous and also, my lord. Sir, আপনার মেধার আলোয় আমি চলে যাচ্ছি. Kindly sees that the judge.
Love to see curial combats.
No, my lord, absolutely.
Not every day a counsel uses this expression. That's why we are just admiring your legal acumen.
No, my lord. Whether it is stupendously relevant or not, I do not know.
Stupendous is a bit out of context, but
all right, my lord.
We can take part of stupendous.
Part of stupendous. Now, my lord, the question is today that whatever my learned senior friend says, my lord, that
is wrong.
I cannot be ousted from this consideration.
Understood. So,
my lord, Then first part, heritable interest. Second part, partnership firm is not a juristic person. I am the biological person. My right to survive, I cannot be alienated from my right. And with a thicker tendency, ultimately it speaks about with the law of eminent domain. The land stood vested. Ultimately, if it says, because he has purchased this land in the year March 1996, after the promulgation of the Thika Act. So that means ultimately, if I survive on my claim in the tribunal or the apex court of the country, my lord, then, my lord, his deed will be set aside. Now, today, he cannot say that I have no right, I have been alienated.
When did he purchase?
1996, subject to correction. March 1996. আপনি কিনেছেন জমিটা স্যার মানে আপনি না মুখ্যেল হ্যাঁ স্যার 20th March 1996. On that date, my lord, if the land stood vested, ultimately court finds, ultimately, then, my lord, his
not
deed
transferable.
goes. Not transferable. Land belongs to state. So, my lord, this is a claim not against the private individual, the purchaser. He wants to survive because he wants to protect his deed. And on the date when it is purchased, ultimately, if court finds that it is a property vested with the state, he has no right title interest in the property. So, today, it is immaterial, my lord. Now, why section 69, 2 and 3, he said, my lord, that it is irrelevant. It is relevant because I'm enforcing, my lord, my right, statutory right, claiming. Why?
It's an unregistered partnership firm.
Huh?
Unregistered partnership.
Unregistered.
Unless it pertains to dissolution under 3.
Dissolution is a distribution of every property of the partnership.
This is not a legal action for dissolution.
No.
So 69(3) is not
applicable.
attractive.
No, I said 69(2) does not create any bar in enforcing my salutary right or common law right.
Partnership firm, can it maintain a legal action?
The question is, order
unless it's registered.
The law says subject to correction, although,
what does the law say?
That is, 89 Supreme Court, 89 partner. It is, that is my humble understanding, my lord. AIR 1989, SCC online, partner 135, corresponding to AIR 1990 partner. আমি আপনাকে দিচ্ছি এটা
AIR 1990 partner page
95. এটা জজ সাহেবকে দিন তো আর এই নাও page 40, paragraph 46, তাই না 46 না বার কর 46 to 46, 47, 38. May I read for my lords?
Para 46.
Para 46.
Yes.
Milord, the partnership firm, milord, filed a milord, the eviction suit. Right to file a suit.
This was an unregistered firm.
Yes. The right to file a suit for eviction vested in a landlord is not a contractual right, and such right, by necessary implication, arises in terms of the provision of the said act. Further, it is well known that a partnership firm, whether registered or under, is not a juristic person. Whether registered under the Indian Partnership Act or not is not a juristic person. It is further well known that a suit filed by the partners along with the partner does not attract the provisions of Order 30 Rule 1 of the Code. In Bharat such and such upon which the learned counsel for the petitioner himself has placed reliance, it has clearly been held that the firm has no legal entity and it is a collective term for the partners who have entered into the partnership with one another. Similar is view taken in such and such, AIR 74 Allahabad, Hasbury's Laws of England, 4th edition, volume 34. In such and such, it has been taken, firm name is not the name of a corporation, but the short names of the partner themselves. In this connection, reference may be made to Lindley on such and such edition, where the learned author stated the law of that partnership is called a collective law that.
But Lindley has been deviated from by the Supreme Court in the judgment cited by Mr. Mitra.
Yes, I will come, Milord, that other judgment, Milord, so that the cloud of confusion can be eradicated, Milord, by subsequent judgment.
Can be? No, please repeat it.
No.
Cloud of confusion can be? We didn't hear you.
No,
we beg your pardon, Mr.
Kindly, Milord.
Cloud of pardon, what happened to the cloud of
it should be removed or eradicated.
Eradicate.
Hear you from. I will forget the points I have.
You won't forget anything.
Your Lordship's brother is.
Let us proceed after eradication of your.
Yes. Milord, firm name in this connection, reference may also be made to section 4 of the Indian Partnership Act, which reads as follows. Definition of partnership, partner form and form name. Partnership is a relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. Persons who have entered into a partnership with one another are called individually partners and collectively a firm, and the name under which their business is carried on is called the firm name.
So it's the persons who are collectively called a firm.
Firm.
So they remain persons.
They remains person. So, my lord, my existence cannot be, my lord, overlooked, ignored. Now, my lord, and my lord, 51, in view of this matter, in my opinion, there is no doubt that a partnership firm is not a juristic person, and conceptually, it is different from an incorporated company. Only in a case of a limited partnership as envisioned and such, England such and such. Then, my lord, in such and such, the Madras High Court proceeded on that basis that the premises in question was owned by an unregistered fund. In the said case, the suit was dismissed in plain account that two persons who are the partners were not carrying on any business not required. So, my lord, today, I survive on this score that my right cannot be ignored because I have legally also the partner. And my lord, 69.2, 69.3, the interpretation of the Supreme Court. Hold ওটা কি দেখালাম তো অডিও লাস্ট হলদিরাম ছাড়া আরেকটা দেখালাম না আরেকটা বললাম না হলদিরামটা this is reported in 2000 volume 3 SCC page 250 জজ সাহেবদের দিয়ে দিন না স্যারকে দিন হ্যাঁ 250 স্যার 250 250 Para 9. Holdiram, sir. The question, may I read, Miller? Paragraph 9, page 257. Sorry, Miller.
Yes, para 9.
Para 9. The question whether 69.2 is a bar to a suit filed by an unregistered firm, even if a salutary right is being enforced, even if only the common law right is being enforced, came up directly for consideration in such and such case. In that case, Majumdar J, speaking for the bench, clearly expressed the view that Section 69.2 cannot bar the enforcement by of a suit by an unregistered firm in respect of a salutary right or a common law right. So, Millard, on the facts of the case, it was held the right to evict a tenant upon expiry of the lease was not a right from arising of a contract, but a common law right or a salutary right under the TP Act. The fact that the plaintiff in that case referred to a lease and to expiry made no difference. Hence, the said suit was held not barred. It appears to us in that the case reference to such and such was obviously treated as historical fact. Then, I am not on. Millard, today, my respectful submission before your lordship, Millard, that if I say that the land stood vested by operation of law, partnership act with you.
Yes, please continue.
If the law says, Millard, on and from the date of promulgation of the Thika Tenancy Act 1981, if the land stood vested automatically by operation of law, then, Millard, I am enforcing a right from my right in the property, and state, Millard, becomes my protector because I am a tenant under a state. Unless this right is adjudicated and crystallized, Millard, the existence of my clients, Millard, in the land as a legal heirs of the partners, Millard, that cannot be, Millard, ignored, and and they cannot shut the door, Millard, because it is an enforceable of my right. I'm execution, and your lordship, Millard, whether I am entitled, Millard, or right or justified, Millard, in making this submission before the highest court of the state, that, Millard, whenever a writ petition before your lordship, Millard, we are seeking basically an execution of constitutional resolution.
And the bar under Section 69 is no suit to enforce a right arising from a contract or conferred by this act. This is neither. This is under the Thika Tenancy Act. It's a statutory right under the Thika Tenancy Act.
So I am protected, I'm saying. So any submission, if my all other points,
that is on a slightly tangential point, whether this application is maintainable by you.
No, question is, Millard, if my right to sue survives, this right, Millard, must be, Millard, derived from the attendant circumstances.
No, undoubtedly, but that would hit the maintainability of your main application before the.
Yes, but if your lordship shuts my door today, that my right to sue, that is a gateway, because I cannot be, Millard, prevented by a person, Millard, whose very existence in the land is questioned, because if I survive at the end of the day, his deed will be cancelled. Because I am claiming, the moment I say, Millard, I am a Thika tenant, obviously, Millard, I am claiming tenancy, Millard, under the state. Now, your lordship knows possibly 192 of the KMC Act, Millard, it says, the moment I become a Thika's tenant, the land owned by the state, and I become the owner of the structure. Milord, yes. Now, Milord, 1949 Thika tenancy, it was repealed in 81 without any clause. 81, Milord, they have a saving and reaping clause, which your lordship said. 2001 also there. Now, Milord, the ultimately, Milord, the absence of a specific pleading, I have a right. It's a mere submission in the writ petition like a ground. The court will derive my right, form its opinion about my rights.
Court cannot go beyond your pleadings to find out your rights.
No,
But even if your application, you say that in your application, if you have stated that you are the heirs of that person, that is
undisputed, that is suffice. I said no further.
No, they are not exactly disputing that you are heirs. I mean, at this stage,
Yes,
at least.
absolutely.
So, if that be so, that averment should be sufficient in law.
In law.
Because of para 22 of the other judgment, and
Yes.
this judgment is on a different point.
Because my learned senior friend has never submitted before your lordship on the last day and also today that we are not the heirs. He said, my learned senior friend said that there is no averment that my right to sue survive. The court, Milord, out of it, the tribunal, Milord, said something, Milord, which was not in the pleading. I said it is not required. Because right to sue, Milord, absolutely
flows from your heirship of the person.
Because it is not disputed. Today, Milord, this is a judgment. Milord, 2022, volume 13 SCC, page 772. 2022, volume 13 SCC, page 772. Sir, it up. ভয় স্যার দেখাচ্ছি ভয় আপনি আছেন স্যার কি করবো নার্ভাস হয়ে যাই স্যার শেখাও হয় 783 পেজ মিলট 783 না প্যারাগ্রাফ না 16 থেকে 25 60 স্যার 16 থেকে 25
No, this is on the same point.
Yes.
Not a bar for statutory or common law right.
Yes.
We agree with you on that. But the present question which has arisen is not on this.
No, I said, Milord, that 69.3 on the last day, Milord, that applicability cannot come because the tribunal has decided on wrong premise of law. I said, Milord, all points, even if, Milord, are
by the impugned tribunal only decided the substitution application.
Substitution application, if I am heir, if you were the heirs of
that is sufficient, but that is on the other proposition on that paragraph.
I'm saying, Milord, possibly if I have correctly understood his mind, Milord,
Milord, Mr. Yes.
He sought to improve.
No, we are seeking clarifications where we are.
No. Your lordships need not clarification.
But there is some curial obscurity. We are seeking your clarification. Yes.
Milord, I said that
you said stopped at if you have understand Mr. Mitro's mind correctly.
I understood that the reference to section 969 2 and 3, these are all irrelevant because the court or tribunal ought not to have asked this question. So, Milord, without entering into the other merits, because it is yet to be adjudicated. But substitution, Milord, that is, Milord, misconceived application. More particularly, only on the one
substitution is misconceived.
No, this application
challenge to the substitution.
Yes, challenge to the substitution. So the absence of averment, Milord, does not alter, Milord, the position of law.
Thank you.
Milord, may I take my lord's please?
No.
Court number 7.
No.
Milord, a student's matter, Milord.
We are all students of yours.
Milord, kindly.
So this is also a student's matter. Yes, Mr. Bose, please.
I'm sorry.
Yes.
With respect, is argument contrary to records. Can they come to page 37, volume 1? What is their case before the controller? That cannot be changed now. About judgment about page 37. This is return their file. On the basis of which page 40, can you see this? Now, clause 1, name of Thika tenant.
Yes.
Who are they? See, MC Khanna, PC Khanna, AC Khanna, SN Khanna, as per registered deed of partnership of the, as partners of Khanna and Sons, MC Khanna and Sons, Messrs. Khanna and Sons.
So this says registered deed, they are registered or unregistered?
It's a
deed is registered, my lord, but it is
Deed
not-
is registered.
it
As
is
per
not
registered
registered
right,
as 60.
Yes.
not the farm.
So
Right.
they're as per the partners of Khanna and Sons, not
No.
not the farm. See, we not kindly have the judgment, page 40. In fact recorded, return of say MC Khanna, etc., as a partner of Khanna and Sons, has filed this return. However, say MC Khanna itself, along with Torunjana Khanna, both alleged partners, they to withdraw the claim. So that is different thing. Now let's see the all history and geography apart. Please come to page 2, the last two paragraphs, just before last two paragraphs.
This is the order of the Tika controller.
Applicant
That is under
averse,
challenge before-
MC Khanna and brothers were inducted as a tenant. That is their case. It's a tenant. These then permission and such. And by Shitangshu Kanto Acharya, brother of the patient, that is the case. Now, argument is something is not four partners or individual partners or partners or not. That is their case.
Mr. Bose has argued that partnership firm is not a juristic entity as such.
That's right.
So it's a collective name given to its partners.
Partners,
So
right.
it's the partners who have a right to sue. Then why shouldn't it be construed that it should the right to sue of one of the partners survives on his heirs also?
No. This is the argument. Partnership firm is not a juristic entity. It's a compendium name of
the partners. That is settled. That is law. But why should then?
What is the right of a partner in respect of a partnership, alleged partnership property? Supreme Court says no partner has a right to a particular property because partnership, this body is a fluctuating body. Today is a partner, tomorrow another partner may come. So at that time, when the right, who was the partners, they have no right to any specific property. They have right, and read about the paragraph, when the partnership firm is dissolved, the right to get all assets sold, all parts sold, and get the distribution of surplus. No right to any specific property when the partner of a partnership firm. A partner member cannot say today I am 1/4 owner of this property, assuming it's a partnership. Or partnership firm owner of a property A. A partnership firm can he file a full partition, saying that no, I am 1/4 share. Give me. So therefore, question is when a claim is made, the tenancy belong to a partnership firm. That's their case. Now, arguments are contrary. Argument, there is no case that the partners were in their or the partners were the tenant. That just case is not arguable now. But I have not gone into the merits of the case. Merits of the case will gone into whether the firm is like 69, etc. I have not gone into that question. That we decided.
That is
different
rather a
thing.
bit.
My question is when a partner had I may submission unnecessarily made himself also a party. Unnecessarily, anyway. When he dies, there's and a partnership property. Let us put it partnership property. Partners have been given the right to file suit because they no juristic person, right to file a suit under Order 30. That is our right. They have filed suit. I'm not saying the suit, no, suit is not maintainable, a claim is not maintainable. Has they given the right to sue in the partnership name Order 30? So that is recognized by the legislator also. And he cannot say that my father was owner of 1/4 share of this property. There was a several property. That's why.
May we have the liberty to file a short written notes?
But
They filed only a little list of dates.
Written notes will
By tomorrow, can you file?
tomorrow.
File?
Written notes,
Not necessary. This is the plinth of your argument on the basis of these judgments, basically.
And I have
Particularly
questioned
paragraph.
the tenancy order Miller before the tribunal.
And the learned friend said that my client purchased the property on the basis. That is different
So
thing.
that is on the merits of
That
it.
is no, that's different.
No,
He said it was the journey, the legal journey which he wanted to
No,
narrate.
when proceed on the basis of judgment of a Tika controller, which is not state or
It is under challenge.
that's challenge it, but facts Facts are not.
That is yet to be decided. If your lordship, suppose if my learned senior friend.
Sorry, I made a mistake, my lord.
Sorry.
I am saying what was the case before the Tika controller, because the original truth, they cannot deviate from that and make a contrary argument here. The case was the tendency of a partnership firm.
Yes.
But therefore, now arguments were all each partners was a partner, and that is not.
The hearing is concluded. Judgment is reserved in the matter. Thank you.
Deeply obliged.
You want to say something, sir?
Before your
No, Mr.
lordship's rise, the next matter is mine. I'll not be here after lunch. If it's
You are on the other side.
I wouldn't have opposed it, my lord. My factory is shut for 2 years. But can it then appear?
Whatever.
Can it appear day after at the top of the list?
Yes, yes.
Can it appear day after at the?
So it will retain its position. So what is we cannot upgrade it, but
day
it's
after-
fairly up in the list.
Day after, my lord.
Not tomorrow.
Tomorrow, I think.
not here, my lord. I'm traveling out today, my lord.
No. Now that has gone.
That's good. Well, day after, my lord. If it can.
Yes, yes. It will. If Mr. Bachauth has some problem tomorrow, today and tomorrow, then we'll keep it day after tomorrow, obviously.
Obliged.
Then it's all. তাহলে একটা call করে একবার একটা next matter 20. You are for the respondent.
Lord, I'm for the respondent. in the
Plaintiff respondent, I am for the defendant.
On the prayer of learned senior counsel appearing for the plaintiff respondent, comma, since the matter cannot be taken before the recess due to paucity of time, comma, let the matter stand adjourned till August 14, 2025.
Let it retain its position.
Cannot say, Mr. Bhattacharya, but its comparative position will remain the same under the same heading. Sometimes matters come above also to be mentioned in other matters. So ইয়ে অনিন্দিতা বলছি কয়েকটা না পাঠাবে ডিপার্টমেন্ট থেকে ফার্স্ট মেনশন
My lord, 21 for appellant Mr. Shaunak Bhattacharya is appearing.
Pardon? Use the microphone, yes.
My lord, for appellant Mr. Shaunak Bhattacharya is appearing. My lord, I'm praying for a day's accommodation.
Why?
My lord, he's on his legs in court number 14.
Start the matter.
That he has completed the argument.
No, no,
right?
my lord, no, no, he has not. He has not completed. He will argue, my lord. Or my lord, kindly make it a passover. My lord, kindly pass
No,
it
no,
over.
he was heard on the prayer of learned counsel for the respondent. It was adjourned
Lord, this was the issue was
because
that
no paper book was served on it.
the paper book was done. Lord, this was a short issue. Lord, the plaintiff filed a suit for recovery of possession under the West Bengal Premises Tenancy.
Yes.
Lord, admittedly, we did not file any application under 7.1 and 7.2.
Huh.
Lord, my learned friend has stated that automatically 7.3 comes into play. Lord, my specific defense was that it was a Thika property. Lordship, sir, under earlier occasion, Lord, was pleased to
Defense was struck out.
defense was struck out.
Whether we could take this point.
Lord, this defense was struck out at the time of delivery, at the time of passing of the final judgment. No independent application was filed because the learned court below as well as the first appellate court, Lord, both had considered the landlord-tenant relationship as well as the maintainability of the suit first. Thereafter, Lord, the learned court.
So you would mean to say that if the Thika tenancy, this objection was held in your favor, there would not arise any question of applicability of section 7.
Lordship.
So it's interrelated.
Lordship.
So
I have also carrying the division bench
therefore it's
judgment.
not the other way around.
Lordship.
He's tried to say it's the other way around. Defense struck out. You cannot take this point.
Lordship.
You say if you take this point, this is upheld, then no defense strike out.
Lordship. Now, I am on the issue of the not the landlord-tenant relationship, the existence of landlord-tenant relationship. That this is very vital. Lord,
Achha.
because at the point of time when the eviction suit was pending, when prior to that a parallel proceeding before the trigger controller was going on. Lord, since there is no judgment passed by the trigger.
No, but even if you are a bharati under the Thika tenant, you are governed by that, then the civil court does not have jurisdiction.
Civil court does not have the jurisdiction. Lord, ultimately, when the matter came before the first appellate court, Lord, first appellate court was the opinion that there will be a judicial chaos. So in that event, I am remanding the matter subject to the decision of the Thika controller. In the meantime, the final judgment of the Thika controller came. Lord, we have been declared as the Thika tenant. Lord, this being
Hearing
the
is over. Nothing.
My lord, he has something.
We'll
to
conclude
address.
arguments.
No, my lord, kindly
at
pass
this
it
point
over.
of time, Lord, we have also not produced the judgment of the Thika controller before the appellate court because at that point of time the judgment was not produced.
My lord,
Lord,
kindly
there
pass
will
it
be
over.
no bar because if the matter is remanded back, Lord, we will adduce sufficient evidence. Lord, it will protect the judicial chaos. Lord, his right will be affected, my right will be affected. Lord, both the parties must come to a neutral position.
Yes, we have heard the matter. What
My
do you
lord,
mean?
kindly pass it over. He has something to address.
Let it be passed over for the time.
That's
Grateful, my lord.
Not today. Pass over.
Grateful, my lord.
Pass over. Unless they are lucky and we cannot reach it. Some other matter is called on. Otherwise,
I'm
we call
waiting.
on.
Lord, I have completed.
You have been appearing all through.
Lord,
You have been appearing all through.
Lord, initially Mr. Vidyut Banerjee.
Mr. Gopal Mukherjee's name is written. That's why.
By mistake.
That's your name.
Mistake. No, it should be my name.
That is what is.
It is a mistake.
Mr. Chandicharan is for the state matter.
Mr. Chandicharan De.
Yes, madam.
Yes.
He is in some other court matter.
Yes, Mr. Ghosh, what do you say?
Lord, your lordship may accommodate, Lord, I am ready.
Well, an adjournment is sought on behalf of the state. Let the matter stand adjourned for the day.
Lord, day after tomorrow, your lordship, tomorrow on probate appeal is fixed, not that's why I am telling you.
No, if you have any difficulty in anything,
Yes.
because we have given them time, why shouldn't
Yes,
we?
no, mind.
Your learned junior is that he's competent enough. He will ask for time. Yes.
Item number 23, my lord, I am for the petition.
I beg to appear on behalf of the.
My lord, the factual aspect of this matter, my lord, the land has been vested under 14T3 proceedings.
All right.
Now, my lord, No, kindly, my lord, do not open the brief.
We are opening the list only.
My lord. Kindly hear me, my lord.
Yes.
The proceedings started long back, then continued till 1985. Thereafter, I challenged that proceedings before this court, and court has granted stay on that proceedings. Thereafter, tribunal was constituted and the matter went to the tribunal. And that particular matter, in that matter, my matter got dismissed for default. Thereafter, state has revived the proceedings and started de novo.
De novo?
Yes, that time I was not alive. I was dead by then. My legal heirs came before, challenged that vesting proceedings, went before the LRTT, taking 3 points. One is that inquiry under section 14N of the West Bengal Land Reforms Act has not taken place. Number one. Number two, the proceedings had taken place against a dead person. Number three, on the cutoff.
De novo proceedings were started in the name of a predecessor.
Yes, my father.
So at that point of time, he was already dead.
Yes.
All right.
And
but do you appear in the proceeding?
Yes. Let
me. You cured that defect.
No. I'll show.
Sir. Then.
And authority, while calculating this, whether my predecessor was holding ceiling surplus or not, in that process has come to the finding that this family has 8 members altogether. But
that was 7.
Yes, given
showed-
I'm sorry, 8 members.
Yes,
but the authority gave a bizarre reasoning saying that 1977 one of the daughter got married, hence I am not entitled to retain as per what is law permits me, that I can retain more than 6.5 acres. Sorry, more than 6.5 hectares, but authority allowed me to retain only 6 hectares. That is also bad in law, because the cutoff date of chapter 2B is chapter 2B of the West Bengal Land Reforms Act 55 is 15th February 1971, and the authority has held on the date of vesting, my family constitution is 8 members, but 1977 one of the daughter got married, hence it reduced the calculation. And my
daughter's marriage was post 1971.
Yes, post 1977.
Post 1971, which is the cutoff.
Yes, post 1971. Now, my lord, kindly come to my.
So these are 3 grounds. No
These are
inquiry under
3 grounds. My lord, before my lord go to the brief, my lord, kindly come to the act, relevant act.
Land Reforms Act.
Land Reforms Act.
14A.
দেখাচ্ছি স্যার। First, my lord, kindly come to 14. Oh, I'm sorry.
সামনে দেখতে হচ্ছে কোন 5th হবে এদিক থেকে।
এই যে আমাদের
এদিক থেকে 5th
আছে।
Looked better. Less used. That's yes. Yours is much more used. Yes.
My lord, kindly come to section 14M first.
M, yes. Ceiling area.
Ceiling area.
Right.
The ceiling area shall be in the case of a Rayat who is an adult unmarried person, 2.50 standard hectares. Then in the case of a Rayat who is the sole surviving member of a family, that is 2.50 standard hectares. Then in the case of a Rayat having a family consisting of 2 or more but not more than 5 members is 5 standard hectares. Then D, in the case of a Rayat having a family consisting of more than 5 members that is 5.00 standard hectares, then plus 0.50 standard hectare for each member in excess of 5.
So one for each of your.
One for,
in your case, 3 people.
yes, 3 people. So, however, that the aggregate of the ceiling area of such riot shall not in any case exceed 7 standard hectares. So in my case, 8 members, it 5, then 0.50, then 0.50, then 0.50, it comes to 6.50 hectares.
You are given 0.05 less in the name of the doctor's will.
Yes. Now I'll kindly come to section 14N. Why it is important? The determination of irrigated area, if any question arises as to whether any land is or is not within an irrigated area, such question shall be determined by the prescribed authority in such manner as may be prescribed. Subsection 2, the state government shall prescribe such authority as it may think fit for the determination of the question referred to in subsection 1. Now, my lord, I would like to show what is the implication of this 14N, how it changes the calculation.
Yes.
My lord, kindly come to 14F. 14K, my lord, I'm sorry, 14KF. My lord has got it.
Yes. Yes.
This standard hectare means in relation to an agricultural land, an extent of land equivalent to 1 hectare in an irrigated area and 1.40 hectares in any other area other than irrigated area.
You took a point that portion was irrigated.
Non-irrigated. So my ceiling goes up. Kindly have a look once again. 1 hectare in an irrigated area, 1.40. It's just 0.40 extra for non-irrigated areas.
Very well. Then if
Yes.
You see it's totally a non-irrigated area.
Yes. And
was a question raised? Anybody raised?
Yes, yes. I'll take my lot.
Then you will be getting 7.
Yes.
Because ceiling is 7.
Absolutely.
It goes beyond 7.
I bow down. That is my case.
Understood.
Now, my lord, kindly come to the rules 14B and 14BB. (14B) deals with the, my lord, I am placing the rules 65.
Give us half a second.
My lord.
Rules টা নেই tenancy tribunal rules tenancy tribunal rules
No, the West Bengal Land Reforms Rules 1965.
Those are not here.
No, kindly have a look.
রেফারেন্স বইতে পাওয়া যাবে বড়
রুলস একটা নোট করে রাখুন এই অ্যাক্টেরই নাম শুধু অ্যাক্টের বদলে রুলস 1965 ওটা একটা আনিয়ে ওরা বলা
commentaries act of the Das's book that is there.
Pardon?
Commentaries book on Das's book.
Amol Kumar Das.
That is there.
I don't know what will be available in the library. It's very difficult nowadays. I mean, we ask for something else comes. So we are just asking for the book containing the rules to be brought. Rules wala boi ani nin.
Sir, are rules ache?
Sorry, you are relying on rule
14B. That memo of these rules perhaps says, I do not have the book, that.
So this is the only book you have?
Yes, all are without rules.
Oh, then you cannot place it. You can place it then. You have one copy, you just place it. Eta ফেরত দিয়ে দিন, আনে দিন। এটা ফেরত দিয়ে দিন আর বইটা কাউকে দিয়ে আনে নিন এখন। Thank you. Rules. এটারই rules.
I have got it, ওটা দিয়ে দিন Joshua.
Any of you please write on a sheet of paper the rules. Just write now so that we can send for it.
একটা ওয়েস্ট
আপনি
বেঙ্গল
লিখে নিন West
ওয়েস্ট
Bengal
বেঙ্গল ল্যান্ড রিফর্মস অ্যাক্ট 1965
Yes, yes, yes. All right, we are doing it. You continue.
manner of determination of questions as to whether any land is or is not within an irrigated area under subsection 1 of section 14N. This rule has been implemented.
No, this is rule
14B, capital B.
14 capital B is manner of restoration under subsection 2 in our copy.
Yeah. The prescribed
This
authority.
is rules of 1965.
Yes, 1965. Well, kindly have a. I don't know. As he made.
It was substituted in 2011. Your version is before 2011. This book. What is beneath that red cover?
No, this is.
Yeah.
My 14B is here written in 1978, and my lord's book is 2011.
2011 there was
substituted.
A substitution, yes.
Substituted.
14B.
Whether that inquiry is there or.
Manner of restoration under subsection 2 of section 14E. This pertains to a period after 2011.
This is not before 2011.
Oh.
This is before 2011. Well, kindly till I get this one, kindly have a look. What are the
problem? That will create further confusion in our library. So at the end, can you just give photocopies of these rules? Pre-amendment rules. Before we get it. So the timing we are making do with this? Yes.
That inquiry has to be made by the revenue officer whether this is irrigated or non-irrigated.
Canal থেকে facilities পাচ্ছে কি পাচ্ছে না
Why is that application? Is there such an application?
All right. Within irrigated area. That inquiry was not there in your case.
Was not there.
That is your first point.
That was my first point.
There is a appeal provision is
Right.
Now, my lord, kindly come to page 30, page 30. That is the death certificate of in my writ petition of my predecessor, 17 June 1990.
Page 30 of this
writ petition. My lord will find the death certificate. My lord has got it.
We hope this is the writ petition. Let us check up. No.
30 or 31, my lord. এই পেজটা কত ডেথ সার্টিফিকেটের পেজটা বলুন স্যার
31 is a prayer.
52 there is something.
My lord, maybe my lord,
52. This
52.
folded.
Yes, folded one. That is the death certificate. And my lord, kindly see the date.
17 June
17 June 1990. But sir, vesting এর ওই জায়গাটা দেখাবো পেজটা বলুন এই যে এই জায়গাটা 2000 থেকে যে স্টার্ট হলো আবার again পেজটা কত now my lord kindly come to the vesting proceedings. First it started long back 1976 onwards, then my lord vesting proceedings vesting এর পেজটা বলুন না পেজটা 76 এর পেজটা 76 এর পেজটা
আচ্ছা ঠিক আছে তো
না না ওইটা তো 2000 এর
হ্যাঁ।
শুরু হলো কবে ভেস্টিংটা
এইটা দেখাচ্ছে
হ্যাঁ পেজ 15 মিলবে জজ সাহেবের সাথে kindly come to page 15 that's the commencement of the vesting order and 5th November 1976 it started
thereafter
ওই
thereafter এই যে
ওটা 28
পেজ 16 সব ঠিক আছে তো এগুলো তারপরে এইখানে শেষ হবে 29/76
Page 50,
মানে page 15
1/5 of the writ petition.
হবে না
1/5 is the continuation of the pleadings.
না
মানে page 36
38 পেজ মার্কগুলো ঠিক করনি কেন পেজ 38 29/76 এই যে শেষ হবে
30 is middle of the order sheet.
yes মানে kindly come to 36 it started in 30 কারে কি করেছেন জগবন্ধুদা
36 is a verification. 37 is
37 আপনারটা মিলছে তো kindly come
yours is telling with us.
yes
yes
37 is this first page.
yes first vesting started
started
মানে kindly come to the next page
38
that is
এই অবধি হয়ে থেকে গেল
29th November 1976 at the bottom
Yes.
till then for hearing it was fixed now kindly come to the next order sheet that is order number 5 6th March 1985
after 11 years
after 11 years after 1976 November 1976 then 85 then again so many notices were sent could not reach then thereafter I participated now kindly come to order number 20 dated 3rd September 1985 Malad has got it order number 20
This is 85.
yes 3rd September 1985
Yes.
after just 2-3 sentences heard the person present the total land schedule of the Rayat prepared on the basis of the ROR and the land statement submitted by the Rayat is shown in schedule A which is
You can't find it. Hard where from this
just after
1 to 8 numbers are there.
the
After that number. After number
Malad
eight.
is at order number 20
Yes.
order dated 3rd
September
September
starts with from the statement of the riot.
from this yes
আরে না না yes এই যে
from the schedule
এই যে
no
অর্ডার নাম্বার দেখো 19
oh
এই যে
oh Malad is at next page the continuation next page Malad from the statement of the Rayat as also from the local inquiry it reveals that the family of the Rayat as per provision of section 14 KC of the WBLR Act considered of the following members as on 15th February 1971 Rayat then wife then daughters 1 2 3 4 daughters then 2 sons altogether 8 as per provision of section 14M of the West Bengal Land Reforms Act the Rayat was entitled to hold 6 standard hectares of the land. He is considering the entire land is irrigated.
একটা পড়ো
As on 15th February 1971. As I said, Malad, that is the cutoff date of chapter 2B. Then Kipal? Papia Pal was married in the year 1977 as per statement of the Rayat and other daughters of the Rayat not married as on today, and the sons do not hold any other land as riots. Then therefore, after the marriage of the daughter Papia Pal in the year 1977, the family of the Rayat consists of 7 members, including himself, and as per provision of section 14M, the Rayat who entitled to hold 6 standard hectares. The change in the family
But
members.
Section 14M itself gives the cutoff date as 15 to 71.
Yes, that is fixed.
It is recorded here also. The previous sentence
Yes.
itself.
And the hectares of land which is equivalent to 25.75 acres of land and non-irrigated area. The circle officer such and such, then Arambagh Circle Office in his memo number dated such and such has intimated that the entire Dadonpur Mouja jail number 6 and some plots of Mouja such and such jail number 4.
Mr. Thought there is some error. He calculated 6.5 rightly. Because standard hectares he says.
Yes.
Not hectares.
Even law says standard hectares.
Yes. Standard hectare equivalent to 1.40.
Yes.
For non-irrigated areas.
For that should have been the calculation. That 6.50 multiplied should have been considered 1.4, not 1 acre.
No, but he calculates equivalent to 20.75 hectares.
Yes. No, it does not come. I'll show the by
Just
calculation.
calculate in your phone or something like that. 6.5 into 1.4, what does it come to? Maybe coming to that.
23.8 acres.
সেটাই আমি রাখতে পারি।
Acre, yes,
Yes.
that has been given.
No.
Yes, that has been given.
1.4 into 6.5.
Hectare, 1 hectare is 1.47 acres. So
1.4.
yes,
40.
total 24.45.
What is 1.40 multiplied by 6.5?
Oh, that is coming around 9 or something.
No.
9, how can it be?
8.60.
Yes.
8.60.
Much less. No, that comes to how many acres?
2.50 means 6 acres. 2.50 standard hectares means 6 acres. তাই তো ঠিক বলছি তো? হ্যাঁ।
7 হেক্টর মানে হচ্ছে 17.5 বিঘা।
17.5 একর।
7 hectares means 7 standard hectares means 17.30 acres.
You are given more.
More.
No, less.
20.75.
No, less. I'll come.
17 point something you say.
No, I was allowed out of 26 point. That calculation is there. Let me place that in the next page of Arambagh PS, which include the plots owned by the Rayat and within notified irrigated area of DVC canal. Kindly note this. Notified.
No, not notified. Non-irrigated area, they say.
Within notified irrigated area of DVC canal. It has got it. In previous sentence, he says non-irrigated. Then, which include the plots owned by the Rayat are within notified area. It has got it.
Notified, yes.
Yes. Notified irrigated area of DVC canal. Now the plots owned by the Rayat in Mouja, such and such, and jail number such and such, Dadanpur such and such, jail number, then Arambagh, and when notified again, within notified irrigated area, then Mouja panel such and such, and Poschim such and such are non-irrigated, and all the Moujas of such and such PS where the Rayat holds land treated as non-irrigated area as there is one case pending in the court, such and such. Then the mojas, different moja and areas were calculated. My lord has got that calculation.
Point is where from he has got.
Then my lord will
No, no, we
find
don't understand this. Some of the areas were held to be
irrigated.
and
He is saying some of them areas is coming under irrigated,
some not.
some of them are under non-irrigated area.
That purpose
So you say that there was no inquiry held.
There was no inquiry held. Then my lord kindly turn to the next page. The total land schedule of the Rayat is shown in Schedule A from the above.
Breakup.
Above breakup, it
You should have
appears.
given a typed copy, Mr. Thor. That would be easier for everybody.
Then my lord, the calculation kindly come to the next 3 lines. Total altogether 26.17 acres. But in terms of non-irrigated area, the Rayat is entitled to hold 20.75 acres. As per provision of section 14M of WBRR Act, and therefore 26.17 acres minus 20.75 acres, 5.42 acres of land in terms of non-irrigated area is excess ceiling land held by the Rayat, and this 5.42 acres of land in terms of non-irrigated area shall vest to the state. This is the calculation. No inquiry was placed regarding how much area is coming under the non-irrigated area. Only what is the gazette notification? Oh, this notification is there. This area is irrigated. This area is non-irrigated, and Malad proceeded with the vesting proceedings. Now Malad kindly come to a 2000 page 2000 50.
You had appeared for the state in this matter.
No.
5th October 2023, Justice Bosak's order recorded.
Wrong order.
State.
Yes. আমার নাম state
But I am appearing on behalf of the state, my lord.
Your name was not.
Page 50.
kindly now
Presume that you are appearing for the state because you appeared for the state in. Very good.
No, kindly come to page 50 once.
50, yes.
July, kindly see the date.
20th July.
20th July 2000, and my predecessor died in June 1990.
Yes.
Kindly see the case number on top.
Yes.
The same case number.
Case number is 41 plus 64.
Plus 64 /7A.
It's numbered like plus with plus.
Yes. That's how they gave the number. In 40 all previous proceedings, my lord will get the same number, 41 plus 64 /7A. 7A, my lord, I can say, my lord, in Land Reforms Act, by filing form 7A, Rayat files the return. That's how 7A proceedings. Now, my lord, whereas on perusal of the case records, subsequently it was amended 7AA. Whereas on perusal of the case records of appeal, the instant proceeding was drawn up to determine the facts of the lands of the allowed to retain under section 14T of West Bengal Land Reforms Act in terms of such and such. Then, my lord, the 85 proceedings, I came before this court, it was stayed, that's been recorded. And then 1997 LRTT Act has come into force, and thereafter they have discussed it, Now, my lord, kindly turn to the next page.
Who had the petitioner? Your predecessor was the petitioner.
My lord is referring about 85
This
proceedings.
proceeding, yes.
In these proceedings, no, my father. Still,
Predecessor, yes.
yes, they were proceeding against a dead person.
But you had to inform them that he has died and all.
I did. আমরা জানিয়েছিলাম তো।
Others, how do they know?
This one. Yeah.
Now they concluded the vesting proceedings. But till date, they have not taken possession under section 14 SS. Read with rule 14 BB. ওই 14B টা দেখুন ওটা amended কিনা। না এই 14B আলাদা স্যার।
Position.
সেটা তো দেখাবো। Manoj is looking at.
No, but you had to inform about the death. I mean, you don't inform them about the death. How do they know?
No, other two grounds are still remaining. Manoj, I have three grounds. One is against a proceeding against a dead person. Number two is there is no such inquiry.
Dead person, it is not exactly an adversarial proceeding against you in that sense. You initiate the riot initiates by filing the return. Then it's on them to carry on with the proceedings. Now they calculate your shares also. Apart from that married daughter aspect, that is another. They calculate the shares and they say that this is the quantum of land.
If I'm not holding ceiling surplus.
No, other points remain. Other points remain.
If 1.40, my lord, calculates that I'm entitled, rather the entire land would be retained by the riot. That is 26 point something.
26.
24.20. If it is
total land was 24.20.
No, my lord, 26.27.
Acres.
That is maximum. That is their finding that I hold or I own or my predecessor owned 26 point something.
Something acres.
Acres. And they deducted 5.442 acres from that and allowed me to retain 20 rest of the 20 point something.
20.7.
According to you, if there were 8 persons,
yes.
So if the cutoff date has been taken 15 February 1971, not the subsequent marriage.
If the riot has died, riot's share has devolved on you.
9 members.
So then you become 7.
As on the date, that is 15 February 71. That is fixed.
Submission of the riot. Right.
Any subsequent change.
So 8 into 1.4 hectares, what does that translate to?
কত দাঁড়াচ্ছে স্যার?
7 standard 2.47 per.
ওই যে মানে
তাহলে ইকার কত হচ্ছে? What does it translate to in acres?
No, no, just
Only conversion
2.50 equal to 6 acres.
You just Google search 1 hectare equal to how many acres, and then you will find some
2.50
converter and just put in the number.
2.50 is 6 acres.
2.47 is 1 hectare.
Yes.
2.47
Acre is 1 hectare.
is 1 hectare. And highest limit is 7 hectare.
7 hectare. 70.29. 7.50 acre. এটাই হয়।
Your total land was 26.27 acres.
Acres. 26.17
26.17 acres.
17.
Yes.
That is more than 7 hectares. More than ceiling limit. 9 member, not 8 member. Even if it is taken as 9 member,
So that comes to how many hectares? 26.17 acres?
26. It is 26.
You do these matters regularly, you must say.
26.17. That will be more than 7 standard hectares.
10.59.
10.59. 10.59 hectares.
আচ্ছা জাজমেন্ট গুলো স্যার
So 7
No, 2.47 per hectare. Hectare মানে হচ্ছে 2.47. হ্যাঁ
7 standard hectares is 24.20.
No.
I'm sorry. 7 কেন গুলি দিচ্ছ আমাকে?
হ্যাঁ বল
ম্যাক্সিমামটা কত? 24.20 তো।
24.20.
তো কেন?
Anyway, so these are your points.
Yes.
Let us hear them.
Now, kindly, I'll be placing the few judgments on this point, Malad.
Without placing the impugned judgment of the tribunal.
No, tribunal, kindly come to the tribunal judge.
Exchange.
What is the page number?
That is last page টা বলুন না কত নাম্বার আপনার ঠিক আছে ললিতদারটা ঠিক আছে বলো না
হ্যাঁ ওটা ঠিক আছে 64 পেজ 64
পেজ আফটার পেজ 64 মানে
conclude হয়নি I made an application
51
after page 60. Perhaps Mr. Mahata would be arguing that my prayer was before the tribunal that I sought for exchange of land. Means options did not have been exercised by my predecessor because the proceedings concluded against a dead person. So I wanted to retain Garihat's land, wanted to give up Garia's land. So that tribunal has not considered. Against that, I have come before this court. Now, Malad, kindly come to page after 64, Malad. As the present applicants being heirs of the Malad has got the impugned order, first page.
13th of July.
13th of July 2015.
Yes.
Malad.
First page starts with this is an application under
This
section.
is an application under. I'm skipping that paragraph.
Yes. Yes.
Kindly come to the second paragraph.
Right.
Applicant's case in short is that the Bigrayat proceeding under section 14T was initiated against their predecessor in interest, Shubodh Kumar Paul, by the state respondent, while some lands were vested, being proceeding number such and such. Said order of vesting was challenged in High Court, being number such and such, 85, the previous proceedings, which was ultimately transferred to this tribunal in the year 2005, and the order of vesting was challenged as no opportunity was given to file option form for retention, and proceeding was held behind the back of the Bigrayat. said case being TA number was dismissed for default, video order dated 5th May 2005. Then being annexed such and such page 27 of the application, as the present applicants being heirs of the Big Raat are still in possession of the lands alleged to be vested, they submitted those representations to the authority for permitting them to surrender 84 decimals of land in Moja Idol Bali in plot number 1704 in exchange of vested lands, being 56 decimals in plot number 6843 and 28 decimals in plot number 6932. Then learned counsel for the applicant submits that as the applicants are still in possession of said lands, they may be permitted to file fresh option so that the vested lands as mentioned above may be exchanged again against 84 decimals of land in plot number 104. But said representations are still pending in the office of the BLLRO since 2014. Then GR's submission was noted. Learned GR, let me place that. Otherwise, Mr. Mahata will say, why did you not place that? Learned government representative submits that though in the representation as well as in the advocate's notice, it was categorically alleged that the said PR proceeding was initiated without notice and without giving opportunity to file option of retention, but those allegations are totally false. In this case, such and such connection, he draws attention of this tribunal to orders dated 76, 85, 85 in the previous proceedings of the concerned proceedings. According to him, said proceedings proceeded in presence of the representative of the Big Raat, then at all stages, and that in spite of giving opportunity to said Big Raat to give options, he did not intend to file any option. According to him, at this stage, it cannot be said that no opportunity was given for taking participation for filing option. He further submits that no plot information of the said vested lands have been filed to show that is their present position and whether those have already been distributed to the third parties or not. Then we have considered the submission made by learned counsel for the parties and peruse the materials lying on the record. If the petitioners filed his specific case in Honorable High Court, praying for setting aside the order of vesting on the grounds of non-issuance of notice, etc. After transfer of the matter.
So there was no fresh proceeding.
2000 proceedings started after the dismissal. This tribunal has not considered that aspect. That the proceedings which
May I permitted to reply on this portion? This is under proceeding under section 14Y. Due to the death of one person, kindly see the section 14Y of the Land Reforms Act. Due to the death of one person, further acquisition of land can be initiated, and that is why that was initiated.
14Y.
14Y. 14Y, the page, your proceedings says that it is under section 14Y. Kindly see, my lord, the order, the initiation of 2000. That is page 50, my lord.
Kindly check. Kindly
Yes, page
check
50.
all the orders. My lord will find the same thing: 14T, 14S, and 14Y.
14Y.
No new proceedings.
14Y means the future acquisition of the land due to the death or marriage. This can come.
Here, my lord, no future acquisition.
Yes, in 77. In 77, one of the daughter married. Further, so his ceiling limit should be deducted.
Let us see the 14Y.
Yes.
Let us see the 14Y.
Why, how it is happening? Situation has not arisen.
Kindly come to 14Y once. If at any time after the commencement of the provisions of this chapter, the total area of land owned by a Rayat exceeds the ceiling area applicable to him under section 14M, that is in respect of a family, the ceiling which I placed under section 14M, I take it in a hypothetical situation 24.20 acres. That is the maximum ceiling. So if that person overreaches that 24.20 acres on account of transfer, if he purchased from X, then if he inherits any subsequent land, then or otherwise, means mortgage or some other form of, then the area of land which is in excess of the ceiling area shall vest in the state. So for that, I have to have an acquisition in a future date, number one. Number two, I have to cross the ceiling limit which has been prescribed under section 14M. So either by way of transfer or by way of inheritance.
Inheritance had to be by the Rayat, subsequent acquisition by inheritance from his heir, his predecessor.
Yes.
Not his heirs.
Not his heirs.
For this purpose,
Yes, how is 14Y applicable here?
How it is, yes. How it is applicable?
14Y does not come in. If the Rayat acquires subsequently some property by transfer or by inheritance.
On the date of vesting, he has the 8 members according to our case.
Rayat himself died.
For the purpose
So
of
eight members.
This, no, 14Y contemplates when by virtue of some transfer or inheritance, if in future there is some further acquisition, that is contemplated under section 14.
The language is transfer, inheritance, or otherwise.
Rayat did not acquire any further property.
My lord, the Rayat has been given 8 members ceiling as on the date of vesting. Now, married daughter, who will be excluded from the ceiling? So after 77, one of the daughter married.
No, just because you occasioned a
on the date of
delay,
vesting.
just because you occasioned a delay in concluding the proceedings, you cannot take advantage of that. We should take the date of vesting. On that date, what was the entitlement?
He
Subsequent marriage,
entitlement.
the daughters cannot be kept unmarried forever because you take time in your proceeding. That would be a ridiculous proposition. We have to see the cutoff date is the date of vesting.
Cutoff date is
On the date of vesting,
17,
subsequently daughters may be
1971.
married. On that date, what was the position? We have to see that only.
But my lord, the married daughter,
Married-
married daughter is not.
She was married in 77.
77.
After 71, which
After
is the cutoff
71.
date. So how can you take that into consideration? One.
My lord,
Secondly, 14 scenario, if the Rayat acquires further land by either by transfer or by inheritance. Rayat himself died, the poor fellow. How could he acquire further land?
in that event too, my lord, his vesting has been given. His
Same
vesting
proceeding
is-
was continued all
My
along.
lord,
Tribunal did not take it.
his vesting, he did not, my lord, the vesting order was challenged in the writ court and it was dismissed for default.
Yes, that we are asking Mr. Dhordya. How can he overcome that?
Overcome that. The vesting order has been dismissed for default and no, there was no.
That is the
challenge.
first question we asked him. From that, this entire thing,
My lord.
14Y generated, you sprang up.
My lord.
14Y is a different thing altogether. 14Y, we
Had
don't
we
find anything.
accept that 14Y logic,
We
then
don't accept their acceptance. There was no 14I scenario here. Your proceeding, your challenge was dismissed for default before the tribunal. So that same proceeding was there. So now how can you reopen that issue?
That issue was, I came before this court challenging that particular proceedings of in
That
the
challenge
year
failed.
1985.
That is the only proceeding which is continuing. There is no
1985.
further proceeding.
There was no further
So your challenge was dismissed for default. Never revived. You never restored it.
They revived the vesting proceedings.
How? Under what
Again.
provision?
They continued with that proceedings in 2000.
They are entitled to continue because your challenge to continuation of that proceeding has failed by virtue of dismissal for default of your challenge to that.
Not in violation of the
You,
state
no, you
provision.
challenged that proceeding, right?
Yes.
There was no final. I mean, even if there was, yes, vesting was there. They had started a proceeding, but that proceeding that culminated in an order, which you had challenged before the High Court, then it was transferred to the tribunal. Before the tribunal, it was dismissed for default. So your challenge ends there. How can you further challenge that by a WB?
Subsequently, 2000 they have
And
started.
we don't also understand if it was dismissed for default, what was before the tribunal? What was the occasion for passing this order? Your previous challenge was
second half of the proceedings, which had started in 2000. Kindly come to that.
Can there be
preamble.
two halves of the same proceeding under this?
Yes.
14A.
Why I say this, my lord? They proceeded with the vesting proceedings. They started in 1976.
Yes.
Then they stopped in between. 1976 they stopped. Then again after 11 years they started in 1985. Then again it went up to the end of 1985 till I challenged that vesting proceedings.
Stay was there.
Then stay was granted by the Honorable High Court. Then
It was transferred to
it was transferred to the tribunal. Kindly visualize that situation.
No, there was no determination under section 49. There was a determination under 49.
No.
There was never any
No,
determination under 49.
subsequent proceeding or no determination.
Vesting has been made.
All right. Subsequently.
5.421 land vested.
No, right. Mr. Mahato is right on that because vesting
5.4
had already occurred.
occurred. 5.42 has been already been vested.
You challenged that. Your challenge was
Challenge-
dismissed for default.
challenge dismissed for default. And my lord, and his prayer.
What was the occasion for the tribunal's order?
My lord, kindly see the prayer of the the second petition tribunal application, original application. Kindly see the prayer.
Where is that? Which page?
My lord, no.
Pratham challenge to dismiss for default.
My lord, page 33, my lord, kindly see the prayer. Here is the prayer is only to the concern that he want to exchange some land. This is the cause of action of the second original application. That is under challenge.
If
yes,
then my lord, the vesting of the previous proceedings should have revived.
No, by this you
because I was unsuccessful.
You sought an opportunity for a fresh option.
Change equal quantum vesting land. He will.
No,
What has he-
opportunity to exercise fresh option for retention of such and such a land and wanted to release such and such. Basically exchange. Yes.
Page 84 decimal land. 84
Kindly come to page 50. No, that would clarify.
Page?
Page 50.
Page 33 is a prayer. How can you go beyond that?
No. Kindly come to page 50.
Annexure B.
If my challenge thrown to the concluded vesting proceedings got dismissed for default, then what was the occasion that authority started in the year 2000?
Again start.
That Mr. Mahata is not giving any explanation. Now, kindly come to 2000 order.
Proceeding was drawn.
Your dismissal for default was when?
2005.
2005.
So this is not after the dismissal for default
Yes,
order.
no. This is not after the dismissal.
Before that, did they start anything after 2005? Your dismissal?
Then my lord, my land may have any cause of action. And kindly see the prayer. Prayer is only for exchange. That he is the.
When did you prefer that challenge before the High Court first?
1985. Kindly come to another page. Another page. 50, 51.
A determination was made in 1985 finally.
52. Kindly come to page 52.
Order.
Yes,
that was the first order by Justice Bhagavati Prasad Banerjee.
When the determination
52 and 53.
When the first determination.
Yes.
55 college.
In that you had challenged what? This.
Kindly come to that order. There will be an interim order.
Which page?
53. It has got it. I don't know whether it is
53
starts from page 52.
52, my lord.
Then next page perhaps would be the death certificate. Then next page would be 53.
52 is the death certificate here.
Then 53 minute.
No, then 54, my lord, kindly come.
Or 54.
Yes, 54.
There will be an interim order injunction in terms of the prayer F of the petition till the disposal of the rule.
Yes.
Liberty is given to the respondents to apply for variation and or vacating of the interim order.
That is interim order.
Notice
Yes.
such and such.
What had you challenged?
That is the vesting of 1985.
Yes.
Setting aside and quashing of the
vesting of 1985.
Vesting of
Vesting order.
1985.
And that
So what has?
Yes.
Then
trying to reopen that 85 exercise.
they state tried. That is in 2000.
Page 50. Page
That is at page 50.
the proceeding was drawn up to determination of the, again they have started for determination.
Kindly read the preamble part, first part. Again determination under section 14T3. These had taken place against a dead person. If I am to accept Mr. Mahata's already vesting had taken place before 1985.
আপনারটা একটু ভালো আছে না
They have recorded in 2000 order.
Yes.
It appears that the riots moved the Honorable High Court challenging the proceeding with a such and such.
Yes.
This was that writ petition.
Yes.
But its
Now
order-
kindly come to the second paragraph. Whereas it appears that
You're reading that only.
riot would be the Honorable High Court such and such moved the Honorable High Court challenging the notice dated such and such CRM stayed the proceedings with such and such not to proceed further towards the
disposal of the proceeding.
Said proceedings.
And the what proceedings then?
And the
instant proceeding. But there was no stay order passed at any point of time.
Yes,
injunction was passed.
Yes, that they have termed it as.
No, at that point of time, stay was.
What else remained after the vesting? What was stayed? So, Mathav, you explain this order.
No, kindly come to the next paragraph. Whereas
what is the explanation of this?
This order is not under challenge under any proceeding.
Huh?
This order, 2000 order is not challenged under any proceeding. No prayer, nothing. The cause of action of the new writ petition is page 32, page 33. Can you see all the prayers?
Yes. What did you do by this 2000 order? Let us see that also.
Now, here in the second petition, here cause of action was only limited portion for exchange. The certain portion of the land, he accepting that vesting, he want to exchange for what has been given to his retention. He will exchange what has been vested, particular point, plot of land, only 84 decimal of land. That is the cause of action.
You can't read page 51. That is a difficult, very illegible. What remained to be done by you, you don't understand. You said there was an interim stay, so you stayed your hands. So what was remaining to be done after that?
My lord, nothing to be done.
Then what did you do by 2000 order?
My lord, in 2000 order, my lord, 2000 order, it is not also under challenge. 2000 order is, my lord, this is, my lord, practically nothing. 2000 order is nothing.
Nothing.
80, yes. 2000.
2 pages of nothing then. There are 2 pages of nothing. I have to explain that to someone.
Nothing.
It's a very big nothing.
Very big nothing.
But it's illegible. That's the difficulty. Otherwise, by now we would have understood what is there. Absolutely illegible. And this handwriting matches mine, actually. That is the difficulty. আপনি পড়তে পারছেন কিছু? পরের দিকটা তো একদম পড়তে পারছি না। ভীষণই বাজে। This is taken up for disposal. Issue notices upon the riot. We can read hence the case is the last is hence the case is taken up for disposal.
Case will be
Issue notices upon the riot, asking them to appear before for what? On such and such date. What date is given?
For fresh 7A form option.
Don't do guesswork. If you can read, please.
Where is that?
hence the case is taken up for disposal, issue notices.
You
upon
just read out this. In the meantime, we'll hear three, four other matters, and then we'll
My lord,
just read out this sentence, last sentence.
the last sentence.
Upon the what for disposal, issue notices upon the riot,
Disposal of-
asking them to appear before the countersigned, undersigned on 27/7/2000 at such and such 11 a.m. to submit. This is the crucial position to
retain as per my lord, that within
provision of the
within
act.
circle, my lord, it's
So this was ministerial apparently, something ministerial.
Ministerial.
We are saying ministerial, you are saying ministerial. You are the state, you are the king, you are not the minister.
Of the petitioner.
But Mr. Dhar, it appears to be ministerial because you have to
No, my lord,
appear.
my lord, whether I want to retain the Garihat lands or Goria,
See,
that
Gorihat, Goria,
option-
forget Gorihat, Goria, both.
My lord.
You challenge the vesting by way of a regular challenge before writ petition before this court, which was subsequently sent to the tribunal. Well and good. It was dismissed for default. That challenge ends. Now you cannot reopen that challenge.
My lord.
Whatever they did in 2000, they gave a date. Issue a notice on the riots, ask them to come and do whatever. That is not challenge, his right on that. Now you file another application before the tribunal, this time conceding to that vesting, and you ask for an exchange only. So by asking for that exchange, Mr. Dhar, you are conceding to giving a concession.
if my lord,
That was rejected by the tribunal.
If my lord, the statute permits me to hold or retain this much of land,
That cannot be reopened. If the statute permits you, if there is an adjudication, it cannot be. Mr. Dhar, if there is an adjudication of court, it cannot be. You challenge that. There was an adjudication by the authorities, which you say were erroneous. There are very good grounds in the appeal otherwise, in the writ petition. But unfortunately, that challenge you had preferred, that was before the tribunal. It was dismissed for default. Order 9 rule 9 principle applies. You never asked for the restoration of that. Why didn't you? And then you file another, you don't ask for a reopening of that. You ask for exchange of your properties on the basis of that vesting only. On the premise of that vesting you have asked for. That has been decided now by the tribunal.
By the tribunal.
You cannot reopen a single line of that vesting.
My lord, I have challenged the vesting as well. That
See the
discussion,
prayer?
that discussion
What
is
discussion? See, look
in
at
the
your prayer.
tribunal's order is
Look
there.
at your prayer. Whatever the tribunal says. Tribunal's order is bad. That is the premise of your challenge. So let us see the good things. Your reliefs. Page 33 is your relief. You read out the relief. Let us be enlightened on how you challenge that original vesting. 33 is with him. From 33 onwards with him.
No, my brief is not paginated.
এটা পড়
The pagination was done by the same revenue officer probably. Come to page. Have you read it? Page 33.
I'm just.
If something appears to be interesting, tell us.
Start fresh proceedings, if any, setting aside earlier.
Which portion? A, B, or what?
B.
B.
Be also pleased to direct the concerned BLR to exercise fresh option.
Is that permitted under the law? And after your challenge gets rejected, why should you get a fresh option? By setting aside vesting
the
schedule?
provision, it was incumbent on the authority also to give all the provisions.
Mr. Thor, this has been rightly decided by the tribunal. The tribunal takes into consideration all these things. Let us see.
তখন স্টে ওয়াজ দেয়ার
ওই পেজটা কত?
ডিসমিসাল হয়েছে 5/5/2005
Application under section 6 read with section 10.
এরা প্রসিডিং
Alleging inaction on the part of such and such, not disposing of
স্টে ওয়াজ
represent-
কন্টিনিউ
You made representations which are not disposed of, therefore you prefer
Can you
challenge.
come to page 49 once of my writ petition?
কি আছে?
ইয়েস
Yes.
My lord has got this.
Dismissal for default.
Dismiss for default. So from 85 till 2005, I take it there is a stay.
was there.
Stay was there.
Injunction was there. You have placed that order also.
My lord,
It was a
kindly
rule
come-
issued.
my lord, kindly-
Injunction. Let us see the injunction. Rule issued in terms of ABC. Actually, that's why we specify the order. We never do this. That was the previous practice, but we enumerate what is the rule. Otherwise, it will be difficult. Interim order of injunction in terms of prayer F. Now find out prayer F for us. Let us come back to that page 34.
My lord, kindly come to.
Let us see prayer F.
Yes.
Earlier read petition টা আছে না?
Earlier writ petition is not here. My lord, earlier writ
So
petition.
this is on this writ petition.
No,
On this
second.
that is 85's writ petition. They were referring.
Prayer D টা হচ্ছে quashing of the
My lord, kindly come to prayer D.
prayer D.
My lord has got in that order. No, not in that writ petition. My lord, in that order. 1985's order. My lord, of the petition cancelling, setting aside, or
Which page?
My lord, page 54. Page 54.
পেজগুলো এত উল্টোপাল্টা করেছো না?
54 years.
Yes.
Yes. My lord, kindly come to my lord. Or why are
No, that is a rule. Certiorari be issued.
Yes.
Why should not be quashed?
Prayer D.
Prayer D. My lord, prayer D is mentioned. My lord.
Prayer D is the main prayer.
Yes.
Quashing.
Quashing.
A rule was issued to that effect.
Yes.
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 That is the usual rule which is issued. That is not the interim order. Interim order is the next paragraph. There will be an interim order of injunction, terms of prayer F of the petition. Must have been not to give effect to that
Effect to the-
vesting.
That is there.
So if that challenge itself fails, this rule is discharged.
No.
The rule is discharged.
Rule automatically gets discharged if the main.
Now, my lord, kindly come to the subsequent dismiss for default of 2005.
Yes.
5/2005.
5/5/2005.
এই যে এটা না? 5/5/2005.
Page 48. Page 48.
এই page 40.
Yes.
48 or 49.
Page 5/5/2005.
On that date,
none appeared for you. They were present.
Yes.
Case is dismissed. Interim order vacated.
Yes.
So what has prompted the authority?
That vesting remains. Now you make another application before the tribunal seeking to reopen the entire chapter by saying that let there be a fresh exercise.
Now, my lord, kindly.
How can you make that prayer?
My lord,
That is
kindly,
meant-
kindly come to again, my lord, the preamble part of 2000. That order is
2000 order is they merely say that we revive the thing. What do they revive? The ministerial actions. They call again because these are on the representations you made. These are, Mr. Thought, 2000 is on your representations, subsequent representations, which were the premise of your second application before the tribunal. Just see your prayers. In your writ petition, you must have stated about those representations. Demand of justice and yes, right.
Your lordship kindly
that
come.
demand of justice is well after 2010. Not
That is on the basis of your representations.
yes.
You say in page 28 that your applicants quite in the dark, no knowledge, proceedings, bad illegal, etc. Then Roman 6, you state that you recently came to learn that such and such has been vested in the name of Rayat, late Subodh Kumar Pal.
Yes. We were of the opinion that proceedings had not culminated. They have not
The
taken
vesting
possession.
occurred in 1985 itself,
Yes.
which you had Subodh Pal had challenged before this court.
Absolutely.
So that was ultimately that culminated in the dismissal for default. So your father's challenge to that vesting culminated in a dismissal for default, subsequent to his demise.
14S possession has to be taken.
Your cause of action for the next application before the tribunal is page 28, Roman 6. You, the heirs of Subodh Pal, who had already suffered a vesting order, you say you came to know of that vesting regarding Rayat, Subodh Pal, but option was not given because Rayat let Subodh Pal move the writ petition against illegal vesting
That's right.
order.
And the last paragraph of 2000 order says invites me to file an option. Now, that's what I am trying to impress upon. Now, kindly read along with 2000 order. Last paragraph. Their authority is inviting me to file an option.
No.
Option for what?
Option to retain. No, my lord, kindly again come. আরে বাবা, পড়তে দিন। আজ কি হয়েছে? আমি ভুল বললে বলবেন। Hence, the case is taken up for disposal, issue notices upon the riot, asking them to
But Mr.
appear.
Dhot, tell us this. Can the options now being given to you be beyond the vesting order? If the vesting order says this much has been vested in the state,
My lord is asking
now
me
what is the question of reopening that and giving an option to retain?
whether revision of form is allowed, permissible or not.
Right.
Answer is yes, my lord.
Because
till they take the possession. Till they take the possession. That is the law. Till they physically take the possession.
তুমি লাস্ট প্যারাগ্রাফটা পড়ো ভালো করে।
All right.
The 2003 volume 9 SCC, my lord, Sulekha Pal's judgment, it says even a riot can exercise or revise their option. If previously he had given option for Goria land, then subsequently he wants to come and retain Gariahat land, then he is permitted to do so till the possession has not been taken by the authority.
Understood. But can that go the traverse beyond this order, which you had challenged and failed?
Challenge and fail.
In 13,985, this exercise was completed. Only the option now has to be in terms of this. It was held, it was finally decided that you had to, you could retain only this much. Please come to page 44, 45. This adjudication was made, which you challenged and failed. Not failed in merits, but yes, dismissed for default. Page 44 says, as per provision of section 14M, you are entitled to hold 6.5 standard hectares.
Yes.
That is final.
That is
It has
final.
attained finality. Whatever option is given to you has to be within the perimeters of that.
Till the continuation, may I take the point of propriety or legality of that order?
Can you, after your challenge is dismissed for default? That is the difficulty. Whatever is now done, whatever option is now given has to be within the parameters of this. Entitled to hold. It is recorded here, but in terms of non-irrigated area, Rayat is entitled to hold 20.75 acres as per provision of section 14. So your entitlement to hold is sealed here.
Sealed here.
You could just have applied for reopening that dismissal for default with a section 5 instead of preferring a new writ petition and all these things. And independent of this, you could have done that. This would be dependent on that then. Then you could have just taken out a section 5 application, a registration application along with the section 5. That order would be recalled. Consequentially, both the challenges would be taken up together and decided. All these points would be valid. You have not done it. Now you have advised you, so I will close your option. You could just have took out a recall application with a section 5 and had that heard along with this. So this is a continuation of that. Now you are bound by that order. Since 2005, you have not done it. We are in 2025, 20 years have elapsed. This is the only consideration, whether how far we have got your points and you cite your judgments, whatever you have to. You just refer to the judgments, give the points, and Mr. Dhod, file a very brief written notes of arguments. We will not conclude today. Just look into it whether what is the scope of
TWN, page 536.
On what point?
On the point of 14N, Mayor saying that this land is coming under the notification of irrigated area will not serve the
Inquiry
purpose.
has to be there.
Inquiry has to be made.
Very well. Write the judgment in the written notes, Mr. Dhor, and give the proposition in bracket. One line. Next
And
judgment.
the other judgment is
Mr. Mahata, take a note so that you can controvert in your written notes. Yes.
1988, volume 2, CHN, page 41. This deals with both the...
Give the citation, paragraph, proposition.
This deals with whether after 15 February 1971...
That 77 marriage.
That can
Very
be
well.
considered or
Get
not.
your point. Get your
Any
point.
subsequent...
Next.
along with 14K D and C, the ceiling, and also 14B, the inquiry has to be made. And memo of inquiry has to be served upon the
Yeah, no
Raya.
such exercise. So this is on both the points, on the first
On-
point
on
as
both
well
the
as
points.
on 1971.
Yes. That inquiry report has to be supplied to the
Understood.
Raya.
Yes. Third,
No, my lord, the other judgment is 1982 1 CLJ.
for
Again, my lord, on 14N and 14B and 14KD, that inquiry is must.
to club these judgments under the same head, give a curly bracket and just say below this is the proposition. Paragraphs. And next,
And my lord, 2003 volume 9 SCC.
multiply too many on the same point. If
No,
it-
this is not on the same point. This is on the point, even revision of retention is allowed by the Raya till authority gets.
This is very
physical.
important. Give the citation for Mr. Mahath.
Well, 2003 volume 9 SCC, page 253.
But here there is something coming in between that proposition and your case. That is your failed challenge. If that was not there, we could have understood.
That's it.
This is all. Yes, Mr. Mahatha, you have already argued that this 2000, how do you explain?
2003.
2000. From 2000, you started something new. What was that?
In 2000, my lord, if you lost, my lord, the concluding paragraph.
Yes.
My lord,
Which you
the-
could not read. You can read out.
Could not read, my lord. It is here that, my lord, that they have been asked, my lord, to attend the office. They have prayed for, my lord, for exchange of land. And if there is, from the vesting, if there is any exchange, that can be done.
The case is taken up for.
See, you said 2000 exercise was for vesting, for exchange.
The exchange, not for further vesting. There is not a single line or single word that further vesting is going to be taken in 2000.
Put that in your written notes and you counter his arguments.
My lord.
Particularly his argument that at any point of time before position is taken, they can exercise the option. Because here there is something very important.
Here the case is totally different. Here the vesting has been concluded, vesting has been challenged, vesting challenge, interim order obtained, and that has been dismissed for default and no restoration.
The question is whether option can go
Option
beyond the
can be
vesting
done
order.
beyond the vesting order. Here the question
Option has to be within the periphery of the
is
vesting
the
order.
periphery of the vesting order.
That is what is irking us. Let us see. But they have made out very good points otherwise on merits. Several points. If you get one small hole, we'll enter through that and reopen. We are telling. So seal the hole very well in your argument. The 2000 is what you reopened. We have to consider that. What is the scope of that? Because options were not exercised. Vesting order is there, but option was not exercised. What is the scope of interference in the interregnum? Is the vesting sealed without the options being given? That is what we are on. If we find that in law, unless the options are exercised, the vesting process is not complete, then we can reopen.
If we go to the 2003 Supreme Court, here that the unless and until the
This is
position
one
is
judgment
taken-
you are citing.
my learned friend is citing, my lord, I am supporting this.
Acha, what is there?
There that if a land, my lord, unless the government has taken the possession thereof, they can change the option.
If that be so, then they can reopen the options.
The option that is relating to only what was the prayer in the writ petition and what was the that is 84 decimal. Only for that 84 decimal land, what has been allowed him to retain 84 decimal land, that can be exchanged by changing the vesting of 84 decimal of land. Now,
It
what
has
is the
to be
prayer?
governed by that vesting.
That vesting. That is the vesting. The vesting will be the same.
Vesting is completed. Vesting is completed, but the retention.
But if it is, my lord, he is in possession, in that event, that 84 decimal of land, what he want to exchange from is the retention land from the vesting land, the land which has been vested. If he is allowed to him that to retain, and the what amount of in another plot, what he said that it is my retained land, that will be vested.
Only that limited scope.
Only that
So how
limited
soon can you file your written notes? Yes, Mr. Dhar, written notes when?
My lord,
Take your time, no difficulty.
within a week's time. My lord.
Within a
We'll keep it on 20th August. Today we are on 12th.
my lord.
20th August?
My
20th August. Very well. Oral arguments are concluded. The matter shall be listed under the heading to be mentioned on August 20, 2025 for the purpose of filing of written notes of arguments by the parties. Thank you very much. এই বইটা ফেরত দিয়ে দিন। এই বইটা আর একটা বোধহয় কপি আছে। এরকম এই বইটা
Well, I'm sorry for extremely well, illegible documents and
what can you do? Yes. এটা এর মধ্যে
আমার বই কোথায়
এটা থাকবে যখন রিটেন নোট ফাইল করব তারপর পাঠাবো। তো টু বি মেনশনড আসবে ওই নোটটা শুধু রেখে দেবেন।
নামগুলো দেওয়া নেই।
পাস ওভার ম্যাটারটা একবার কল।
Going to one.
Yes. You had concluded, Mr. Bhattacharya. What remained?
The two judgments, my lord.
Side.
One. ওইগুলো the suit was filed, my lord, on the ground of reasonable requirement, default, violation of MOP, my lord, of clause 108, section 108 of Transfer of Property Act, and default. Now, my lord, there were several issues framed. When the first,
1 second. এটা ইয়ে কোথায় বললেন যে নোটটা? উল্টো ফাইল দেননি তো? উল্টো ফাইল দেননি তো আমাদের? সেটা জিজ্ঞেস
জাজমেন্ট গুলো এনেছো?
ফার্স্ট জাজের এটাই? কোথায় গেল সেটা? ওটা তো লাগবে। একটু চলতে হারালে তো মুশকিল হলো, ওটাই তো খুশি হলো, ওটার উপরই তো মামলাটা শুনেছি আগের দিন।
What is like the hearing to?
আপনার এই পাওয়ার ফাইলটা আমার একটু আলাদা করে রাখতে হবে তো, এক্ষুনি তো দেখালেন নোট। নোটটা কোথায় গেল তাহলে? Repeat your points.
Yes.
In a nutshell, I'll remember.
My lord, this is a suit, my lord, filed on the grounds, my lord, of section 6 of the West Bengal Premises Tenancy Act. Now, my lord, the grounds, my lord, were default, reasonable requirement, and violation of clauses MOP of section 108. Now, my lord, regarding, my lord, the several issues were framed. Now, my lord, regarding default, my lord, extensive issue was framed. It was the specific finding of the learned trial judge that they did not file after entering appearance under section 7.2 for determination of landlord-tenant relationship and for quantification of areas of rent and the rate of rent. Therefore, since there is a default, our case is that of default since 1991. Therefore, their 7.3 has been allowed and they are not entitled to get protection under section 7.4. One. Number two, reasonable requirement, we were successful. Regarding service of notice under section 6.4, that issue was decided in our favor. Only one thing which was we were unsuccessful is we could not prove nuisance and annoyance.
MOP.
MOP, we could not prove that. Now, in the written statement, they had taken a defense that the suit was barred in view of section 8 and section 5.3 of the West Bengal Tika Tenancy Act because of the jurisdictional issue. Yes. Now, thereafter, that was, my lord, point was not taken into consideration because the learned trial judge says the defense struck out.
But
Why
Mr.
should
Bhattacharya, isn't that point to be decided first? Because if thicca tenancy is applicable, the suit is not maintainable, there is no applicability of section 7. So how can you do the reverse, go the reverse and say that no, I strike out the defense and then don't take your argument?
yes, then my lord, they preferred the appeal.
Rightly.
Appeal court said, since the proceeding is pending before the thicca controller, I am setting aside the impugned judgment. I am remanding the matter to the trial court, and the trial court should wait to the outcome of the Miller proceedings before the thicca controller, and then.
No, Mr. Bhattacharya, wasn't that the just the right thing to do?
No, Millard, Order 41, Rule 24, Millard, I think, Millard, it's applicable in this case.
How? Because why we say this? Because then if 24 is applicable, your entire decree should have been set aside.
24 is applicable. Why, Millard?
Setting aside, if I was an appellate judge, the ideal thing, according to me, would be, correct me if I am wrong, that trial court erred in law in not deciding the issue of maintainability of the suit
decided
as taken in the written statement by due to the defense being struck out, by overlooking the fact that in the event the maintainability point was decided in favor of the defendant, the question of defense being struck out would not be attracted, because the the 1997 Act, rather section 7 would not be applicable at all before the civil court. Civil court would not have jurisdiction. So trial court erred in not taking up the jurisdiction question first, irrespective of the written statement, deciding that and only then considering whether it is applicable. If it did not have jurisdiction, it did not have jurisdiction to strike out the defense also. So then it would have been a direct outright setting aside of the trial court's decree.
Well, that is there.
And then also we would have to remand it to the trial court for deciding the maintainability issue first. And by now they have got an order from the thicca controller. So you're gone.
Yes, well, kindly, Millard, see, Millard, how, Millard, the issue was decided by the learned trial court.
We'll
Maintainability.
supply further reasons. We'll say that no, but because Mr. Bhattacharya, the trial judge went absolutely wrong in deciding all of the issues without deciding the issue of maintainability first. Issue of maintainability was shirked on the ground that the defense has been struck out. But it was the reverse. It should have been the converse, actually. The maintainability issue should have been decided first, and only if held in favor of the civil court, then the rest would follow. And here we find that maintainability issue goes in their favor.
No, Millard, otherwise, Millard, there was
Section 5, Section 8.
No application under Order 14, Rule 2 or Order 7, Rule 11 from the side of the defendants.
Need not be. At the time of final
degree, yes, definitely. But he has done so, Millard.
The first issue is maintainability. How does he deal with it? Saying that defense has been struck out, I won't look into this.
Millard, yes, Millard, that is there, Millard. But in addition to that, Millard, he has also...
All the other issues are dependent on that, Mr. Bhattacharya. All the other issues, every other issue. Section 6.4, because if he does not have jurisdiction to look into it, it's subject matter jurisdiction. Goes
Millard,
to the root of the matter.
Yes, very well. Now, Millard,
let us sustain the order.
No, Millard, kindly, Millard, I'll place these two issues only for my satisfaction, because I am seeing the maintainability from another point. Yes, kindly see, Millard.
Give us the page.
Yes, it starts, Millard, from page 80. Page 80 kindly comes to the issue. As 88, page 88. My lord would kind enough to come to Millard 93. However, the third paragraph, page 93. Here, Millard, where the learned trial judge gives its reasons. However,
yes.
Kindly, however, on perusal of the above rent receipts been marked as Exhibit A collectively, which has been produced from the side of the contesting defendants, it is found that though the above rent receipts relate to some huts and sheds situated on the western side of the plot of land at premises number 21B, Sagar Dotto Lane, Kolkata 7,73,000, but the said document nowhere specified that the said premises is a Thika tenanted property as claimed from the side of the defendants all along, but it merely denotes a payment of rent before by the predecessor of the defendant Sheikh Jamruti and thereafter by the present defendant towards the original owner Durga Charan Pine and subsequently towards his legal heirs including Aurobindo Pine. DW1 candidly stated during his cross-examination on 8th August 2023 that my father last paid rent to Durga Charan Pine prior to his death in the year 1999. DW1 further stated that I have paid rent to Durga Charan Pine personally. I have paid rent. I have rent receipt for the same. It has further come to the from the cross examination of PW1 that his father Sheikh Jamruti since disease died in the year 1991 and Durga Charan Pine died in the year 1994 to in the year 1994 to 1995, and the father of the defendant lastly paid rent to Durga Charan Pine prior to his death in the year 1991. And thereafter, on his death, the present defendant paid rent to Durga Charan Pine personally, and on demise of the said Durga Charan Pine, they never paid rent to the sons or of wife of Durga Charan Pine. However, Exhibit A contains a rent receipt showing payment of rent to by the present defendant towards her legal heirs of Durga Charan Pine. DW1 kept on saying that my father never received any notice from the office of the Thika controller or any other authority claiming the suit premises to be a Thika property during his lifetime. He also stated that he cannot say as to whether his father or himself deposited any rent before the Thika, before the office
Mr.
of the Thika.
Bhattacharya, the way the trial court proceeded was precisely what he could not do under section 5(3). Because this judgment was passed and the suit was filed after 2001 Act came into force. Now, page 101, after exercising this entire thing, he says, therefore, taking into consideration the above points, it becomes quite certain that though the defendants have claimed the suit premises to be a Thika property, but they have miserably failed to establish the same before this court by adducing cogent evidence to that effect. That is precisely what the trial court could not do. The civil court could not do. Civil court was duty bound to hold only one sentence in view of section 5(3). Since a dispute as to whether the property is Thika tenancy has arisen, I dismiss the suit or return the plaint to be presented before the Thika controller. Return of plaint would be clumsy because Thika controller is a different proceeding. Rejected the plaint, Order 7, Rule 11, Rule 13 applies. Could have preferred.
No, kindly appreciate, Milord. If Milord, he has no jurisdiction to even determine that also, because 5(2) say whether
he can't determine the issue at all.
Then Milord, return of plaint is also not possible, because he has to then render a prima facie finding. This is a
plaint rejected, or at least suit dismissed on the preliminary issue of maintainability. Because maintainability was one of the issues, not preliminary, the first issue.
Yes.
He would say that the suit is not maintainable in view of section 5(3). 8 would come into later. If it's a Thika tenancy, then
and Thika tenancy.
Yes. 5(3), under 5(3), the suit is barred.
And 21.
21 is obviously the blank.
Civil court.
So we'll hold that the suit was barred by section 50. We can set aside the remand order also to save you from much agony and directly dismiss the suit on the ground of maintainability.
So, Milord, kindly see, Milord, my next submission would be, Milord, 2001 Act has no application here.
Yes, why?
Yes, kindly comes to page 103. Are the defaulters, defendants defaulters in payment of rent since October 1991? Kindly see, Milord, 27, section 27 of the
Of what?
Of the Thika Tenancy Act.
Yes.
Kindly, Milord, see, Milord, the repeal and the savings clause. Kindly see, with effect from the date of commencement of this act, the Kolkata Thika and the Other Tenancies and Lands Acquisition and Regulation Act 1981, West Bengal Act, the West Bengal Act, such and such stands repealed. Subsection 2, notwithstanding the repeal of the said act, such repeal shall not A, affect the previous operation of the said act or anything done, duly done or suffered thereunder, or B, I say, my lord, B is, my lord, applicable in this case, B, affect any right, privilege, obligation or liability acquired, accrued or incurred under the said act. My lord, the DW wants
to understand the implication of your argument, Mr. Bhattacharya. You don't. We will tell you. If you say this, then they were governed by the 1981 Act. You are admitting it's a Thika tenancy.
Then, my lord, civil court has jurisdiction. 81 Act controller had no jurisdiction to determine a civil court.
The suit was filed after 21 Act.
No, my lord, that was my lord specific argument before another bench. My lord.
Suit was filed after 2021. This suit was filed.
Yes, much later.
Much later. So 53 bar does not come in.
Because the rights are accrued, my lord, and at a, my lord, in 1991.
You are admitting it's a Thika tenancy.
I am not admitting this is a Thika tenancy.
If you don't admit it's a Thika tenancy, you are disputing it's a Thika tenancy. How could the 1981 Act be applicable?
My lord, let us proceed. My lord,
if you admit, unless you admit it's a Thika tenancy, 1981 Act does not come into play. Section 27B does not come, is not attracted at all. If it's a Thika tenancy, only then 1980, it's a catch-22 situation, catch-27 situation.
Catch-27.
Because Mr. Bhattacharya, the moment you admit it's a Thika tenancy, whatever may be the incidents, 53 bar also comes in. Rather, 8 bar comes in then.
8 bar, yes.
8 bar is applicable. Even if for examining the effect of 27B, then that has to be done by the Thika controller. Because what rights have accrued in their favor or not, right, privilege, obligation, maybe Thika before the Thika controller, this may be a good argument that they became Thika tenants prior to this 2001 Act. But at the end of the day, you are disputing that they are Thika tenants, and that was an issue in the suit.
That was an issue in the suit.
And the issue was formulated because you denied that it's a Thika tenancy.
Thika tenancy, my lord, because they, my lord, admitted, my lord, the part of that cross-examination is, my lord, quoted there, my lord, they admitted. They
so that civil court could not decide this on that date, on the date of the judgment. We'll pass a very short judgment.
My lord, if your lordship, my lord, kindly goes.
Yes, cite your.
596. Kindly, my lord, pardons me, this is a single bench judgment, but I think law has been laid down.
No, single bench judgments are often much better. Oh, you are barred from citing this.
No, my lord, I cited, my lord, for the other reason. Kindly see the, my lord.
Oh, so I am also barred from looking at this. Did I lose or win before your father?
My lord was successful.
One. And this should be, we'll rely on this. Yes, what is the proposition?
Lordship would kind enough to.
Yes, apart from prejudicial value, any other value?
My lord, kindly see, my lord, page para 22.
Paragraph numbers are not there at that point of time.
2009, volume 2, CLJ.
No, give us a citation. You have just given us a
596.
2009
volume 2, CLJ, 596.
Volume 2, CLJ.
Page 596.
No, these are not numbered paragraphs.
The last 3 paragraphs, it starts with before concluding.
Yes.
Before concluding, this court wants to keep it on record that this court does not feel it necessary to consider the contention of Mr. Gupta regarding maintainability of the instant suit before the civil court seriously, as the said point was neither raised by the petitioner before the learned trial judge or the same was decided by the learned trial judge. Though it is rightly pointed out by Mr. Gupta that Section 8 of the West Bengal Thika Tenancy Act provides for trial of such suit by the controller appointed under the said act, but in view of repealing and savings clause contained in Section 27 of the said act, which in my prima facie view does not create a bar in maintaining the instant suit before the civil court, as the plaintiff's right to evict the defendant had arisen under the Act of 1981 due to default committed by the defendant in payment of rent during the time when 1981 Act was in operation.
Sir Bhattacharya, we understand, we appreciate your argument on that. That we appreciated, even this judgment holds so, and even without this judgment. There are two layers of objections here.
I cannot, my lord.
5, 3 and 8. There it was admitted position probably that it was a Thika tenancy. You are right. That point, I mean, if this right to evict accrued prior, then yes, maybe it's doubtful whether it would be applicable. But 5.3 comes in again. Now, when the suit was filed, 5.3 was in force. So you have to cross that hurdle first. If you admitted Thika tenancy, then probably this would be German. And that second layer is not covered because Section 5.3, this is not a right which has accrued. Their right to have an adjudication before the controller is not a right.
Right.
But your right to evict is a right. But it's a statutory imposition that the Thika controller has to decide. So the second layer, we are more concerned with the second layer.
But my lord, the learned appellate court did not render any finding on this. My lord, learned appellate court, my lord, gone one step further. My lord, they say that since, my lord, landlord-tenant relationship was in dispute, my lord, he was not obliged to, my lord, deposit, my lord, rent in terms of Section 7(1) of the Act. Therefore, my lord,
the admitted amount would be 0.
Therefore, the defense, my lord, cannot be, my lord, struck off at all. My lord, that is, my lord, also
we'll have
decided.
to obliterate everything.
Well,
The
that
records have
is-
to be clean before you go to
the justice
and
sought
Mr.
a judgment of-
Bhattacharya, in that proceeding, if the controller has by now, he says he has already by now decided.
Already decided, my lord, that is neither here nor there, because that is up after the, my lord, the appeal. Now, my lord, we have also challenged it before the, my lord, Land Reforms and Tenancy Tribunal. Order has ultimately gone against it. Us.
That challenge is pending before the
The
tribunal.
tribunal is pending minutes in November. My lord, that is, my lord, page 138. If your lordship looks at, my lord, appeal court order is, my lord, even more, my lord.
No, but this proposition we'll have to look into the 1981, whether the right to evict comes under this. Mr. Bhattacharya, although I argued and your father adjudicated in my favor, but it's doubtful as a division bench, I have some doubts.
Lord,
Why I
that's
say
right,
this?
Lord.
I'm clarifying so that you can clarify. Now here, this 2A says, 2B says, affect any right, privilege, obligation or liability acquired, accrued or incurred under the said act, right? Now, what is a right? What is the right in this case? Your right to have an eviction. Right to have an eviction is not flowing from the 1981 Act. Because this says any notwithstanding repeal of the Act, such repeal shall not affect any right, privilege, obligation or liability acquired, accrued or incurred under the said Act, meaning the 1981 Act. Your right to evict springs up from 1997 Act, Premises Tenancy Act. 1981 Act does not give you right to evict, nor does it specify the modalities. It only specifies the forum. That's a forum clause. The right is not created. Forum is not a right, Mr. Bhattacharya. Forum is the place where you get it adjudicated. Now, right to evict arises out of 1997 Act. So, therefore, it does not come any right which arises or privilege which arises out of 81 Act. That would be saved.
Deposit of rent.
That would be only considered before the tribunal, before the Thika controller, when you take out an eviction suit before the tribunal. Because right to evict is not under 1981 Act. It's under the 1997 Act, Premises Tenancy Act. So therefore, repeal and savings is only relating to rights, privileges, obligations arising out of the 1981 Act. That provides only a forum. Other rights are there, incidents of tika tenancy and all these things, heritability. Those rights are protected. But right to have an eviction is under 97 Act or 56 Act previous to that. So therefore, 1981, this 27 does not protect. With utmost respect. I was wrong there. But this is an obiter probably.
No, this is a Millard.
Before
Under
concluding-
Order 41 Millard, it was not admitted, but it's not a
No,
Millard
we
judgment.
can avoid saying that this, because court says before concluding, this court wants to keep on record that court does not feel it necessary to consider the contention of Mr. Gupta regarding maintainability. No, it hits the maintainability point.
It's the maintainability point. Now, Millard, another thing, Millard.
Yes.
The appeal court, Millard, said, Millard, since they were not obliged to, Millard, pay rent, Millard, to maintain an application under 7.2, since the landlord-tenant relationship itself is under dispute. Millard, that is also not, Millard. Now it has been again, Millard, settled, Millard. No. In view of Millard Chamaria's judgment, Millard, that is a complete code.
Last paid rent has to be paid.
Has to be, along with 10%. Otherwise, 7.2 itself is not
No,
maintainable.
7.1 compliance is not there then.
Then
That
Millard
is also
defense
there.
goes. Then if
7.3 covers both 1 and 2.
one, yes. Then Millard, if defense goes, Millard, my Millard counterpart in the trial court had before the appellate court had basically relied upon the judgment of Modula India Kamakhya Singh Deo, Millard, which says, Millard, if defense is struck out, what are, Millard, up to what extent, Millard, the defendant can be permitted to raise its case? Only falsity of the plaint case, weakness of the plaint case, and that's all. One. And maintainability. Maintainability, Millard, I have never argued in my plaint, never stated in the plaint, Millard, the suit is barred under thika tenancy. It's, Millard, that point taken in written statement, which is a factual aspect. Well, whether that can be looked into in view of the Modula India's case. That has been discussed by the learned appellate court.
So you say section 5.3 only applies when if any question arises as to whether.
As to whether.
So question does not arise because the defense cannot be looked into.
Because through two, Millard, situations are given, Millard, in Modula India's case.
Just it will be a circular logic. Question খুব interesting. The defense judge strike out whether any question at all arises. Yes, what is your answer to that?
Kindly comes to page 54 of the paper book. Millard, he admits, Millard, even going by the Modula India's judgment, Millard, he admits that a proceeding was going before the Tika controller.
No, that is a different aspect of the matter. Proceeding may go on.
Millard, there was admittedly a proceeding pending before the Tika controller.
Your application, you had applied before the Tika controller for an adjudication.
Before the Tika controller, prior to the eviction suit.
Achha, let us see that. Page 54.
Millard, page 54.
So therefore, even as per their plaint, it could be derived.
At page 54, Millard, the third paragraph. Millard, this was the cross-examination of the PW1.
Not cross-examination. Yes, cross-examination you are permitted.
PW1. And I am aware that a proceeding has been initiated before the Tika controller with regard to the premises concerned in the present case. The said proceeding has been initiated at the instant of Safi Alam, Sami Alam, Mustafa and Muktaza. But the Safi Alam and Sami Alam are the defendants or rather the respondents in the present case. Millard, thereafter, Millard, on the penultimate portion, the defendant is paying rent to the Tika controller.
Is their admission?
Their admission. Millard, this was the cross-examination. Kindly comes to page 52. Cross-examination of the PW1.
I cannot, Millard, that is kindly comes to, Millard, part 2, page 337.
What is that?
Millard, the notice from the Tika controller. This was exhibited, Millard, at the instance of the Millard defendant. Kindly see, Millard.
Defendant's exhibit, can it be looked into if the defense is struck out? Because there cannot be proof beyond pleading.
Exactly.
We cannot look into that.
Because
even if defense is struck out, they can cross-examine you.
Cross-examine, Millard, what, Millard, I want.
And elicit answers in cross-examination.
No, cross-examine on the weakness of the plaint case.
That is what they've done.
This is not weak. They have to confine. There was suppose, my lord, what weakness? My lord, weakness, my lord.
Two things they can
notice
do.
point.
Two
Whether
things.
notice has been served or not.
No,
Whether notice
two
is
things
valid.
they
These
can.
are the things.
They can try to demolish your case.
On my lord,
See, your
kind.
case is, Mr. Bhattacharya, that a suit lies before you have filed a suit under Section 6 before the civil court.
Civil court.
Now, suppose that defense is struck out. They can try to point out, elicit from your cross-examination, from your witness, that there is a dispute going on regarding ticket tenancy which hits your suit also. That will come under the lacuna of your suit. They can do two things. One, point out any defect in your plaintiff case, any sort of defect. Any sort of defect in your
Notice
case.
not served, notice
Including
banned,
maintainability
anything.
of the suit also. Including maintainability of the suit also. Unless
Yes.
new facts come in which are disputed by you.
These, my lord, these
They can cross-examine you.
Yes, meant regarding, my lord is absolutely right, regarding weakness of the plaintiff case. That is the language, my lord, used in modular in the yes case. But I do not say, my lord, that my lord, in my plaint, that there is a, my lord, proceedings pending before the Chika controller. Even if, my lord, I admit it, because there is, I cannot, my lord, deny it because of 337, page 337. My name is appearing from page 337. I cannot deny it.
That's your exhibit.
No, they are exhibit.
So then,
exactly. But even if I admit in my cross-examination, that is not in the four corners of the, my lord, plaintiff case.
the appellate court says that the defense cannot be struck out. Why?
Well, kindly see, my lord, page 138.
137.
137. Kindly see page 137, para 23. Kindly the relevant portion, my lord, is, my lord, page 144, 137 in the kindly see para 23. My lord, up to para 22 is, my lord, reiteration of facts and arguments.
Part 1.
Part 1, my lord.
Part 1.
Up to para 22, judgment cited and arguments. Page para 23 is
Modular India is referred to here.
Yes. Kindly comes to page 136, para 20. Modular India
No, then they can cross-examine according to modular
It's
India.
to cross-examine.
Not to lead any evidence of his own.
Exactly.
Nor can his cross-examination be permitted to travel.
Exactly. They have to, my lord, on the cross-examine on what is there on the four corners of my plaint.
Falsity or weaknesses of the plaintiff's case.
Falsity, falsity, my lord.
Falsity, weakness.
Weakness, my lord, is also, my lord, thicker tenancy plea. If that is not there, my lord, what weakness, my lord, they will find out from my yes. Otherwise, my lord, weakness, why cannot be, my lord, shown? Because notice has been proved to be sufficiently served. Notice was, it has been said that notice is valid.
Modular India is very important here. Yes.
Reasonable requirement has been proved.
Yes, what other page you were saying?
Yes, kindly comes to, my lord, the page 144, para 39. That is the ultimate finding. Kindly see, considering defense of the written statement. This is where, my lord, the learned first appellate court is going wrong.
Categorical defense.
Yes, categorical defense of the defense. He is considering the defense case. Is that the defendant is structural owner of the portion of the land at premises number such and such, and the defendant duly filed a return form before the controller, Thika tenancy, and the suit property was vested with the state of West Bengal with effect from 18th January 1982 to 31st December 2011. My lord, I do not know whether a periodical vesting, my lord, can be done. I do not know. He records that the ground rent is realized up to the date of the date from the office of the controller, Thika tenancy, after vesting of the portion of the land in the suit premises, knowingly and willfully suppress the fact that a partition suit was filed by the plaintiffs as legal heirs of Durgacharan Pine, in which decree was passed. After vesting of the suit property, Aurobindo Pine became outsider. He had no right and title over the suit property, and so no question arose to transfer and or sell the suit property. An application was filed by the defendants under Order 7, Rule 10 and 11 read with 151 of the Code of Civil Procedure before the Learned Trial Court. By Order number 16 dated 1st April 2014, the Learned Trial Court rejected the petition, observing at the stage that there was no scope to adjudicate the finer points on the basis of the case so made out in the written statement. Thus, filing the photocopy of the challan showing payment of ad hoc ground rent and pendency of a proceeding before the learned ipso facto did not demolish the plain case as to reject the same at the threshold. This is what I am arguing. As says, the learned trial court has left to the adjudication for subsequent stages of the suit. Then my lord, arguments of 3, 8 and recorded. Now my lord kindly comes to my lord wanted to look at the my lord the ultimate finding at page 147, paragraph 43. The present suit was filed on 7th day of May 2013, that is long after enactment of the West Bengal Thika Acquisition and Regulation Act 2001 and rules framed thereafter. Further, the defendant has received the notice of hearing and Annexure G, Millard. Annexure G is page 337 of the second part. From the Office of the Controller, Calcutta, Kolkata, Thika Tenancy, Government of West Bengal in respect of miscase 14 of 2013 for the suit premises. From the document, it is also clear the plaintiffs were also received the same from the notice of the controller. Furthermore, PW1 in cross-examination admitted pendency of such proceeding before the controller. As per the paragraph 26 of affidavit in lieu of examination in chief of DW1, the proceeding was pending. No cross-examination was made under the plaintiffs in respect of notice of hearing issued by the controller, Exhibit G.
His evidence could not be looked into. TR form Exhibit B shows payment of ad hoc ground rent from 18 January 1980 to 31st December 2011. The same was accepted provisionally, and such acceptance of rent shall not create and establish any right or. The court actually did what we were proposing. I mean, it took the jurisdiction point first and then reversed it.
Then, Millard, this is what, Millard, this is before institution of the suit. It is not the case of either party the miscase has been disposed of. For that, undisputedly, a miscellaneous case is pending before the controller in respect of the suit premises. It is out of place to point out that the court having no jurisdiction to try whether a person is a Thika tenant or not, or the incidence of Thika tenancy, is obviously not empowered to decide which documents are sufficient to establish the defense as Thika tenant. But in the suit, learned trial court erroneously examined documents meticulously to arrive at a conclusion that the defendant is not a Thika tenant but tenant under the West Bengal Premises Tenancy Act 1997. Millard, this is also incorrect. Millard, for eviction of Bharatia and Thika tenant, Millard, it's the West Bengal Premises Tenancy Act which applies, Millard. That's the statute. Legislative intention of enacting Section 5(3) or Section 21 of the West Bengal Thika Tenancy Acquisition and Regulation Act 2001 was not the court would first decide whether the person claiming as Thika tenant has enough documents to establish the same or not, to leave the question under Section 5(3) of the Act of 2001 to the controller. The jurisdiction of the controller in this regard is exclusive and independent of any court's decision. Plain and grammatical meaning of Section 5(3) of the Act of 2001 creates no confusion that if any question arises as to whether a decision is a Thika tenant or not, or whether the land in question is a Thika tenant or not, it is only the controller under the Act who is empowered to decide such question after examining all such documents. Moreover, pendency of the proceeding before the Thika controller since 2013 can easily raise presumption that if the defendant's claim of Thika tenancy was baseless or without merit, the controller should have disposed the proceedings much earlier. As unfounded claim would not take such a long time, more than 10 years, to decide. And at the time of deciding the maintainability of the suit, the learned trial court has undertaken the task of deciding whether the suit property is a Thika property. To arrive at
This was struck off only at the hearing stage, at the
judgment, because
final judgment.
They did not file 7(2).
Yes, but that should have been done earlier. They have been permitted.
Operation of law. Now, Millard,
7(2), The rigors of 7 to that time period of the proviso under the proviso had relapsed long back.
Yes. Now, Miller,
7
also
3
Miller
should have
7 1
automatically
3.
followed.
Also Miller 7(1)(c)
Should have followed.
should have followed. Then Miller, it is
But
by
they were permitted by the trial court even after that time period to adduce evidence, independent evidence.
Miller, they were permitted. But Miller 7(3) is by operation of law now. Because Lordship Miller kindly recollects Miller Chamaria's judgment. It says Miller, it's a complete code which has to be meticulously followed.
Court shall strike out defense.
Court shall strike out defense.
Not automatic.
No, Bina Devi Binani, Miller, it's automatic.
Court has to strike out the defense. Automatic means without an application, court can do it.
Yes, but formal or recording has to be there.
Yes.
Formal recording has to be there.
They are permitted to adduce evidence and everything is done. Then the evidence was adduced by them before the defense was struck out.
Evidence was, yes. As and the suit proceeded, Millard, in other normal course, Millard, other suits, just like other suits.
Peculiar.
Then Millard kindly comes to Millard at that however no judicial the decision authorizes learned court to decide the question of status of any person as thika tenant or property as thika property or otherwise whether proceeding is admittedly pending before the controller. That apart, no cross-examination of DW1 was made on the part of the plaintiff to controvert his claim of structural ownership by the defendants in respect of 2 rooms in the suit's property. Clear admission of PW1 was
there. There was a 7-2 order here in this suit?
No.
No.
They did not file section 7.
No, they did not file. That's Millard, the next page.
Did not make deposits under section 7(1) then?
Even 7(1)(c), non-compliance. I will place that Millard at paragraph 52. I will place that.
Peculiar.
Peculiar. The plain and grammatical meaning of section.
Yes, very interesting case. Not sarcastic, really.
Yes. The plain and grammatical meaning of section 5(3) of the Act creates no confusion that if any question arises as to whether a person is a thika tenant or not, or whether the land in question is a I was placing paragraph 46. However, no judicial decision authorizes learned trial court to decide the question of status of any person as thika tenant or property as thika property or otherwise, whether proceeding is admittedly pending before the controller. That apart, no cross-examination of DW1 was made on this part of to the plaintiffs to controvert his claim of structural ownership by the defendants in respect of 2 rooms of the suit premises. Clear admission of PW1 was there that the defendant was depositing rent to the controller. He was aware about the pendency of proceedings before the controller in respect of the suit premises at the instance of the defendant. Learned trial court had candidly admitted about the embargo of subsection 3 of section 5 and 21 of the 2000 Act of 2001. But
1 second, Mr. What is it? In the order 7 rule 10/11, did they raise the question of thika
yes,
5(3)?
Yes, that was rejected. Res judicata not challenged.
Rejected, but then that question was.
That was rejected, but reserved.
But then a dispute was raised.
At the time of trial.
Dispute was raised, but rejected.
So then the dispute, a question arises then. Section 5(3) of the Act does not say if an issue is raised. Issue cannot be under order 6. Issue can be raised only if there is a plain and written statement and a controversy. Without pleadings, there cannot be an issue. But language used in 5(3) is not issue, but question. 7(11) raises the question. So.
But that was rejected, Millard. I do not.
Rejected on the ground that it cannot be decided on the plaint. It has to be decided on merit.
Merit has again gone against them.
Court decides on merits, maintainability. Not that court says that no, defense has been struck out, therefore I won't go into the question. Court decides, trial court decides and says that it's not a thika tenancy.
Millard, I have not checked up, Millard, the memorandum of appeal of Millard of the ejectment appeal. I do not know whether Millard that has been taken as a ground under 105 Millard. That I have not checked up, Millard.
What 105?
Millard, order 7, rule 11, rule 10.
Order 7, rule 11 was rightly rejected.
Res judicata, Millard, interlocutory order affecting the merits of the.
Not res judicata. It was kept open for being decided at the final hearing. That is the premise of
Yes,
the,
yes, that is there.
it was rejected on the ground that it cannot be decided
Upon
next
evidence.
question. Yes.
Upon a taking
Has to be
evidence.
taken on, the res judicata does not apply at all.
Then may I
So
kindly
then there is the question, Mr.
There is the question. But ultimately, my lord, their defense was not there. Even raising their question, my lord, whether court can go into.
Defense is not required. Civil court does not loses jurisdiction if a question is raised.
This defense or this question is a purely factual aspect. It's not, my lord, this defense, my lord, is on a point of law. Suppose, my lord, a cancellation of a deed, my lord, is, my lord, question. My lord, they file a suit, my lord, after, my lord, 20 years, 15 years. Court can say that Article 58 barred limitation. My lord, those are the, my lord, which are, my lord, on the face of the plaintiff, my lord, cannot stand on the, my lord, due to, my lord, bar of law. But those defenses which are factual aspects, my lord, subject to correction, my lord.
Mr. Bhattacharya, even if there is no suit,
yes,
just a question is raised as to whether a person is a Thika tenant or not. Controller has, because controller can decide either on its own motion or upon receiving any info. So they are not even required to take that question in a sense, because suppose in some other proceeding it incidentally arises.
But question is
controller either on its own motion, on his own motion, or upon receiving any information,
yes,
may decide that issue.
my lord, suppose, my lord,
and controller was deciding the issue.
Well,
Give a notice to you.
Yes, my lord, no, at that point.
How can you shut our eyes to that just because his defense is struck out?
At that point of time, the issue was not decided. It was decided much after. Much after.
Decided, but it was pending adjudication before the controller under section 5(3).
Pending adjudication.
How can we just shut our eyes to it?
Then,
even in a civil proceeding.
Then, my lord, even if to my lord, return back the plaintiff under Order 7, Rule 10, my lord, court must have a, my lord, prima facie, my lord, finding.
No question of Order 7, Rule 11.
Or 10.
No, that does not apply because plaintiff does not disclose anything about this. But that issue comes up, I mean, maintainability question
Even
is
if
decided by
transfer, my lord, court has to give a prima facie finding that
no. Court, while deciding Order 7, Rule 11 says that this I will decide the maintainability issue later on.
And
on
decided
evidence,
accordingly.
On the evidence. Now decided. It could be decided on the basis of pure cross-examination. Modular India is there, but still it could be decided on whatever is there.
Modular India, my lord, kindly see, my lord, Modular India only to, my lord, demolish the plaintiff case.
Cross-examination cannot traverse beyond the pleadings of the plaintiff case.
I, my lord, have never stated in my plaintiff.
Plaintiff case is that
it's a simplicity ejectment
There
suit
are
under
tenants.
Section 6 of the Premises Tenancy Act.
There are premises tenant, you say,
Premises tenant.
but there are bharatiya, where 97 Act applies.
97 Act applies.
The language is 1997. The Premises Tenancy Act applies, but you do not say he's a bharatiya.
I do not say I am a Thika tenant.
No, you say defendants were joint monthly tenants under you, under
Yes,
whoever.
yes.
So the moment you say monthly tenant, it is to be ascertained by the court as to whether he was a monthly tenant under you.
No, if I admit that he was a monthly tenant, it was my case. They say they, my lord, in their written statement, my lord, raised the landlord-tenant relationship, but they did not, my lord, choose to file, my lord, even for a prima facie find to get a prima facie finding from the court to file a, my lord, application under 7(2).
Under
7(2), they did not choose to file either 7(2). 7(1) is not required because they can automatically, my lord, go to the court and seek permission. Even oral application is made to. They did not file it. And, my lord, the most, my lord, surprising, my lord, the finding of the learned appellate court, my lord, is at page, my lord, 152, para 52. kindly see, it is to be kept in mind that in that suit, the defendant has claimed him a Thika
It
tenant.
is absolutely palpably wrong.
Palpably wrong.
Take out a 7-2 there.
53, Milord says, Milord, I need, since Milord landlord-tenant relationship is Milord challenge, I need not, Milord. That is also decided. I'm with that judge.
Cite that. Cite that. Formally cite that.
Justice Sarkareর judgment
Sir,
that
formally cite modular and this.
modular print এনেছো
So these are very German.
লাইব্রেরি থেকে মডুলারটা নিয়ে আসো এই ওটা কপি দিচ্ছি CO3681 of 2022 Milord, again, Milord, this is a single bench judgment, Milord.
No difficulty.
But Calcutta Gujarati Education Society was considered. Paragraph number 21. Kindly see, Milord. No, Dipcha, Dhiravat. Yes, Milord, it starts, Milord, from para 26 at page 8.
Yes.
By an application under section 7(1) of the said act, the defendant petitioner sought for permission to deposit rent from August 1997 to September 1998 and for September to 2022. The delay in filing the said application was calculated as 27 days from the date of the final order passed by the High Court on July 12, 2020, dismissing the civil revision application. The learned court below observed that the provision of section 5 of limitation act would not apply and the delay in filing the application under section 7(1) of the said act could not be condoned.
No, they did not in their written statement deny the landlord-tenant relationship, did they?
Yes, because
they say they are tenants under somebody else.
No, initially, Milord, Milord, that is, Milord, up to 2011, they have, Milord, up to 81, Milord, they have deposited rent with Milord Durgacharan Pine, who was the original owner. Thereafter, Milord, since they are giving ground rent to the office of the Thika controller. Hence,
they never paid rent to you.
Could not be condoned. In this case, the delay was of more than 3 years from the date of appearance of the defendant petitioner in the suit, even if it is accepted that the summons have not been served. In my opinion, the learned court below did not commit any irregularity, as the law has been discussed in great detail and rightly applied in this case. It is evident that the defendant petitioner did not deposit area rent along with statutory interest while raising the dispute of landlord and tenant and while asking the court to determine the rent payable. This is what, Milord, I am raising. According to the law, the petitioner defendant ought to have deposited the admitted area rent along with 10% statutory interest within a month from entering appearance in the suit. Such compliance is a mandatory prerequisite to filing an application under section 7(2) of the said act. Asking the court to determine the relationship between landlord and tenant and rent payable requires the tenant to comply with the provisions of section 7(1) of the said act. Section 7 provides a complete mechanism to be availed of by a tenant in order to protect himself from eviction. Such mechanism was provided under section 7 of the said act. On institution of a suit by the landlord for eviction on any of the grounds referred to section 6 of the said act.
Yes, Mr. Bhattacharya, you've seen. So whatever ground rent he was paying, at least he had to pay.
At least. Then Milord kindly comes to skip over to Milord paragraph 38 and 39. Ultimate, Milord. And Milord, here Devashish Pal, Chamaria, Calcutta, Gujarati, so all were considered. Section 7(2) of the said act cannot be independent of 7(1) without depositing admitted areas along with 10% statutory interest within the time limits prescribed under section 7, that is 1 month from the either receipt of summons or 1 month from the date of entering appearance, and if the defendant petitioner enters appearance without receipt of summons had to be complied with. The compliance is mandatory, a provision to be fulfilled by any tenant who seeks protection from eviction under the
this is well settled.
This is well settled, Milord. This is
7(2), irrespective of 7(2), they have to comply with 7(1).
Therefore, paragraph 53 and 54 is completely, Milord, is an erroneous finding, Milord. Number, Milord, and the last point, Milord, kindly see, Milord, the order of remand at page 155. Court, appellate court, Milord, directs remand and to reopen and so that after, Milord, the proceedings before the Thika controller are disposed of, and to reopen the suit. That is the ordering part. Kindly see, Milord, this court is the suit is remanded to the learned third bench presidency small cause court at Calcutta with direction to readmit the suit under its original number and register of civil suit, and to decide the issues regarding maintainability of the suit and landlord-tenant relationship between the parties to the suit, as well as other issues framed in the suit after disposal of miscase number 14 of 2000 pending.
Sir, what would be your stand now? Now that the Thika controller has decided, now what will be your,
Milord, that is, Milord,
why shouldn't section 8 be applicable? Whatever happened, yes.
Now, Milord, Thika controller has decided. Therefore, this is
as of today,
they are Thika tenants. They are Bharatias under the Thika tenants.
Yes, and trial court's degree is not there because it has been set aside by the remand order as of today. So therefore, shouldn't you? We can give you liberty to take out a proceeding for eviction under section 8.
Milord, I do not know what will happen before the Land Reforms and Tenancy Tribunal. If it is set aside, again, Milord, my suit is revived.
What is set aside?
If order of the
you have challenged that.
Challenged that. If it is set aside, it Milord, here, Milord, Milord. Therefore, Milord, if the order of the Milord learned trial court, Milord, is set aside, and I have lost before the Thika controller, therefore, Milord, the parties are Bharatias and Thika tenants. Without, Milord, let us forget that I have, Milord, challenged it before the tribunal. If that be so, then, Milord, my lord, the first question which my lord had put to me, that whether 81 Act, Milord, comes into operation. If, Milord, if the Thika controller decides that, then, Milord, in view of section 27 repeal and savings clause, again civil court's jurisdiction is restored.
How?
Milord, in that case, Milord, I am a Thika tenant, they are Bharatias. Therefore, and section 27 says rights accrued under the said act. Here, Milord, it has been stated that, Milord, rights have accrued as far as back in 1991 when the 81 Act was in operation.
What right are you speaking about?
Milord,
no, what right in this case? Right to have an eviction.
Evict.
As you told you, right to eviction does not is not conferred by the either by the 81 Act or the 2001.
Milord, right to evict, Milord, is
the 2001 Act is very clear. Right comes.
Right to evict, Milord, either
general law or rent control.
Milord, general law will subject to correction, not
here it will apply.
Premises Tenancy Act. Therefore, either I go before the, Milord, controller or before the civil court, Premises Tenancy Act will apply. But jurisdiction will be returned with the, Milord, civil court. Jurisdiction to entertain the suit, Milord, will be returned with the civil court.
If it is held that you are not a Thika tenant.
If I, Milord, succeed in rent controller, Milord, before the land.
If you don't succeed, then what happens? You remain Bharatiya Thika tenant.
Bharatiya and Thika tenant. Then, Milord, I am entitled to take the, Milord, Milord, advantage of section 27 and, Milord, that Justice Bhattacharya's, Milord, judgment.
How?
Because 1991, default since 1991.
Yes, but whatever advantage you derive for that default is under the 97 Act, not under the 1981 Act. It's not a right accrued under 1981 Act at all.
No.
In Justice Bhattacharya's case, it was the Thika tenancy was not disputed.
No, that is not. That is not.
Now, therefore, now the question of eviction, that is not a right. We humbly differ from that opinion of Justice Bhattacharya that right to evict flows from the 1981 Act. It does not. 81 Act does not say anything about eviction. It only decides confers the forum.
Here, Milord, the ejectment suit was filed, Milord, in 2005.
Under 1981 Act, there was a provision for eviction suit between Bharatiya Thika tenant also.
97 Act is before.
Was there any such provision?
25.
Huh?
Before coming into effect.
Please check up in 1981 Act whether there was any provision for these eviction suits against Bharatias being decided by the Tika controller. I've forgotten that. This is a reported judgment, Justice Bhattacharya's judgment.
Yes, 9-2 CLJ.
Why don't you file a photocopy of that? Do that.
My
Tomorrow-
junior says it's not there in the SCC online. I will make a photocopy from the book itself.
From the library, you can get it. Our library, High Court library, your library.
Well, I'll come back. কালকে পারবে না? কালকে।
Very well. So let us continue. No, you complete your argument. This is what else is required to be argued by?
Section 9.
You have argued modular India. You have cited these two judgments.
Section 9 of the 81 Act. The monthly and periodical tenancies of Bharatiya in respect of structures occupied by them on payment of rents to Thika tenants shall with effect from the date of coming into force of this act be governed by the provisions of the West Bengal Premises Tenancy Act 1956 in all matters coming within the purview of the said act, and for the purpose the owners and structure shall be deemed to be landlords and the Bharatiyas shall be deemed to be tenants. And notwithstanding anything contained in this act or in the West Bengal Premises Tenancy Act 1956, a Bharatiya under a Thika tenant shall be entitled to take separate electric connection that is different, my lord. Well, I'll check and come back. I will check and come back. 1 day's time, my lord. Day after tomorrow.
Why day after? What is the difficulty tomorrow?
Actually, I have some difficulty tomorrow.
You also have difficulty.
My junior has a difficulty.
Very well. Hard in part for further hearing on August 14, 2025.
Very.
You have to say something.
For the very next matter, 24, can I seek a 1 week adjournment, my lord?
Call করে দিন।
I am
Time
appealing
আছে।
for this one number 3. I am for the appellant. I was seeking a 1 week adjournment, my lord.
When do you want us to keep it?
Anytime next week, my lord. Anytime next week. No,
Monday.
Thursday, my lord. Kindly make it on Thursday. Next Thursday week. Thursday week. 14th of August.
Thursday week you are wanting it.
14th now. Huh?
You are for the other side.
Yes, I am for the respondent.
On the prayer of planet, yes, you check up yourself.
21st August. Thursday week হচ্ছে 14th.
21st.
আচ্ছা আচ্ছা আচ্ছা।
Thursday week is 21st.
21st of
On the prayer of planet.
Anytime next week. আমার Monday, Tuesday কোনো অসুবিধা নেই।
So he is appearing with you or against you?
No, against him.
You don't have to move away.
Lord, any day. 21st is the better, Lord. I was told for fixing on 21st.
On the prayer of learned council for the parties, the matter is adjourned and shall next be listed under the same heading on August 21, 2025.
Problem.
তারপরটা ডাকুন, এক মিনিট আছে। Please give the names in the previous matter.
Well, 25, I am for the petition.
Affidavit
in opposition.
Have you filed?
Well, there is a direction to file affidavit in opposition to the matter, my lord. It is ready, my lord. May I file?
You are ready with a reply?
No, my lord. I am praying 1 week time.
We'll take your opposition on record.
Let it be appear on 27th, my lord.
Yes, 27.
Well, I thought upon him. Today I am also not ready, my lord.
Very well. Affidavit in opposition filed today be kept on record. So on the prayer of learned counsel for the petitioner, the time for filing reply is extended till August 19, 2025. Full-stop. Learned counsel for the petitioner seeks an adjournment till August 27, 2025. Full-stop. Accordingly, let the matter be listed next on August 27, 2025 under the same heading. আচ্ছা
লেখা হয় না কেন